Court officer, ಹಿರೇಮಠ್ ಏನ್ ಸರ್ ಹಿರೇಮಠ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸಾಹೇಬ್ರೆ? ಎಲ್ಲಿ ಬಾಬುರಾವ್ಗೆ ಏನ್ ಬೇಕಂತ ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕಾ ಸರ್? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಹಿರೇಮಠ್? ನನಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಮಸ್ಕಾರ ಸರ್. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ನಮಸ್ತೆ. ಸರ್ ನಮಸ್ತೆ ಸರ್, ಕೇಳ್ತಿದ್ಯಾ? ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ನಮಸ್ತೆ, ಕೇಳುತ್ತಾ ಸರ್?
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಸರ್ ಕೃಷ್ಣ ಮೋಹನ್ ಅವರು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
ಹೇಳ್ತಿಲ್ಲ ಸೌಂಡ್ ಏನು ಸೌಂಡ್ ಬರ್ತಿಲ್ಲ. ಇಲ್ಲ ಬಂದಿದೆ ಸೌಂಡ್ ಕೇಳ್ತಿಲ್ಲ. ಎಲ್ಲೋದ ಪೃಥ್ವಿ ಪದ್ದು
The court mic is muted, my lord.
Yes, you will be here. You're hearing now?
Yes, my lord.
You're able to hear now? Yes.
My lord, I appear for the petitioner, my lord. I appear for the petitioner, my lord. Petitioners are the employees of the Karnataka Vidyut Karkhane Limited, my lord. Petitioners are working in Karnataka Vidyut Karkhane Limited as the Group C and Group D workers, my lord. Petitioners' representation was not considered by the respondent number 3, my lord.
Presentation for what?
Representation for the implementation of Requirement Regulation and Promotion Policy 2012, wide annexure E, my lord, page number 210, my lord.
AGA. Take notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA.
Pensionary benefits and regularization not annexure to is the impugned order. Three litigations, my lord. He was appointed in the 1980. 91, my lord, his services regularized and he was working as FDA.
Imbaraha. ಏನಂತ
ದಾಖಲಾತಿ ಸಿಗ್ತಾ ಇಲ್ಲ, ದಾಖಲಾತಿ ಸಿಗ್ತಾ ಇಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ನಾಟ್ ಅವೈಲಬಲ್ ಅಂಡ್
ಏನ್ರ ಬಗ್ಗೆ
ಸರ್ವಿಸ್ ಬಗ್ಗೆ ಪಿಟಿಷನರ್ ಸರ್ವಿಸ್ ಬಗ್ಗೆ. Annexure Q is the honorable criminal, sorry, honorable court's order.
ಸರ್ವಿಸ್ ಬಗ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಗ್ತಾ ಇಲ್ವಾ ಅಂದ್ರೆ ಕೆಲಸನೇ ಮಾಡಿಲ್ಲ ಇವರು.
Three litigations this honorable court clearly directed to extend the benefit and regarding seniority, regarding he was working as chief officer 91 lida 2017 and after retirement.
ಏನ್ರಿ ಹಿಂಗ ಹೇಳ್ತೀರಾ? ಚೀಫ್ ಆಫೀಸರ್ ಆಗಿ ಸರ್ವ್ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಗಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಏನ್ರಿ?
All the
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned AGA.
Orders passed by the first respondent, my lord, the Chief Executive Officer, Jilla Panchayat, my lord, Annexure A. My lord, I requested to consider my prayer for promotion. My lord, the contesting respondent number 4, my lord, his promotion was upheld. Therefore, my lord, I preferred an appeal and that was rejected on the ground that in the year 2009 itself he was appointed. And I was appointed subsequently in 2012. But my lord, the documents otherwise reveals that my lord, he was not working at that point of time. I produced all those documents also for the consideration. Please, my lord, it requires, my lord, the first respondent should have considered all these things. Please.
Anyone appearing for this Jilla Panchayat and Taluk Panchayat?
My lord,
Issue notice to all the respondents.
please, let my request for emergent.
Emergent.
I am applying for the petitioner. But the petitioner is working as Anganwadi worker. But he submitted an application for shifting my lord to Hinduvalli, and they have not, my lord, acceded to the request. And I approached this honorable court at annexure G, my lord, page 64. Page 64. And this honorable court directed the respondent to consider the representation and to dispose of. My lord, in the Hinduvalli, another lady is working as an assistant. She has also approached this honorable court, filed a writ petition at annexure H, and this honorable court, my lord, also directed to consider the case of an Sahayaki, assistant, for my lord, promotion to the Anganwadi worker. My lord,
Now, what have they said?
now
What have
here,
they said in the
my
last-
lord, annexure K, ನಿಮ್ಮನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್.
ಏನಕ್ಕೆ?
ದಟ್ ಇಸ್ ಇಂಬರಹ ದಿ ಲಾಸ್ಟ್ 5 ಸೆಂಟೆನ್ಸ್ ಅಭಿಪ್ರಾಯದಂತೆ ಹಾಗೂ ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಹೇಳಲಾದ ಷರತ್ತುಗಳು ಪೂರೈಸಿರುವ ಶ್ರೀಮತಿ ಯಶೋಧ ಓ ಇವರಿಗೆ ಎಂಡುವಳ್ಳಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರ ಕಾರ್ಯ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿ ಆದೇಶದಿಂದ ನೀವು ಸಲ್ಲಿಸಿರುವ ಸ್ಥಾನ ಪಲ್ಲಟ ಅರ್ಜಿಯನ್ನು ನಿಯಮಾನುಸಾರ ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವಾಗುವುದಿಲ್ಲ. ಮಾಹಿತಿಯನ್ನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರುತ್ತಾ ನೀಡಿದ ಸ್ಥಾನ ಪಲ್ಲಟ ಅರ್ಜಿಯನ್ನು ವಿಲೇ ಮಾಡಲಾಗಿದೆ. My lord, he is eligible for, my lord, the shifting from, my lord, Kamballi to, my lord, the Enduvalli. And the worker who is working as an assistant in the same, my lord, the Anganwadi, she has been promoted as an Anganwadi teacher, and her request, contrary to, my lord, direction issued by this honorable court, appointed, my lord, the contesting respondent, my lord, as an Anganwadi worker. The last appointment order
takes notice for response number 1 to 4. To notice for response number 5.
But emergent notice, my lord.
Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Yes.
Emergent notice for respondent.
The emergent notice.
Appear on the petitioner counsel. Petitioner is the first division assistant working in Bangalore, respondent Bangalore University. But there was allegation of tampering of marks by one of the private institute to whom the work was entrusted for the scanning of the mark sheet and for sending it to evaluation. Not on the basis of that complaint, on 1/1/2021, my lord, an FIR was registered, not against some of the persons in which petitioner was, his name was not found in the FIR nor in the complaint. Not on 16th, after almost 1 year, my lord, on 16th to 2022, he was arrested. And my lord, he was remanded to judicial custody till 28th to 2022. But since not, he was there in the custody for almost more than 48 hours. Not, he was placed under suspension as per annexure G, 25 to 2022.
Yes.
But now even the charge sheet has not been filed in the criminal case. Nor, my lord, any charge memo has been issued by the department, the respondent university.
Learned counsel. B. Ramesh is directed to take notice for the respondent university. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexure on the learned counsel for respondent. Release this matter on 7th of April.
Please.
As per the university statute, till the end of the academic year, it has to be continued. Connected matters. I have to read it.
Say that.
Page 267, 266. Sorry. Page 270. Relevant version is 272. (274) and 277. Petitioner shall not be relieved from the services and attain their superannuation. Shall continue up to the end of the academic year.
Same as yesterday.
No,
Same as, huh?
this is university statute till the end of the academic year. Here the academic was commenced in November 2021. I am entitled to continue till the November 2021. Not for a superannuation under the university statutes.
Same as WC number 1278 of 2022, dated 24/1/2022, page number 273. Same. Respondents note contact. Learned counsels are ಯಾರು ಹೇಳಿದ್ರ ಅದೇ same is.
Petitioner.
File a memo.
Huh?
File a memo.
For
Entry model. Evening is going.
handover.
Fourth respondent is a meat producer cooperative society. Fourth respondent is a meat producer cooperative society. Not due to lack of forum, not in the management, the special officer was appointed. Thereafter, not for appointing a chief executive on ad hoc basis, on 22/4/2021, the fifth respondent was appointed as the chief executive officer. Within a span of 2 months, he was discharged from the service on account of several irregularities and irregularities and complaints. Now, what has happened? The invited application and some other person has been posted to that post. Now, what has happened on 25/2/2022, connection B at page 22. Now, he has been reinstated to the post of chief executive officer. He has only passed SSC and he is aged about 40 years. As far as rule 17, for holding the chief executive post, he should hold a bachelor degree. And rule 18+2, he should have been age limit is up to 35 years. Yesterday I filed a memo. Verification of the respondent says that he is not only SSC and age 40 years, therefore he is ineligible to hold the post. ಇದುವರೆಗೂ ಉಲ್ಲೇಖ ಒಂದರ ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ಜಂಟಿ ನಿಬಂಧಕರ ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಹುದ್ದೆಯಿಂದ ಕಾರ್ಯನಿರ್ವಹಿಸಿ ಆಗಿರುವ ನಿಮ್ಮನ್ನು ಮುಂದುವರೆಸಲು ತಿಳಿಸಿರುತ್ತಾರೆ. ಬದಲಿ ಪತ್ರದ ಕ್ರಮ ಸಂಖ್ಯೆ 8ರಲ್ಲಿ ನೇಮಕಾತಿ ಷರತ್ತು ನಿಬಂಧನೆಗೆ ಒಳಪಟ್ಟು ನೇಮಕಾತಿ ಕ್ರಮ ಇಡುವ ಮುನ್ನ ವಿದ್ಯಾರ್ಥಿ ಖಾತರಿ ಮಾಡಿಕೊಳ್ಳಲು ಸೂಚಿಸುವುದರಿಂದ ನಾನು ನಿಮಗೆ ವಿದ್ಯಾರ್ಥಿ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸುವಂತೆ ದಿನಾಂಕ 14/3/2022 ನೀಡಿದ ಪತ್ರಕ್ಕೆ ನೀವು ದಿನಾಂಕ 19/3/2022 ಸಲ್ಲಿಸಿರುವ ವ್ಯಾಸಂಗ ಸಂಬಂಧಪಟ್ಟ ದೃಢೀಕೃತ SSC ಅಂಕಪಟ್ಟಿ ಆಧಾರ್ ಕಾರ್ಡ್ ಪರಿಶೀಲಿಸಿದಾಗಿ ಈ ಹುದ್ದೆಗೆ ದ್ವಿತೀಯ ಅತಿ ಸಹಾಯಕರ ನೇಮಕಕ್ಕೆ ಸಮಾನದ ಕನಿಷ್ಠ ವಿದ್ಯಾರ್ಥಿ ದ್ವಿತೀಯ PUC ಉತ್ತೀರ್ಣ ಆಗಿರಬೇಕಾಗುತ್ತದೆ. ಆ ಸಾಮಾನ್ಯ ವರ್ಗಕ್ಕೆ ಸೇರಿದ ಅಭ್ಯರ್ಥಿಗೆ 35 ವರ್ಷ ನಿಯಮಿತ ಇರಬೇಕಾಗುತ್ತದೆ. ನಿಮಗೆ 40 ವರ್ಷ ಆಗಿರುತ್ತದೆ. But he is only SSC pass and he is age 40 years. On the both account is ineligible to hold this chief executive post as per rule 17 and 18 plus rule 18.
So they're taking action. What is the problem?
That's not it. Now he is insisting to take the post.
They have initiated action. They will take action.
Lordship may
At your instance, this cannot.
Lordship may observe that and discourse. Even Lordship may observe that they are taking, let them take interest and let them consider.
Perfect. Learned AGA takes notice for response number 1 to 3. Notice to response number 4 and 5. 4 to 6 is dispensed with, since this writ petition is being disposed of at the stage of admission. Full stop. At the stage of preliminary hearing. Full stop. Next para. The grievance of the petitioner is directed against the fifth respondent, who was appointed as a special officer, chief executive officer of the fourth respondent, K. Naganahalli Milk Producers Cooperative Society. For the purpose of our CEO antane appoint agidra.
Chief executive officer.
Full stop. For the purpose of that. Full stop. However, in view of certain allegations made against the fifth respondent,
on 7/6/21, he was discharged from the service.
Huh?
On 7/6/2021, he was discharged from the service initially.
on 7/6/2021, he was discharged from service. So thereafter, the sixth respondent was appointed in the place of the fifth respondent. He wrote 20 years. Huh? Sixth respondent.
Huh? We don't know the correct date. Some mistake I have.
So, nevertheless, on the reinstatement of the fifth respondent, the fifth respondent was once again directed to take charge as CEO of the fourth respondent society.
As of now, he has not taken any charge.
It is submitted on behalf of the petitioner that the fifth respondent is not qualified to hold the post of CEO. Stop. This aspect of the matter is sought to be supported by a communication dated 23/3/2022 made by the special officer to the fifth respondent, and the said document is filed along with a memo dated 30/3/2022. So, the memo is taken on record subject to all just exceptions. Stop. Next para. Learned counsel for the petitioner submits that since the fifth respondent does not have the requisite educational qualification, he cannot be continued as CEO of the fourth respondent society. Stop. Next para. It is evident from the communication dated 23/3/2022 that the chief officer, the special officer, has in fact communicated to the fifth respondent regarding the educational qualification, and that he is not entitled to be continued as CEO. So, therefore, the grievance of the petitioner is already considered by the special officer, and action is sought to be initiated against the fifth respondent. So, in that view of the matter, this writ petition is premature. Full stop. If no action is taken for removal of the fifth respondent, consequent to the action initiated by the special officer, only then the petitioner may be entitled to seek a removal of the fifth respondent. Full stop. At this stage, the writ petition cannot be entertained. Full stop. Next para. Consequently, the writ petition stands disposed of.
To answer the special officer and second respondent may consider. Second respondent may consider. The second respondent is appointed. He appointed second respondent. Second respondent also consider the report of the special officer. That one line observation.
Lord, we have only said he has already initiated action. It has to be taken further. I thought sentence add. Yes.
The second respondent also consider the report of the.
Yes.
Kindly pass on. Kindly pass on.
Serial number 8, my lord. I'm representing Mr.
ಏನಪ್ಪ ಇದು? Huh?
Serial number 8, my lord.
Yes, yes.
Yeah, I'm representing Mr. Manmohan P and appearing for R3, my lord.
Yes, yes. And what is the matter about?
Sanction, my lord. Kindly pass on.
Huh?
Serial procedure is against me. Kindly pass
Actually,
on. Sanction challenge.
He is challenging 17A permission granted to prosecute, my lord, to do the investigation.
Chief Engineer, BPMP.
Yes, my lord.
Possible.
Please.
My lord, I appear for the petitioner. I may permit to present the petitioner advocate. My lord, in this case, we have sought for, I appear for the petitioner. My lord,
Yes.
we have sought for consideration of our representation, my lord, mandamus, annexure J, page 25. We are requesting, my lord, the compassionate appointment, my lord. My father was working as an inspector in the United Insurance Company. We have multiple representations, my lord. There is no there is no response. So if my lords would, my lord, direct the expeditious consideration, we'll make a and they can annexure J, page 25.
No, representation, who has to consider?
The United Insurance Company, my lord.
Where?
My lord, annexure J, it is addressed to the zonal office.
Hubli.
Yes.
Why have you come to Bangalore?
My lord, the earlier posting was, he was holding the posting at Bangalore. The office is there, my lord. But earlier his postings were here. Earlier he had held offices here also. The zonal office is situated there. Bangalore ಕೆಲವೊಂದು series of communications ಮಾಡಿದೀವಿ. Only, my lord, I am asking a representation to be considered or keeping all contentions open, my lord. Only a mandamus, my lord, to anywhere to consider or not. So, many representations were given that have remained undecided and
issue emergent notice to the respondent.
I may be permitted to serve the standing counsel to United Insurance.
ಅದು ಪ್ರಾಬ್ಲಮ್ ಏನು ಅಂತಂದ್ರೆ those are all MACT matters.
Please.
ಆ ಪ್ಯಾನಲ್ ಅಲ್ಲಿ ಇರೋರು. This is service matter, so let them decide.
I'll serve and I'll move the matter.
Yes, yes.
I'm grateful.
Practicing advocate. He was appointed legal officer for respondent company. Account of some harassment, sexual harassment. She had presented complaints. Legal officer was warned. In spite of that, being harassed, transferred to various other places, despite the National Commission for Women
Ah.
directing the respondent not to transfer. Thereafter, proceedings are initiated on the shared ground that being a advocate on record or practicing, she is not entitled to take up employment.
Onditala is similar matter.
Yes, there is a similar matter I have referred to it.
Ah.
WP is pending.
Ah.
With regard to transfer.
Ah.
This is with regard to sent in the order past. Disciplinary inquiry. On this ground. That she is a practicing advocate and
No, but we have directed in that matter itself, not to precipitate. Nanta. Huh?
Same to be connected.
Where was the need to file? Where was the need to file one more writ petition, sir?
Very transfer. In that
No, but at your request, we have directed not to take any further action.
However, there is no direction to speak. The applicant transfer was made much earlier. This order is communicated recently. Next year that you come to next year that.
Sir, I remember very well.
Yes. I have referred to that.
Where is that order? Where is that interim order that I had passed?
Not to precipitate.
Illegal.
WP number.
Page number 83. In the meanwhile, if the first respondent is contemplating any other inquiry against the petitioner on the ground that she has not surrendered her sanad to the Bar Council of Karnataka, no precipitatory action shall be taken till the next date of hearing.
Yes. In this case, that is only with regard to transfer. We have not sought for quashing of the inquiry proceedings. Inquiry officer has been appointed and inquiry is about to commence. Next year, that.
It 12th of March 2022.
Recent. ಆದ್ಮೇಲೆ ರಿಟ್ ಹಾಕಿದ್ಮೇಲೆ ಈ ಬಂದೆ. ಅಲ್ಲಿ ಕೇಳಕ್ ಸಾಧ್ಯ. Only transfer was silent.
ಏನು charges?
Only practicing advocate cannot take up employment with the company.
Where is that?
Next year, that next year. X2. Next year, X2, page 88. Statement of imputation. Employee of the so cannot accept any PR. Polygram. Active member of the Karnataka State Bar Council.
Who is appearing in that matter? Or BML?
Find out and serve copies of the same advocate. I'll serve it.
ಅಲ್ಲ ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿಲ್ವಾ ಇನ್ನು? Who is the advocate?
ಕೊಡ್ತೀವಿ ಸರ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಸರ್ ಮಾಡಿ. Nine 754 and 54 of the 2021.
Nataraj Ballad. Learned Counsel Shri Nataraj Ballad is directed to take notice for respondents, for all the respondents. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the Learned Counsel for the respondent. Good stop. The petitioner, next para, is already before this court in WP number 19754 of 2021. Challenging
Order of transfer. Order of transfer.
challenging an order of transfer. Stop. However, by an interim order dated 21/3/2022, this court had directed the respondents not to take any precipitatory action if the respondents are contemplating any other inquiry against the petitioner on the ground that she had not surrendered her sanad to the Bar Council of Karnataka. Stop. However, in this writ petition, the petitioner brings to the notice of this court that by the impugned order dated 12th of March 2022, an inquiry officer and presenting officer have been appointed to conduct inquiry in respect of the very same issue. Stop. Next para. Consequently, there shall be stay of all further proceedings pursuant to the impugned order dated 12/3/2022, annexure Z, till the next date of hearing.
Petitioners not are all the directors of the respondent number 4, Milk Producer Cooperative Society, Pune Tumkuru. Not election was held on 7/1/2019, in which 11 directors were elected. Not on 1/12/2021, one Jayama Manot submitted a resignation as per Annexure E. Not after the statutory period of 15 days, her resignation was accepted. And in her place, one Jayama was co-opted on 10/1/2022 as per Annexure F. Not thereafter, what happened? Not on 22/2022, 4 more directors, Krishnamurthy, Shankar Lingegowda, Moregowda, G. Netra submitted their resignation. Not after the statutory period of 15 days, their resignation was accepted, and in their place, under section 29E, 4 more directors were co-opted as per Annexure H, as per Annexure J, on 14/3/2022. Same was intimated to the assistant registrar that the resolution passed and the 4 directors who were co-opted. Same was intimated to the assistant registrar as per Annexure J1, page number 49. And thereafter, on 21/3/2022, the monthly meeting was also held. There were a total number of 11 directors. It so happened, my lord, one Shankar Lingegowda, who had submitted his resignation letter on 22/2022 along with 3 other directors. He makes a representation to the assistant registrar saying that in the meeting in which Jayama had resigned and in her place one another person was co-opted on 10/1/2021. His signature is not there. His signature is forced. He makes a representation on 19/3, my lord. And assistant registrar, my lord, he says that I see that there is a forgery in the signature. Therefore, Lord, there is no, thereafter subsequent whatever has been held, it's all null and void, and he appoints a special officer in section 31. Without there being Lord, he does not, he has no locus standi to file. He has already resigned. His resignation was accepted. Now kindly see annexure L, my Lord, a democratically elected body has been
Learned AGA takes notice for response number 1 to 3. Issue emergent notice to response number 4 and 5. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on learned AGA. Release this matter on 7th of April.
Allah, kindly see, my Lord, kindly see.
No, sir.
Allah, kindly see the.
Sir, all these factual aspects, we can't take it for granted.
Lord, it was intimated that co-option has been already intimated.
Let us see, let them come, let them come. Yes.
Kindly see annexure L, my Lord. Now they say, Lord, they will take charge, my Lord.
No, sir, let him take charge. It's okay. Yes.
Apologies to the honorable court. On the earlier hearing date, I could not be present before the honorable court, my lord. Had some personal inconvenience. My colleague could not appear, my lord. My apologies to the honorable.
No problem.
Sorry, my lord. My lord, this is a writ of mandamus. My lord, there was, my lord, with regard to the second respondent, my lord, it was, they say that, my lord, they are not coming under the state. So therefore, my lord, whether it lies or not, that's the first point, my lord. That also, my lord, I asked my client. The second respondent is the Regional Oil Seeds Growers Cooperative Societies Union Limited. My lord, according to our information, my lord, it is coming under the Department of Cooperative Societies, but later, my lord, a query was raised, my lord, from the government side that it is not coming under the government. But my lord, when I appeared for the competitive exam, my lord, I sought for the copies of the OMR and answer sheets. My lord, recently, my lord, the second respondent, my lord, they say that, my lord, they will consider our prayer and they will supply it. Therefore, my lord, I pray for a short accommodation. If they, my lord, if I get those, my lord, I may withdraw this petition, my lord, because my purpose will be served. My lord. That's my humble submission. 2 weeks accommodation.
Submits that there is a possibility of the grievance of the petitioner being redressed at the hands of the second respondent. Full stop. Therefore, learned counsel prays for some time. Full stop. Release this matter on 18th of April.
Please.
Yes.
ಪಾರ್ಟಿ ಹುಷಾರಿಲ್ಲ ಪಾರ್ಟಿ ಸಿಗ್ನೇಚರ್ ಬೇಕು ಪಾರ್ಟಿ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದ್ದಾರೆ
ನಮ್ಮ ಪಾರ್ಟಿ ಹುಷಾರಿಲ್ಲ ಅಂತಂದ್ರೆ ನೀವೇ ಯಾರು ಹೋಗ್ಬಿಟ್ಟು ಸಿಗ್ನೇಚರ್ ತಗೊಳಕ್ ಬರಲ್ಲ. What do you want now?
1 week time.
In spite of submitting on the previous occasion that a memo will be filed at the hands of the petitioner seeking to withdraw this writ petition, learned counsel for the petitioner seeks for some more time on the ground that the petitioner is not in station. Full stop. Release this matter on 7th of April 2022. Yes.
Lords, the parties have settled the matter. We had pertains to termination of the respondent from his services for misconduct and misappropriation. We challenge the order before the education tribunal. The education tribunal set aside our termination. We challenge that order before this honorable court. The parties have settled the matter. We have paid a rupees sum of 18 lakhs to the respondent as full and final settlement. Both the parties have signed the settlement agreement on 22nd of February 2022.
Who's for the respondent?
Mr. Bhaskar is
He's not come today. Mediation happened where? Not in the Bangalore mediation center.
Bangalore mediation.
Huh?
Bangalore mediation. Report to mediation from this on.
Correct, but they send it in a prescribed format, isn't it?
Please,
This is done by you.
no, Lord. Before the mediation center itself, the mediator drafted the settlement proposal.
Where is the signature?
It's not forthcoming.
Bangalore mediation center seal ಹಾಕಿದ್ದಾರೆ. The parties have submitted a memorandum of settlement drawn before the Bangalore Mediation Center. Under section 89 of CPC, read with rules 24 and 25 of the Karnataka Civil Procedure, bracketly mediation, close rules, 2005, along with the a covering letter dated 24/2/2022, forwarded by the Bangalore Mediation Center. So, in terms of the settlement, the petitioner has paid a sum of rupees 18 lakhs to the respondent, Shri S.G. Hanumantaraju, as full and final settlement. And both the parties have given up their claims against each other. So, consequently, the writ petition stands disposed of in terms of the memorandum of settlement entered into between the parties. Full stop. Ordered accordingly.
There is the order of the education tribunal, orders reinstatement that has to be set aside by this one court.
Next para. Consequently, the impugned order dated 16/3/2016 passed by the Educational Appellate Tribunal and third additional civil district and session judge, Bangalore City, in MA bracketary EAT close number 4 of 2008 is accordingly set aside. Huh? Arvan?
Represent R2.
My lord, serial number 15, my lord.
Yes.
My lord, I am appearing for petitioner, my lord. My lord, I have filed memo for
R1 HCGPS respond number 1. Learned counsel for the petitioner has filed a memo dated 29/3/2022 seeking leave of this court to withdraw the writ petition. Why with liberty to file fresh petition?
Yes, my lord.
Why?
My lord, I have not been informed.
You will have to give reasons, madam, why if
My lord, I'm the proxy counsel, my lord. Senior just intimated me to make representation, my lord.
I'm not aware. Memo has not been served to me.
What can be the reason? If they are asking for liberty, transfer matter,
that it isn't been so far as that for the penalty that account of so far as that he has a misappropriation. Where that so far as that increment also has been reduced. On account of that they have just challenged.
Reasons ಹೇಳಲಿಲ್ಲಮ್ಮ.
My lord, may I seek instruction in
Pass over.
Oblige.
Yes.
In this matter, main matter, find IF for direction, payment of salary. I am working in a petitioner institution. Granting me the petitioner institution was cancelled. That was challenged before this court by the petitioner institution. The Lord, this honorable court was pleased to state the impugned order passed by the first respondent. Later on, the Lord, some affected parties who were working in the petitioner institution have filed a impleading application that was also has directed the respondent to consider the granted a leave.
He had passed some orders, if I remember.
21/9/2021 order.
Earlier, on 21/9, your lordship passed an order in all three petitions.
21/9?
21/9/2021. In view of the order, interim order passed by this honorable court, I am also entitled of the benefits of the
21/9.
Yes.
I am permitted to read last portion, last paragraph.
Prima facie, although the applicants being staff of the institutions are not concerned with the impugned order, but however they are affected since they were to be transferred to any other aided institution. Therefore, the impleading applications are required to be allowed according to
liberty could transfer ಮಾಡಿ ಹಾಗೆ payment.
Thereafter,
I am also working in the petitioner institution.
Huh?
I am also working in the petitioner institution, my lord. In view of the order passed by this honorable court, I am also entitled for the benefits of the
Yeah, from 5/10/21.
That way of the matter, liberty is granted to the respondent state to transfer the staff to any other aided institution and pay them the salary attached to the aided post. The arrears of salary shall also be paid to the staff. To that extent, the interim order dated 31/10/2020 stands clarified. The directions issued herein shall be complied by the state government as expeditiously as possible.
Nanu impeding application. I have also filed impeding application for R12 and R13.
Where was the need for you to file one more application? Where was the need for you to file one more application? This is not restricted only to the applicants. The benefit is given to all the staff.
They are not considering the same. That is the reason I have preferred this application before this honorable court. And I have filed a IA for impeding application for R12 and R13. Clarity ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಹೀಗಾಗಿ ಕೊಡಕ್ಕೆ ಬರಲ್ಲ.
ಏನು ಕ್ಲಾರಿಟಿ ಇಲ್ಲ? ಏನಪ್ಪ? So you want the same benefit, though it was granted. You have filed IA number?
IA number 3 and 4. One is for impeding application and one is for direction.
ಯಾವ್ದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ
ಮೇನ್ ಮಾಡಿ ಫಸ್ಟ್ ಪಿಟಿಷನ್ 12794
3 and 4 of 2021. Direction filed by advocate for respondent number 12 and 13. You are already a respondent.
No, that was a mistake. ಅದರಲ್ಲಿ impeding application ಬರೆದು ಬಿಟ್ಟು 12-13 ಅಂತ. Impeding application was allowed.
Allowed.
It was allowed. Direction is pending. Direction IA for direction is pending for consideration. That is.
Then you are respondent number 12 and 13.
12 and 13.
Orders on IA number 3 and 4 of 2021. ಈ ಆರ್ಡರ್ ಅಲ್ಲೇ ಮಾಡಬಹುದಾಗಿತ್ತಲ್ಲ ಅವರೇ. Why it had to be brought before me?
Because I am the respondent also, but the order is very clear.
Correct.
Totally no restriction.
Where was the need to bring all these matters before me?
But therefore, there is no order restricting on the petitioners or the applicants not in that application. All the staff are directed.
2021 in WP number 12794 of 2020. Respondents number 12 and 13 have filed this application. These applications seeking a direction to the respondent state to pay the salary to the said respondents attached to the aided post and to direct payment of arrears of salary by extending the benefit granted by this court in its interim order dated 21/9/2021. Next para. It's clear from the interim order dated 21/9/2021 that this court, having considered the predicament of the staff institution. Respondent, which is the respondent, which institution?
Sri Srinivasa Education.
Respondent number.
Petitioner.
They are the petitioner.
ಅದನ್ನ ಕೇಳಿತ್ತು. Petitioner is a institution.
Petitioner is 12794.
ಏನಂದ್ರೆ? Of the petitioner institution. Who were left without any salary. By virtue of an interim order, earlier interim order dated 13/11/2020, they had also been directed. There also being a stay in respect of cancellation of the grant in aid, liberty was granted to the respondent state to transfer the staff to any other aided institutions and pay them the salary attached to the aided post. Staff. The arrears of salary was also directed to be paid to the staff. Staff. The earlier interim order dated 13/10/2020 was accordingly clarified. Stop. Next para. Learned Counsel for response number 12 and 13 submits that the benefit given to the respondents in the to the staff of the petitioner institution in terms of the interim order dated 21/9/2021 has been restricted by the state government only to the applicants therein. Stop. Next para. The respondent state government is hereby directed to grant the same benefit in terms of the interim order dated 21/9/2021 to respondents number 12 and 13 also. Stop. In fact, it was clear from the interim order dated 21/9/2021 that the respondent state was granted liberty to transfer the staff of the petitioner institution to any other aided institutions and pay them the salary attached to the aided post. Stop. Under normal circumstances, it is clear that the benefit was required to be extended to all the staff of the petitioner institution. Stop. Next para. Ordered accordingly.
Submission, I would like. Order dated 5/10/21. Modified that order. So far as the petition number 1163/1 of 21. 5/10/21.
ಏನಂತ
1163/1 of 21 ಗೆ last paragraph. 1163 of 21. Respondent state shall not proceed to implement the order in 21/9/21 if the teachers are already not. The hand respondent state is required to place and record the number of students studying in the institution, number of staff studying, teaching in the institution, revise the matter immediately. Also, along with my IFR posting, I have filed the required teaching staff and the student strength. The student strength and the teaching staff is much below as required under the rules. Therefore, there is a lackage of the student strength also, but only few students are left. Therefore, the teaching staff and the minimum strength of the students as per Rule 11 is not maintained in the said institution. Therefore, the applicants in the WP number 11631 also to be given the benefit of the said order.
No, that was
Yes, madam.
that was not applied in WP number 11631.
Yes, therefore now I am seeking for its application because your lordship directed the state government to furnish the list of the student strength and the teacher strength. That they did not furnish, but I have now furnished along with the application posting the student strength and the teaching staff. In fact, the students in the first year PUC are 9, 7, 16. In commerce, 2 students are there. In the second PUC, 9 students are there. The teaching strength, in commerce, 1 teacher is there. For 1 teacher, 40 students is required to be the student strength as per the rule. In this one, only 2 students are there for the teacher.
Correct.
Therefore, the student and the teacher strength the ratio is not maintained.
Yes.
Therefore, they are required to be transferred as per the order.
That is the order passed already. No.
That has been restricted now by this order.
Huh?
By the order dated 5/10/21.
That order is not applicable to WP number 11631.
Yes, therefore now I am seeking that order made applicable to 11631 also.
How are you concerned with that one?
I am the applicant in that writ petition.
Huh?
I am the implementing application in that writ petition.
Implementing
I'm sorry, my lords.
Staff.
May my lords make a submission.
There is a dispute between the
Therefore,
management.
that dispute,
It is not so. It is not so, my lords.
all the writ petitions, there is a dispute between the government and the management. Now, by order 21/9, I was also extended for the same benefit. Subsequently, oral submission made by the counsel for the petitioner, that restriction is imposed on this petition only. Now I am seeking in 11631 also the same order to be continued.
Insofar as my case is concerned, my lord, management has not made.
ನಂದು ಒಂದ್ ಕಣ್ಣು ಹೋದ್ರೆ ಪರವಾಗಿಲ್ಲ ಅವ್ರದ್ದು ಎರಡು ಕಣ್ಣು ಹೋಗ್ಬಿಡ್ಲಿ ಅಂತ. What is this? I can't understand.
What I am saying,
if you are seeking for any benefit, I can understand.
I am seeking for benefit.
ಏನ್ ಬೆನಿಫಿಟ್ ಕೇಳ್ತಾ ಇದೀರಾ ನೀವು?
Same benefit of the order dated 21/9/21.
ಏನು? What is that benefit?
Arrears of salary.
That benefit is to transfer that staff to any other institution.
Yes, arrears of
What
salary.
benefit are you going to get, sir, with that?
I am the one of the staff, I am the application.
Staff? You said you are the institution.
No. I said I am one of the implementing applicant.
Implementing applicant.
Yes.
So now you are for one of the implementing applicants.
Yes. That
In that matter.
21/9, all the 3 petitions, all of them were to be transferred. By 5/10, the subsequent order,
Implementing applicant, who are you?
staff,
Staff?
Yes,
You don't want to be transferred.
I want to be transferred.
You want to be transferred.
Yes, by this order, that is restricted. By
Where is that?
5/10/21 order.
ಯಾವ್ದ್ರಲ್ಲಿ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು?
11631 of 21.
My lords, I appear for my lords management in the matter. My lords, in fact, my lords, implementing applications for fine, my lords, in all the matters. Your lordships consider, my lords, initially, my lords said that will be considered along with the main. However, in other matters also, my lords, applications were filed, and IA for vacating, my lords, was filed. My lords, those instances, my lords,
In 11631 of 21.
I agree for implementing.
Yes, and for
your lordships passed another order later on.
it was allowed, implementing application is allowed. And the same order was extended to me by the 21/9 order,
Subsequently, an order was passed. My lords, your lordships passed the order, considering my lords, the submission made in the other application that the institutions are closed. Insofar as our institution, my lord, it was not closed. There is a distinction, my lord, which I pointed out. As such, my lord, your lordship said that the strength of the institution be placed on record by the respondent. I contended that, my lord, the order virtually amounts to closure of the institution.
The applicant ಹೆಸರೇ ಹಾಕಿಲ್ವಲ್ರಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ?
First, after the cost title itself, the name, sir. In the cost title itself.
CB Doddayya.
Yes.
Churamayya.
Against them, my lords, we initiated disciplinary proceedings. To escape, my lords, they have filed the application. I have filed, my lord, the objection and filed on record, my lord, the notices issued to them. They are unauthorizedly absent.
That's all right. The state is required to file its objections. Because if you are talking about the number of staff, It is for the state government to clarify that.
They did not do. I have done it. What I'm saying.
Nimdagalla.
They only have to do. Their own letter I produced.
No. Let them only file.
IFR posting.
Let them only file.
IFR posting download.
In idral ಬರ್ಕಳಿ 11631 of 2021 ಅಲ್ಲಿ ಬರ್ಕಳಿ. The respondent state is directed to file objections to
Comply with the order. Say.
To IA number. See that IA that you have filed.
Your Lordship kindly see the order in 5/10/21. Let them comply with the order dated 5/10/21 so that it will be clear. Your Lordship said, my lord, the date is required to place on record the number of our students studying in the institution.
5/10/21.
The common order is passed in petition.
Respondent state is required to place on record the number of students
Studying in the institution and the number of staff teaching in the institution.
Yes.
Let them do that, my lord. Comply with the order.
In the other, that was, my lords, passed in view of the fact that, my lords, other cases, there were no students. I contended that, my lord, there were students in our institution.
Correct,
and
sir.
virtually
Correct.
almost closure.
Correct. So there was already a direction.
Yes, my lord. Let them comply with that direction and produce for a lordship the student strength and the teaching strength.
ಇದರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಇನ್ನೊಂದು ರೆಪ್ಯುಟೇಷನ್ ಅಲ್ಲಿ. Although the respondent state government was directed by order dated 5/10/2021 to place on record the number of students studying in the institution and the number of staff teaching in the institution, comma, the information is not forthcoming
From the state government.
from the state government. Full stop. Learned council for respondent number 4 and 5 submits that he has supplied the requisite information along with
IFR posting.
the IFR posting alla of
To show, my lord, to show the urgency in the matter, my lord, I had to produce that. To show the urgency, my lord, in posting, getting the matter.
22. So, nevertheless, it is for the state government and its authorities to clarify the said position. Full stop. Therefore, the learned SCGP is hereby directed to comply with the directions issued on 5/10/2021 and place on record the requisite information. Full stop. Release this matter on
7th, your lordship.
7th of April.
Already there is a letter, but I have got that letter from the state government itself.
It is only for download system.
Please.
I'm for the petitioner in this case. The petitioner, the husband has got two wives. One is relation with the rent.
Objections, Chairman.
One objection in the prayer. I will do it.
Index to be filed along with the page numbers. Date mentioned at prayer to be clarified with respect to annexure B. All annexures to be filed and objections. More there.
Permit next week.
What about court fee?
It's paid.
Court fee is paid. Then it comes for the petitioner submits that court fee has been paid. However, in respect of the other office objections. Learned counsel prays for a short accommodation to comply. An interim prayer is here. Yenilla. I'll issue notice then. Please. Learned AGA takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on learned AGA. Full stop. In the meanwhile, office objection shall be completed.
It is suspension matter.
To approach the respondent.
Learned counsel for the petitioner has filed a memo dated 31/3/2022 stating that the petitioner does not wish to prosecute the petition any further. Full stop. The petitioner intends to make a representation to the respondent to review the suspension order. Full stop. It is also stated that in the event of non-consideration of the representation, liberty may be reserved to the petitioner to move this court. Stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn. Full stop. Liberty is also reserved to the petitioner to file a fresh petition, in the event of his representation not considered favorably by the respondent. Ordered accordingly.
I'm sorry, Lord, I have consumed.
It's all right. Yes, Mr. Srikanth.
There are two objections, my lords. One is insofar as the certified copy to be produced. My lords, I'll undertake to file, my lord, IFR dispensation, my lords, so far as that is concerned. And 2 pages are required to be attested. My lord, these are the only objections which remain. But the matter requires some urgent consideration, my lords, for the reason that, my lords, I'm JOC candidate, my lords, who was working in, my lords, the institution run by the management. My lords, the management accommodated me, my lords, as the JOC courses came to be closed in the high school of the management. Whereas, my lords, the private respondent, my lords, he wants to come to this institution. And, my lords, an order is passed, my lords, in his favor by the government. In fact, my lords, your lordships held, my lords, in respect of the rules.
JOC
and job oriented courses. In fact, my lords, earlier, these courses were conducted, my lords, as a policy measure. My lords, all the courses were closed. And the persons who were working in such institutions were redeployed, my lord, in pre-university colleges and high schools. Of that is, if they are government staff, my lord, they were accommodated government institutions. For aided, my lords, they were accommodated in aided institution. Lords, the person, my lords, who is not wanted in the institution, against whom, my lord, certain criminal cases are also lodged, even as per the management. My lords, is sought to be, my lord, imposed on the management. In fact, my lord, similar issue had come up for consideration before your lordships. Page number 55, my lords, in respect, we challenge the rules.
How are you concerned with that?
My lords,
who are you?
My lords, I am employed in the institution. I was also a JOC employee. I was accommodated in this institution. Management has given no objection in my favor. They said we'll accommodate him. In fact, my lords, I have been working throughout. And in fact, there were earlier orders issued. Now, my lords, when the matter goes to the government, my lord, government says hold counseling and post them. My lords, this honorable court, my lords, has held. If your lordships kindly see, my lords, page number 55. Annexure P, my lords, the issue arose, my lords, in respect of the similar provision contained in Rule 11.6 of the my lords, 19 rules applicable to primary and secondary employees. My lords,
yes, yes. I
this honorable
remember.
court held, my lords, that they cannot be imposed upon, my lords, the management. In my case, my lord, there is a clear representation, my lords, page number 48, annexure L, if you lords kindly see, of the management itself. They say the Shivaswamy, my lord, who is the respondent in the case, lord's eighth respondent, is not required in the institution because against him several cases are pending, and they have preferred me, my lords, and said we don't have any objection for him to be continued. In spite of that, my lord, the institution is asked to take him onto duty, my lord. If that happens, my lords, I'll be displaced.
Where is the communication?
Lords, annexure M, lords, is the order of the government directing, my lords, the commissioner.
52, annexure N.
Please, annexure M ali. They record, my lords, the operative portion of the earlier order passed, where it is said that, my lords, the speaking order will be passed. ಅದರಂತೆ ಪ್ರಕರಣವನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಎಂ.ಎನ್. ಶಿವರಾಜು ಎಲ್ ಶಿವಸ್ವಾಮಿ
please read the first paragraph.
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೋಟ್ಸ್ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದ ಪ್ರಸ್ತಾವನೆಯನ್ನು
ಅಲ್ಲ, ಇದು
ಪರಿಶೀಲಿಸಿ
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ.
That is, my lords, annexure M, my lords, dated 16/7/2000.
Annexure N only.
Annexure M, my lords, the order, please, my lords. ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸು ದಿನಾಂಕ 6/4/11 ರಾಜ್ಯದಲ್ಲಿನ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆಯಲ್ಲಿರುವ ಖಾಸಗಿ ಅನುದಾನಿತ ಸಂಸ್ಥೆಗಳ ವೃತ್ತಿ ಆಧಾರಿತ ಕೋರ್ಸ್ಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಅರೆಕಾಲಿಕ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳನ್ನು ವಿಲೀನಗೊಳಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿದೆ. ಈ ಹುದ್ದೆಗಳಿಗೆ ವಿಲೀನಗೊಳಿಸುವ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಶ್ರೀ ಎಂ.ಎಸ್. ಶಿವರಾಜು, ರೂರಲ್ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಇವರಿಗೆ ಉಲ್ಲೇಖ 2 ಶ್ರೀ ಶಿವಯೋಗಿ ಮುನೇಶ್ವರ ಸ್ವಾಮಿ ವಸತಿ ಪ್ರೌಢಶಾಲೆ, ಶ್ರೀ ಮಲ್ಲೇಗಾವಿ ಮಠ, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ, ನಂತರ ಉಲ್ಲೇಖ 3ರ ಆದೇಶದಲ್ಲಿ ಸ್ಥಳ ಮಾರ್ಪಡಿಸಿ ಗ್ರಾಮಾಂತರ ಪ್ರೌಢಶಾಲೆ ಸಾತ್ನೂರು, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಶ್ರೀ ಎಲ್ ಶಿವಸ್ವಾಮಿ ತೋಟಗಾರಿಕೆ ಶಿಕ್ಷಕರು, ಭಾರತೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು, ಭಾರತೀನಗರ, ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಇವರಿಗೆ ಉಲ್ಲೇಖ 4 ಗ್ರಾಮಾಂತರ ಪ್ರೌಢಶಾಲೆ ಸಾತನೂರು, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಗೆ ಸ್ಥಳ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 3ರ ಸರ್ಕಾರದ ಆದೇಶದ ಮಾರ್ಪಾಡು ಆದೇಶದಂತೆ ಕ್ರಮವಹಿಸುವುದಾದಲ್ಲಿ ಶ್ರೀ ಶಿವಸ್ವಾಮಿ ಅವರಿಗೆ ಸ್ಥಳ ಹಂಚಿಕೆ ಬಗ್ಗೆ ಸರ್ಕಾರದ ಮಾರ್ಗದರ್ಶನ ಕೋರಲಾಗಿರುತ್ತದೆ. ಶ್ರೀ ಶಿವಸ್ವಾಮಿ ಎಲ್ ತೋಟಗಾರಿಕಾ ಶಿಕ್ಷಕರು, ಭಾರತೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು, ಭಾರತೀನಗರ, ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಇವರನ್ನು ಗ್ರಾಮಾಂತರ ಪ್ರೌಢಶಾಲೆ ಸಾತನೂರು, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಅನುದಾನಿತ ಶಾಲೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಲಾಗಿತ್ತು. ಸದರಿ ಶಿಕ್ಷಕರನ್ನು ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿರುವ ಗ್ರಾಮಾಂತರ ಪ್ರೌಢಶಾಲೆ ಸಾತನೂರು, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಯಲ್ಲಿ ಈಗಾಗಲೇ ಶಿವರಾಜು ಎಂಎಸ್ ಎಂಬ ವೃತ್ತಿ ಶಿಕ್ಷಕರನ್ನು ನೇಮಕಾತಿ ಮಾಡಿರುವುದಾಗಿ ಆಡಳಿತ ಮಂಡಳಿಯವರು ಠರಾವು ಸಲ್ಲಿಸಿ ಶ್ರೀ ಶಿವಸ್ವಾಮಿ ಎಲ್ ಅವರನ್ನು ಈ ಶಾಲೆಯಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಕೊಳ್ಳದೆ ನಿರಾಕರಿಸುತ್ತಾರೆ. ಶ್ರೀ ಎಲ್ ಶಿವಸ್ವಾಮಿ ತೋಟಗಾರಿಕೆ ಶಿಕ್ಷಕರು, ಭಾರತೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು, ಭಾರತೀನಗರ, ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಇವರು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಾಖಲಿಸುವ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ ಸೋನ್ಸು ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ದಿನಾಂಕ 10/6/2019 ತೀರ್ಪಿನ ಉದ್ಧೃತ ಭಾಗ ಈ ರೀತಿ ಇದೆ. Therefore, on the short question that the petitioner has not been provided an opportunity before replacing him by appointing 5th respondent, annexure G dated 6/12/2014 stands set aside insofar as 5th respondent is concerned. The first respondent date is hereby directed to issue show cause notice to the petitioner within a period of 4 weeks. Thereafter, petitioner is permitted to submit his explanation within a period of 4 weeks from the date of receipt of the notice. After receipt of the petitioner's explanation, first respondent is hereby directed to take decision by passing an order within a period of 10 weeks thereafter ಎಂದಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಇದುವರೆಗೂ ಶ್ರೀ ಶಿವರಾಜು ಎಂಎಸ್ ವೃತ್ತಿ ಶಿಕ್ಷಕರು, ಗ್ರಾಮಾಂತರ ಪ್ರೌಢಶಾಲೆ ಸಾತನೂರು, ಕನಕಪುರ ತಾಲೂಕು, ರಾಮನಗರ ಜಿಲ್ಲೆ ಮತ್ತು ಶಿವಸ್ವಾಮಿ ಎಲ್ ತೋಟಗಾರಿಕಾ ಶಿಕ್ಷಕರು, ಭಾರತೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು, ಭಾರತೀನಗರ, ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಇವರನ್ನು ಒಂದೇ ಹುದ್ದೆಗೆ 2 ವೃತ್ತಿ ಶಿಕ್ಷಕರು ಸ್ಥಳ ನಿಯುಕ್ತಿಯಿಂದ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವಾಗದೆ ಬಾಕಿ ಉಳಿದಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 6ರ ಈ ಸರ್ಕಾರಿ ಪತ್ರದ ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನ ಅಂಶಗಳನ್ನು ಪ್ರಸ್ತಾಪಿಸಿ ಸರ್ಕಾರದ ನಿರ್ದೇಶನ ಕೋರಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 8ರ ಸರ್ಕಾರ ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ಎಲ್ ಶಿವಸ್ವಾಮಿಯವರ ಹುದ್ದೆ ಸಕ್ರಮೀಕರಣದ ವಿಚಾರದಲ್ಲಿ ಸೂಕ್ತ ನಿರ್ಣಯ ಕೈಗೊಳ್ಳಲು ಸೂಕ್ತ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಇದರನ್ವಯ ಉಲ್ಲೇಖ 9ರಲ್ಲಿ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ 83 ನಿಯಮಗಳ ಅನ್ವಯ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಯು ಆಡಳಿತ ಮಂಡಳಿ ಆಗಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಒಮ್ಮತದ ನಿರ್ಣಯ ಕೈಗೊಳ್ಳದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಪ್ರಕರಣಗಳನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ ಎಂದು ಪ್ರಸ್ತಾಪಿಸಿ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ನಿರ್ದೇಶಿಸಿರುವಂತೆ ಜಿಲ್ಲಾ ಉಪನಿರ್ದೇಶಕ ರಾಮನಗರ ಜಿಲ್ಲೆಯವರಿಂದ ಸ್ವೀಕೃತವಾದ ಮಾಹಿತಿ ದಾಖಲೆಗಳನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗುತ್ತದೆ. ಉಲ್ಲೇಖ 10ರ ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ಎಂ.ಎನ್. ಶಿವರಾಜು ಮತ್ತು ಎಲ್. ಶಿವಸ್ವಾಮಿ ತೋಟಗಾರಿಕಾ ಶಿಕ್ಷಕರು ಇದುವರೆಗೂ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳ್ಳದೇ ಇರುವುದರಿಂದ ಸದರಿ ವೃತ್ತಿ ಶಿಕ್ಷಕರಿಗೆ ಕೌನ್ಸಿಲಿಂಗ್ ಮೂಲಕ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸುವಂತೆ ಹಾಗೂ ಈ ಬಗ್ಗೆ ಕೈಗೊಂಡ ಕ್ರಮದ ಮಾಹಿತಿಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖ ಸೋನ್ಸರ್ಲಿ ಕಚೇರಿಯಿಂದ ಕೋರಿದ್ದ ಮಾಹಿತಿಯನ್ನು ಉಪನಿರ್ದೇಶಕರ ಆಡಳಿತ ರಾಮನಗರ ಜಿಲ್ಲೆಯವರು ಉಲ್ಲೇಖ 12ರಲ್ಲಿ ರಾಮನಗರ ಜಿಲ್ಲಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಿವಿಧ ಕಾರಣಗಳಿಂದ ಖಾಲಿ ಇರುವ ವೃತ್ತಿ ಶಿಕ್ಷಕರ ಖಾಲಿ ಹುದ್ದೆಗಳ ಮಾಹಿತಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಜಿಲ್ಲಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ರಾಮನಗರ ಜಿಲ್ಲಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಆಧರಿಸಿ ದಿನಾಂಕ 19/1/22 ಅಪರಾಹ್ನ 3 ಗಂಟೆಗೆ ಆಯುಕ್ತರ ಕಚೇರಿ ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಸಭಾಂಗಣದಲ್ಲಿ ಕೌನ್ಸಿಲಿಂಗ್ ಹಮ್ಮಿಕೊಳ್ಳಲಾಗಿತ್ತು. ಆದರೆ ಆಡಳಿತಾತ್ಮಕ ಕಾರಣಗಳಿಂದಾಗಿ ಸದರಿ ಕೌನ್ಸಿಲಿಂಗ್ ಅನ್ನು ಮುಂದೂಡಿ ದಿನಾಂಕ 20/1/21 ಹಮ್ಮಿಕೊಳ್ಳಲಾಗಿತ್ತು. ಸದರಿ ಕೌನ್ಸಿಲಿಂಗ್ ಶ್ರೀ ಶಿವರಾಜು ಸೋನ್ಸೋ ಮತ್ತು ಶಿವಸ್ವಾಮಿ ಸೋನ್ಸೋ ಇವರು ಖುದ್ದು ಹಾಜರಿದ್ದು ಸ್ಥಳ ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡು ಸ್ಥಿರೀಕರಿಸಿ ಸ್ಥಳ ಆಯ್ಕೆಯ ಚಾಲನಾದೇಶವನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಕ್ವಿಡೇಷನ್ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ತೀರ್ಪಿನ ಬೆಳಕಿನಡಿ ಮತ್ತು ಉಲ್ಲೇಖ 10ರ ಸರ್ಕಾರದ ನಿರ್ದೇಶನದ ಸದರಿ ಸಿಬ್ಬಂದಿಯವರು ಕೌನ್ಸಿಲಿಂಗ್ ಅಲ್ಲಿ ಭಾಗವಹಿಸಿ ಸ್ಥಳ ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡಿರುವುದು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ಹೊರಡಿಸಿದೆ. ಮೇಲ್ಕಂಡ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ವಯ ರಾಜ್ಯದಲ್ಲಿ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣದಲ್ಲಿರುವ ವೃತ್ತಿ ಆಧಾರಿತ ಕೋರ್ಸ್ಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಖಾಸಗಿ ಅನುದಾನಿತ ಸಂಸ್ಥೆಗಳ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಅರೆಕಾಲಿಕ ಬೋಧಕ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಅನುದಾನಿತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಪ್ರೌಢಶಾಲಾ ಖಾಲಿ ಇರುವ ನೇರ ನೇಮಕಾತಿ ವೃತ್ತಿ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗಳಿಗೆ ಈ ಕೆಳಗೆ ಸಂಬೋಧಿಸಿದ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಕೌನ್ಸಿಲಿಂಗ್ ನಲ್ಲಿ ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡಿರುವ ವೃತ್ತಿ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗಳಿಗೆ ವೇತನ ಶ್ರೇಣಿ ಸೋನ್ಸೋ ಪ್ರಾರಂಭಿಕ ಮೂಲ ವೇತನದಲ್ಲಿ ಸೋನ್ಸೋ ಅವರಿನ ಸರ್ಕಾರದ ಆದೇಶಗಳು ಮತ್ತು ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ತೀರ್ಪಿನಂತೆ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಡಿಸಿ ಈ ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಈ ಕೆಳಕಂಡ ಶಾಲೆಗಳ ಹುದ್ದೆಗಳಿಗೆ ವಿಲೀನ ಮಾಡಿ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. ಎಲ್. ಶಿವಸ್ವಾಮಿ is the 8th respondent. He is posted to Gramantar Prodashale, Satmuru, Kanakpura, Taluk, Ramnagar district. Whereas I am posted to Srirama Prodashale, Hosdurga, Kanakpura, Taluk, Ramnagar district. The conditions are there. The plea that that there was that I chose the place in the counseling is not correct. I was made to sign, and your lordships can also see the counseling according to them was held.
Both of you are in Ramnagar only.
Insofar as the institution is concerned, I was working in an institution run by the same management that is the rural society, the sixth respondent hearing. I was running in another institution and I am accommodated in the high school run by the same institution. And I have been working till this day. Now, the 8th respondent, in fact, he is not wanted by the management. Management has also represented even after the order was passed. However, that is not being considered. And if your lordships kindly come to annexure K, page number 47.
Yeah, at present, this 5th respondent is not working anywhere. 8th respondent?
8th respondent is working in Bharati College. That is Malwadi. That is Bharati College, Malwadi. If he sent to Malwadi, if he sent to some Malwadi, if he sent to some other institution also, we do not have any objection. The management says he is not required in the institution. If your lordships kindly come to page number 47, the resolution of the management.
Let us see. Learned AGA. Take notice for response number 1 to 5. Issue emergent notice to response number 6 to 8. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA.
Please.
Put a fast and order based on the discourse direction.
I have said you cannot impose. So therefore, you could have asked them. They are already on record saying that they don't want this person. How can you trust him on them?
Based on the direction of this honorable court.
Correct. Yavdo.
This court has passed an order. Lordship can kindly see at page 51.
Haudama, adu aledaitu 2019. You please see my order at page number 55.
Please, 55.
Yes.
Lordship's order.
Yes. See,
management.
in
managing committee.
paragraph number 14, having considered all these aspects, I have said, having regard to these complexities and the need to balance equities, guided by the verdict of Honorable Apex Court in the case of Namit Sharma, this court is of the considered opinion.
Section 98 of that and the rules 1999 are required to be read down to make it more effective, workable, and will ensure the attainment of the object of the Act. The provision contained in Section 98 of the Act and 1999 rules. In the matter of allotting, transferring a teacher employee from one private aided institution to another shall be done only with the consent of the governing
Only with the consent of the governing council.
Now that that observation.
ಅಲ್ಲ ಇನ್ನು ಬರ್ಬೇಕಲ್ಲ ಅವರು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. We'll have to only next para. Learned counsel for the petitioner draws the attention of this court to an order passed by this court in the case of Dharmaratnakara Rai Bahadur versus State of Karnataka and others, reported in 2021 SCC Online Karnataka 12003, wherein, having considered the provisions of Section 98 of the Karnataka Education Act and the 1999 rules, which were under challenge, this court held that the provisions contained in Section 98 of the Act and the 1999 rules, in the matter of allocating or transferring a teacher or employee from one private aided institution to another shall be done only with the consent of the governing council or managing committee. Full stop. The council further draws the attention of this court to a communication. Communication of that institution. Mute ಆಗಿದೆ ಕೇಳ್ತಾ ಇಲ್ಲ.
Annexure L, page number 48.
48. Communication dated 16/2/2022 at Annexure L, made by the sixth respondent, management of Shri Rural Education Society, Kanakpura, expressing its reservation to receive the eighth respondent by transfer, and further that the institution is happy with the petitioner. Stop. Then a council therefore submits that although there is a direction in favor of the eighth respondent in WP number 57576 of 2014, dated 10/6/2019, nevertheless, the counseling and transfer of the eighth respondent requires to be considered in the light of the directions issued by this court. In the case of Dharma Ratnakara Rai Bahadur, bracketal Supra. Stop. Next para. Consequently, there shall be an ad interim order of stay of the operation and execution of the impugned order dated 16/7/2021 at annexure M.
ಯಾರು ನಾವು ಹೇಳಕ್ಕಾಗಲ್ಲಪ್ಪ ನಮ್ಗೆ ಇವ್ರೇ ಇವತ್ತು
Annexure N also request.
And order dated memorandum dated 24/1/2022 at annexure N, comma, till the next date of it.
Publish.
Next para. In the meanwhile, office objection shall be compared.
Publish.
Office objection, my lord. Court fee has already been paid, my lord. Through online. 25th of March. It is one of the office objection.
The counsel for the petitioner submits that court fee have been paid. Office to verify. Yes.
Other, my lord, paragraph numbers in affidavit, but in my office copy, my lord, it's correct, my lord. I will just do that, my lord. Only small minor this thing.
Classification to be verified.
Classification the service, because this order passed, my lord, based on the report filed under section 64 of Cooperative Societies Act. On 68, my lord, there is a direction issue. Against which, my lord, under section 106, an appeal is preferred before the deputy joint registrar of Cooperative Society. Against which, my lord, this is the
correct. It has to be cooperative societies, not service matter. Anyway, even otherwise, it will come before this court only.
Yes.
Office is directed to correct the classification as
CS.
Cooperative societies, CS, bracketly. Yes.
CS ಅಂತ ಹಾಕಿದಾರಲ್ಲಿ ಲಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ನೀವು ಎಸ್ ಅಂತ ಹಾಕಿದ್ರ ಅದಕ್ಕೆ ಹಂಗಾರೆ learned counsel for the petitioner is directed to correct ಅಂತ.
Yes, right.
Yes.
My lord. The petitioner, my lord, who is a cooperative development officer, working in the state government. My lord, was working during that current period, my lord, that period between 2015 to 20 at HD Hegdevan Kote Taluk. But every taluk would have one taluk development officers. Would the societies of the entire taluk, my lord, comes under their control. Then, my lord, actually, initially, my lord, she was appointed as a stenographer. Understand? She belongs to my lord scheduled caste community. She was appointed as a stenographer, and then my lord, she acquired qualification. Then, my lord, she was promoted, my lord, as a CDO, and she was posted there. My lord, there is absolutely not even a single, my lord, anything, my lord, against her, my lord, in service records. Then, my lord, all of a sudden, during 2019, my lord, it appears there is a complaint lodged by one of the members of the primary credit cooperative society of Antarasante. It's a place, saying that, Lord, there is a scheme by the state government, loan waiver scheme of 2017. Lord, up to 50,000 rupees, my lord, the scheme was announced by the state government to pay the loans for these farmers. In that particular society, my lord, in this particular society, it appears there is a lot of misappropriation, and the complaint was lodged on the ground that one loan has been given 2 to 3 times to the same person, same farmer, and the management and the office bearers of the society has misappropriated the amount. Then, my lord, complaint was lodged. Based on the complaint, my lord, an inquiry officer was appointed. My lord, respondent number 4 was appointed as an inquiry officer to look into that. Then, my lord, he has inquired into and found that the manager and CEO, manager and board of directors, they are all responsible for this, because it's at that stage only, my lord, giving an application, taking an application, and loan disbursement, and one taluk supervisor also, my lord, who who comes under the DCC Bank of Taluka, who is responsible for that. Then, my lord, during the course of inquiry, they have inquired the CDO also, my lord. My lord, the CDO's duty is, my lord, after the sanctioning and everything has been done, my lord, he has to only say yes, my lord. That's all. She cannot, my lord, personally, my lord, physically impossible to, my lord, see each and every receipt, bills, applications, everything for all these 16 societies, my lord. That is what they say. You should have done that. Without doing that, you have, my lord, this is your dereliction of duty. Because of that, you are also responsible.
Yes.
Then what happened? During the pendency, my lord, the entire amount, about 76 lakhs rupees, my lord, has been paid by the society. That's Siddhagowda, my lord, who claims to have misappropriated the amount. He has paid the amount to the government. With the interest, he has paid the amount. Then, in spite of that, my lord, of course, my lord, I have nothing to do with that. He has paid the amount, he has misappropriated, he has accepted and paid the amount. Then, in spite of that, my lord, based on the report, my lord, the assistant registrar has issued a direction to, my lord, hold an inquiry, disciplinary proceedings, my lord, against me, my lord. Which, my lord, I challenged before the, my lord, in an appeal under section 106, saying that I have no role, and he has misappropriated, he has paid the amount, and at this stage, I am not at all responsible. My lord, that appeal, my lord, came to be dismissed without, my lord, assigning any reasons at all, my lord. Against which, my lord, I have this petition, my lord. Now, my lord, she's my lord, she's in the verge of, my lord, the promotion. This, my lord, it should not come in the way, my lord. My submission is, the other submission is, the person who has passed an order, my lord, has no authority or no jurisdiction, because, my lord, he had now qualification to hold that post, the inquiry officer. That also, my lord, I have raised the ground. My submission is, my lord, there is absolutely no my lord, allegations against me, and it has not been proved against me. Jointly, my lord, they have included my name also. My submission is, my lord, is 68 order, my lord, direction, my lord, annexure E. Kindly be stayed, my lord. 134, my lord. It's a direction. But 106 farmers, my lord, this 2 to 3 times, my lord, loan has been given. And the first column, my lord, is the findings of the inquiry officer. The second, my lord, the next is the direction, the 68.
Annexure E.
Annexure E. Really. Page number 136 ಅಲ್ಲಿ ಆದೇಶ ಇದೆ 6/10/2020 ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಭರತ್ ಕುಮಾರ್ ಎಚ್ ಪಿ ಸೋನ್ಸೋ ಅವರು ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 59 ಪ್ರಕರಣ 62 ದತ್ತವಾಗಿರುವ ಅಧಿಕಾರದಂತೆ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಅಂತರ ಸಂತೆ ಎಚ್.ಡಿ. ತಾಲೂಕು ಇದರಲ್ಲಿ ನಡೆದಿರುವ ವ್ಯವಹಾರಗಳ ಕುರಿತು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 59 ಪ್ರಕರಣ 64ರ ರೀತಿಯ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಿ ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಸಹಕಾರ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಕೆ.ಆರ್. ತಾಲೂಕು ಇವರು ಸಲ್ಲಿಸಿರುವ ಪ್ರಕರಣ 64ರ ವಿಚಾರಣಾ ವರದಿಯಲ್ಲಿ ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಆರೋಪವಾರು ಅಭಿಪ್ರಾಯಪಡಿಸಿರುವಂತೆ ಸಂಬಂಧಿಸಿದ ಅಧಿಕಾರಿ ನೌಕರರ ಸಿಬ್ಬಂದಿ ನೌಕರರ ವಿರುದ್ಧ ಸೂಕ್ತ ಜವಾಬ್ದಾರಿಗಳನ್ನು ನಿಗದಿಪಡಿಸಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಹಾಗೂ ನ್ಯೂನತೆ ಅಥವಾ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಸರಿಪಡಿಸಿಕೊಂಡು ಈ ಆದೇಶ ದಿನಾಂಕ 30 ದಿನಗಳ ಒಳಗಾಗಿ ಅನುಪಾಲನಾ ವರದಿಯನ್ನು ಆದೇಶ ಹೊರಡಿಸಿದ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವಂತೆ ಈ ಕೆಳಗಂಡ ನಿರ್ದೇಶನ ನೀಡಿದೆ. ದಿಸ್ ಇಸ್ ದ ಸೂಚನೆ ಅಂಡ್ ಡೈರೆಕ್ಷನ್ಸ್. ದ ಲಾಸ್ಟ್, ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ ನಂಬರ್ 140, ಮೈ ಲಾರ್ಡ್. ಬಡ್ಡಿ ಸಹಾಯ ಧನ ಬಿಲ್ಲನ್ನು 100% ಕರಾರುವಕ್ಕಾಗಿ ಪರಿಶೀಲಿಸಿ ದೃಢೀಕರಿಸುವಲ್ಲಿ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿ 3 ಲಕ್ಷ ಮೇಲ್ಪಟ್ಟು ಸಾಲ ಪಡೆದ ಅನರ್ಹ ಸದಸ್ಯರಿಗೆ ಬಡ್ಡಿ ಕ್ಲೈಮ್ ಜವಾಬ್ದಾರರಾಗಿರುವ ಶ್ರೀಮತಿ ಅನಸೂಯ ಸಹಕಾರ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಎಚ್.ಡಿ. ತಾಲೂಕು ಇವರ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮ ಹೊಡೆಯಲು ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘ ಸೋನ್ಸೋ ಮೈಸೂರು ಅವರಿಗೆ ಮುಖಾಂತರ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದ್ದು. ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್, ಮೈ ಲಾರ್ಡ್, ಇನ್ ದ ಪ್ರೀವಿಯಸ್ paragraph, my lord, may kindly be seen. This is the petitioner, Srimati Anasuya. Previous paragraph, I kindly be seen, not in 3 ಅಲ್ಲಿ, but same thing. ಬಡ್ಡಿ ಸಹಾಯಧನ 100% ಕರಾರುವಕ್ಕಾಗಿ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿ 3 ಲಕ್ಷ ಮೇಲ್ಪಟ್ಟು ಸಾಲ ಪಡೆದ ಅನರ್ಹ ಸದಸ್ಯರುಗಳ ಬಡ್ಡಿ ಕ್ಲೈಮ್ ಜವಾಬ್ದಾರರಾಗಿರುವ ಜಿಲ್ಲಾ ಸಹಕಾರ ಕೇಂದ್ರ ಬ್ಯಾಂಕಿನ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಯಾದ ಚಂದ್ರ, ಹಿರಿಯ ಸಹಾಯಕರು ಮೈಸೂರು ಬ್ಯಾಂಕ್ ಚಾಮರಾಜ ರಮಾಪುರ ಶಾಖೆ ಕೆ. ನಾಗರಾಜು, ಹಿರಿಯ ವ್ಯವಸ್ಥಾಪಕರು ಹಾಗೂ ಇವರುಗಳ ವಿರುದ್ಧ ಬ್ಯಾಂಕಿನ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಮತ್ತು ಆಡಳಿತ ಮಂಡಳಿ ಶಿಸ್ತು ವಹಿಸುವುದು. Then, my lord, this has not been done. They have not taken any action against them. Even in the previous, my lord, para 2 ನಲ್ಲಿ ಅದರಲ್ಲಿ 2ರಲ್ಲಿ ಸಿದ್ದೇಗೌಡ, my lord, who is responsible. Lord, it says, 3 ಲಕ್ಷ ಮೇಲ್ಪಟ್ಟು ಸಾಲ ಪಡೆದ ಅನರ್ಹ ಬಡ್ಡಿದರ ಕ್ಲೈಮ್ಗೆ ಜವಾಬ್ದಾರರಾಗಿರುವ ಸಂಘದ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಶ್ರೀ ಸಿದ್ದೇಗೌಡ ವಿರುದ್ಧ ಸಂಘದ ಅಧಿಕಾರ ಮಂಡಳಿ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವುದು. Nobody, no action has been taken against anybody. Even the person has accepted and paid the amount, my lord. Only against me, my lord, this, my lord, direction has been. They have not taken any action in spite of these directions, my lord. Now, my lord, the department, my lord, is even the writ appeal, my lord. Sorry, my lord. Even in the appeal under section 106, the learned my lord, joint registrar, my lord, says that annexure H, my lord, they say they have paid the amount. ಹಾಗಾಗಿ ಮಾಡಿಲ್ಲ. So you are not proved your case. This is what, my lord, this findings. That is at annexure H, my lord. Page 154, my lord, the third paragraph. ಮೇಲ್ಮನೆಯವರ ಪರ ವಕೀಲರು ಲಿಖಿತ ಮತ್ತು ಮೌಖಿಕ ವಾದವನ್ನು ಮಂಡಿಸಿರುತ್ತಾರೆ. That's my lord, it says. ಎರಡನೇ ಎದುರುದಾರರ ಸಹಕಾರ ಸಂಘಗಳ ರತ್ನಾಕರ ವಿಚಾರಣೆಯಲ್ಲಿ 2017 ಪ್ರಾಥಮಿಕ ಸೌಂಡ್ಸ್ ಸಾಲ ಮನ್ನಾ ಯೋಜನೆಯಲ್ಲಿ ಆಗಿರುವ ವ್ಯವಹಾರಗಳನ್ನು ಕುರಿತು ವಿಚಾರಣೆ ನಡೆಸಿ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಸಲ್ಲಿಸಿದ್ದು, ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಸಹಕಾರ ಸಂಘ ಪ್ರಕರಣ 68 ಆದೇಶ ಹೊರಡಿಸಿದ್ದು, ಸೌಂಡ್ಸ್ ಸುತ್ತುವರಿಯಲ್ಲಿ ಸಾಲ ಮನ್ನಾದ ಬಿಲ್ಗಳು 100% ಸಹಕಾರ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಪರಿಶೀಲನೆಗೆ ಸೂಚನೆ ಇದ್ದಾಗಲೂ ಸಹಿತ ಸರಿಯಾಗಿ ಪರಿಶೀಲನೆ ಮಾಡದೇನು ಮೇಲ್ಮನೆಯ ಕರ್ತವ್ಯ ರೂಪವಾಗಿರುತ್ತದೆ. ಈ ಕಾರಣದಿಂದ ಸಾಬೀತಾಗಿ 2 ಆರೋಪಗಳು ಮೇಲ್ಮನೆಯವರು ಸಹ ಮೇಲ್ಮನೆಯಾದರೂ ಸಹ ಜವಾಬ್ದಾರರು ಎಂದು ಇವರ ವಿರುದ್ಧ ಸೂಕ್ತ ಶಿಸ್ತು ವಹಿಸಲು ನಿರ್ಬಂಧಕರಿಗೆ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧನ ಮೂಲಕ ಪ್ರಸ್ತಾವ ಸಲ್ಲಿಸಲು ಆದೇಶವಾಗಿ ಈಗಾಗಲೇ ಸಂಘದ ಮುಖ್ಯ ನಿರ್ವಹಣಾಧಿಕಾರಿಯಾಗಿ ಕಲಂ 68 ಆದೇಶದ ವಿರುದ್ಧ ವಸೂಲಾತಿ ಇಟ್ಟಿರುವ ಮೊತ್ತದಲ್ಲಿ ವಿಚಾರಣೆ ಪೂರ್ವ ಭಾಗಶಃ ಹಣವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಪಾವತಿಸಿ ಅನುಪಾಲನಾ ವರದಿಯನ್ನು ಸಕ್ಷಮ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಅನುಪಾಲನಾ ವರದಿಯಲ್ಲಿ
AG takes notice for response number 1 to 3. ಇವರೇನಕ್ಕೆ fourth respondent?
Our inquiry officer. He has held an inquiry. He had no power.
He is also cooperative development.
The cooperative development officer ಮಾಡಿದ್ದಾರೆ. He has no power on the jurisdiction blood contention I have taken. Same caterer.
But how can you make him a party by name? He is only appointed as an inquiry officer. He will conduct the inquiry. How can there is no allegation against him? Why do you make him a party by name? You can delete it.
Yes,
at the oral request of the learned counsel for petitioner, the fourth respondent is permitted to be deleted from the array of respondents. Learned counsel for the petitioner is directed to carry out the amendment in the cost rate and furnish an amended cost title within a period of 1 week from today. Copies of the writ petition shall be served on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that even as per the inquiry report, submitted in terms of section 64 of the Karnataka Cooperative Societies Act, at annexure D, it is clear that there is no allegation of misappropriation against the petitioner. Stop. The transactions have taken place before a primary cooperative society. Primary na enadu? Primary cooperative society. Primary credit cooperative society. And the staff and chief executive officer of the society are held guilty of misappropriation. Stop. On the other hand, disciplinary proceedings are directed to be initiated against the petitioner only on the ground that she should have scrutinized the applications.
All the records, 100% verification has not been done. Application or receipts or vouchers, everything, my lord, it's physically impossible, my lord. Only impossible.
Scrutinized the documents.
For any officer to do that.
Being the cooperative development
officer of the taluk.
Of the taluk. Stop. It is submitted that there are about 16 societies in the taluks, and at the taluk level, the petitioner used to receive the information from the societies and she has countersigned the documents forwarded by the societies. Stop. That being the case, the petitioner preferred an appeal under section 106 of the Act before the
second respondent.
Second respondent, Deputy Director, Deputy Registrar of Cooperative Societies, challenging the initiation of disciplinary proceedings against the petitioner. Stop. Learned Council submits that although the DRCS has given a finding that the Chief Executive Officer and the other staff of the society
and the supervisor, my lord, the supervisor, taluk supervisor, who is from Taluka DCC Bank. There are two circles. One Mr. Chandra, my lord, he is also
are held guilty of misappropriation, and no such allegation is made against the petitioner. Nevertheless, the DRCS has proceeded to dismiss the appeal without application of mind. Stop. Learned Council would further submit that the petitioner is due for promotion, and at this stage, only on the basis of the inquiry contemplated against the petitioner, she would lose an opportunity of promotion. Full stop. Next para. There shall be an identity order of stay of the operation and execution of the impugned order dated 6/10/2020 at Annexure E, until further orders, and to enable the petitioner for consideration of promotion. Stop. Yes. In the meanwhile, office objection should be compared.
Yes,
Lordship may kindly take up with the next week, my lord, I shall compare the argument.
A week's time is granted at the request of learned counsel for petitioner for compliance of office objection.
Lord, serial number 22, my lord.
Yes.
Lord, during the course of the day, Lord, I'll file the amended cost title, Lord. There was direction to amend, file the amended cost title. I'll file it during the course of the day, Lord.
For the pleading application is concerned, the Lordship may permit me to withdraw because I wanted to bring the husband, the brother of the deceased on record. The husband is there, I think that will be suffice. That LR application be allowed.
1 of 2022.
Yes. The brother, I wanted to bring the brother on record so that they will get the benefit of the money.
Who has filed the application?
The brother of the deceased has an pleading application.
Applicant.
Yes.
Lord, the sixth
If
response
they have
is,
serious objection,
I have already brought the husband of the deceased on record, my lord.
the school authorities may have. I am also appearing for the management. They have no objection. What happens is this, my lord, the
Learned counsel for respond number 2. Vijay Kumar submits that
he may permit it.
he has filed IA number 1 of 2022 on behalf of the applicant therein to bring himself on record.
In addition to the LR,
In addition to the legal representatives of deceased respond number 2. Full stop. However, since there were objections raised in this regard, learned counsel submits that the application may be permitted to be withdrawn as not present. Full stop. Ordered accordingly. Yes. Next para. Each time is further granted at the request of the learned counsel for petitioner to carry out the amendment.
I have already carried.
To furnish amended cost title.
Yes, ma'am.
In terms of order dated 2-3 na?
Yes, sir. 2nd of March.
2-3-2020.
matter is quite short. What has happened is she was appointed as
early next week. If you want, I'll give a date.
My lord, sir, I request my lords to kindly fix a date because my lords, only reason is my lords, now the respondent institution, my lords are permitting to take back the petitioner to the said post, my lord. My lords, I may be permitted to, my lords may fix a date.
Release this matter on 7th of April.
Obliged.
7th.
Grateful.
Pertains to the appointment of Anganwadi worker.
Yeah, for posting.
Respond number 4, my lord. I'm in receipt of some relevant documents regarding respond number 4, my lord. I'm yet to submit it to the honorable court. Kindly allow me a week's time.
It's of the year 2018.
You have filed objections?
No, they have not filed.
Why? 2018 matter.
2018 matter. Working, my lord, from this. Appointment is called.
We can't wait any further, sir.
Kindly 1 week's time.
Although
We'll furnish all those documents to the honorable court, my lord.
so this matter is of the year 2018 and till now objections are not filed on behalf of the fourth respondent. Stop. Learned counsel for the fourth respondent seeks for a short accommodation to file objections. Full stop. With great reluctance, finally a week's time is granted to the fourth respondent to file objections. Full stop. Release this matter for final hearing. Immediately after, statement of objections are filed at the hands of the fourth respondent.
Date 26, my lord. The reason is this.
No,
She is working, my lord.
the interim order of status.
Yes.
Matter have to come for B group. The previous matter has to come up for the B group. Hearing and
a final hearing on that. Yes. Yes.
Kindly pass on. Pass on.
Yeah.
Displace ಇದು ಬಿಟ್ಟು ಬಂದಿದ್ದೇನೆ ಮತ್ತೆ ಮೇಲೆ 230.
230.
Field cover which is the cause list shows that there is a field cover from the registrar judicial. Correction.
What do you know? ಹಳೇದು ಅದು 2021. All right, 230.
230 I have been application for posting. ಇನ್ನು ಸ್ಟಡಿ ಮಾಡಿ ತಂದು ಸ್ಟಡಿ ಮಾಡಿದ್ರೆ ಟುಮಾರೋ ಇಟ್ ಇಸ್ ರೆಡಿ.
ಮತ್ತೆ ನಾಳೆ ರೀಚ್ ಆಗ್ಲಿ ಅಲ್ಲಲ್ಲ, ನಾಳೆ ರೀಚ್ ಆಗಿದ್ರೆ ಬೇಜಾರು ಮಾಡ್ಕೋತೀರಾ. ನಾನು ಏನ್ ಮಾಡ್ಲಿ? ರೀಚ್ ಆದಾಗ ನೀವು,
ಇದು ಏನಾಗಿದೆ ಸರ್,
ನಾನು ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ, ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ರೀಚ್ ಆಗದೆ ಇದ್ದಾಗ ನೀವು ಇಲ್ಲಿ ಬಂದು ನಿಂತ್ಕೊಂಡು ಗಲಾಟೆ ಮಾಡ್ತೀರಾ. ರೀಚ್ ಆದಾಗ ಈ ತರ ಪ್ರಾಬ್ಲಮ್ ಹೇಳ್ತೀರಾ, ನಾವೇನ್ ಮಾಡೋದು?
ನನ್ನ ಹೆಸರನ್ನು ಏನ್ ಮಾಡ್ಬೇಕು, ಅಲ್ಲಿ ಫೀಡ್ ಆಗುವಾಗ ಮೋಹನ್ ಚಂದ್ರ ಅಂತ ಕೆಲವು ಬರೀತಾರೆ, ಮೋಹನ್ ಚಂದ್ರ ಅಂತ ಬರೀತಾರೆ. ಹಾಗೆ ನಾನು ಮೋಹನ್ ಚಂದ್ರ ಅಂತ ಇದ್ದಾಗ ನೋಡುವಾಗ ನಂದು ಇವತ್ತು ಬಂದ ಗೊತ್ತಾಗಿಲ್ಲ, ನನಗೆ ಬಂದದ್ದು ಇವತ್ತು ಲಿಸ್ಟ್. ಹಾಗೆ ಕೈಂಡ್ ಹ್ಯಾವ್ ಟು ಟುಮಾರೋ.
ನಾಳೆ ಆಗುದಾ? ಆಯ್ತು. At the request of the petitioner party in person, release this matter tomorrow.
Friday, group B employs the second respondent. Petitioner appointed as group B employee
for posting.
Actually, one of the petitioners is already retired, sir, and other petitioner number one is supposed to be retired.
Yeah, for regularization, na? For regularization.
Some of the persons who are working, who are juniors to the petitioners, who are also appointed and regularized their service.
Does it stand covered by earlier decisions?
Now Uma Devi's case, now the impugned endorsement is issued.
Allah, if the other persons are regularized,
yes,
It must be by virtue of orders passed by this court.
Yes.
Where is that order?
I produced my annexure C, D, and E. Annexure B is the first order at page number 19. And subsequently, annexure C at page number 25. Is of 2000, 4th April 2000. Pursuant to these orders, and subsequently there are two judgments, my lord, which I have not produced. I have the copy.
Who's appearing for this other respondent?
This is Asha.
Asha.
The statement of objection also.
Why your case was not considered with the others?
We have continued the service pursuant to the order of the honorable court.
Which is that order?
Endorsement, Uma Devi's case.
No. Which is the order which gave you that benefit? Annexure B na? Huh? What is it?
It was only restricted for 6 months. Last paragraph 5. That view of the matter, without expressing any opinion on the merits of the and demerits of the petitioner's case, these writ petitions are disposed of, reserving liberty to the petitioners to make appropriate representations before the respondent authority within 2 months from today, requesting for them to regularize their services in their post of held by them and not to implement the government order dated so and so. Further, a direction is also issued to the respondent not to terminate the petitioners from service of the second respondent board till they consider and dispose of the representation made by the petitioner in the facts and circumstances of the case. What is so and so. So within 6 months they were supposed to consider the request. So after 6 months, this benefit was not extended to us.
Till the 6 months.
Till the disposal of them.
Till they consider and dispose of the representation made
by the petitioner. In the facts and circumstances of the case.
6 months until it. Representations within 2 months from the date.
From the date of requesting them to regularize their services in the post held by them and not to implement the government order dated 6/8/2019. Further, a direction is also issued to the respondent not to terminate the petitioner from the service of the second respondent till they consider and dispose of the representation.
Now order is passed from the date. And as per annexure A and B, B and C, there is a direction Even this honorable court has held, my lord, if they are not eligible for the post they were holding, even they are entitled for continue in the lower post.
How's sir? But what will you say about this continuation of your services by virtue of an order of this court?
That is also, my lord, within 2 months. My
2 months you have to give representation.
Yes.
And you will not be terminated till your representation is considered.
Taken up on Tuesday, my lord.
You have to come thoroughly prepared, sir. These are not simple matters.
Please.
You cannot dispose of these matters just like that.
Tuesday.
You will have to make a lot of research.
Please.
By plain reading, it will go directly against you. But you'll have to find out other orders, directions, or decisions. What is the purport of that order contained in paragraph number 53 in Umadevi's case? If you have already put in more than 10 years, even before this order was passed, and thereafter they are directed you to be continued in this one till the representation is considered. That doesn't mean you are continued to serve for 10 years. That 10 years has already elapsed. So you will have to.
Please, I will work on that.
Yes.
Tuesday.
Matter is called out. There is no representation for respondent number 2. Release this matter on 7th of April.
Please.
I appear for the petitioners, my lord. Serial number 26, my lord.
Yes, I have for posting.
Yeah, my lord, here the reason, my lord, what are petitioners who are research students have challenged the withdrawal of fellowship, my lord. Demand for a refund has been made at Annexure R, page 43, my lord. In this, the University Grants Commission has to file statement of objections, my lord. In the meantime, for stay of refund, my lord, amount is also not retrospectively. They have sought for refund, my lord. Annexure R, page 43, my lord.
Next week, my lord. Hello, but though this is issued on 3/7/2019, they have not done anything further, is it?
No, my lord, they are repeatedly demanding the money, my lord. So,
but they have not acted upon it.
They are continuing to.
It's only 2,525.
My lord, some of them and they've also asked for the
Kashinath Illela 17,864.
In fact, the university has
file madilva ನೀವು ಮಾಡಿದ್ದೀರಾ
the UGC has to file objections, my lord. It is the UGC grant which has been given to the university, my lord, which has to be in turn paid to the students. Now that amount has been paid and later they are asking for refund. In fact, in addition to this amount, my lord, they have to pay further amounts, but they have not done so, my lord. They are in the meantime asking for refund of this amount.
So that amount had to come from UGC.
Actually, UGC the mistake, my lord. Yes, for the UGC circulars and all, they are not entitled for that amount. The UGC is same, my lord. UGC appears.
838 inform that the University Grants Commission has to ask the project fellows and research associates working on the LP programs to be paid revised fellowship from 1/2008 as per public notification issued by Secretary UGC. The revised fellowship may be paid from UPE for CPEPA allocation already approved to the university plus interest earned on the UGC grant. It is already given to the university. Further, there is nothing to be paid from the UGC to the university. It will please be noted that no additional grant will be released by the UGC for revised enhancement of the project. And has been made, it is with the university. If anything has to be done, it is for the university to do.
ಈ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ. Produced document annexure R3 along with the objections. UGC only. Based on the complaints, 23rd September 2018. Please refer to a letter date so and so. Forwarding hearing the representation received with the project fellows and research associates UPE project, University of Mysore, Vignana Bhavan, Manasundar, so and so, requesting therein to clarify the order of enhancement and research of emoluments to UPE research candidates. In this regard, I am directed to inform you that UGC has not made any revision of fellowship or scholarship amount to the project fellows or research associates under the scheme of UPE CPEA. The public notice for enhancement of the fellows issued with the approval of the commission for specific schemes, and the same cannot be extended to other schemes, that is UPE and CPEA. Your UPE scheme only wrote. Your parak barodilla. They themselves have clarified. UGC.
My lord, your lordship may see annexure N, my lord, for a minute, page 39. This is an office order, my lord, issued by the University of Mysore, dated 3/9/2018. Here they say, as per UGC order and public notice of UGC, the fellowship is enhanced. The university has sanctioned us to enhance the fellowship as per UGC. Below mentioned chart shows past and present fellowship details of UPE projects, resource associate, and project fellows. All the required documents are attached with the arrears of bills. Research associates and project fellows, my lord, they have been sanctioned. This additional funds, my lord, and the fellowship has been enhanced. That is from 3/9/2018. So it is for the UGC to say whether, my lord, that the petitioners come within the scheme or not. They have to
but they have clarified that it does not apply to UPE and CPEP.
My lord, they have to say it, my lord, by way of objections. They have to point out before this honorable court if we are eligible or not, my lord, and retrospectively they can't take a refund of the fellowship which has already been paid. A benefit which has been extended to the petitioners cannot be withdrawn, my lord. And no reasons also have been assigned in the order, my lord. No doubt in the statement of objections, they give some reason saying that it has not been sanctioned under the scheme. But annexure R, page 43, no reasons are assigned.
Reconsideration ಅಂದ್ರೆ ಮತ್ತೆ ಇನ್ನೊಂದು ಸಲ ಪಾಸ್ ಮಾಡ್ತೀವಿ. Is making submission. It is not a considered order. They wanted an order, my lord. We refer all these circulars and the UGC notification, and we will pass an order. Detailed order giving assigning reasons why they are not entitled.
Recovery of only about 17,000.
70 in respect of one candidate, my lord, and in addition to that,
the others are even less.
Yes, my lord. I'm not saying that the amount are more. It is first relief, my lord, is for quashing of that order, my lord, annexure R. The second relief what is sought for is issue of writ in the nature of a mandamus or any other appropriate writ or order directing the respondents to pay arrears of fellowships claimed by the petitioners as per order dated 3/9/2018 passed by the respondent at annexure N, my lord. As per annexure N, they themselves have sanctioned the amount. Later on, they cannot withdraw the amount, is my humble submission, my lord. At any rate, it is for the UGC to say whether we are entitled for the amount or not, my lord. In the meantime, I am only requesting that the amount of refund be stayed, my lord.
The respondent, the second respondent, UGC, is directed to file objections within a period of 2 weeks from today. Stop. In the meanwhile, no precipitative action shall be taken for recovery of the excess amount said to have been paid to the petitioner. Yes, sir.
Yes, much obliged.
ಆಯ್ತು ಕೊಡ್ರಿ ಇವಾಗ ಏನ್ ಮಾಡಕ್ counsel for the petitioner is directed to serve a copy of the writ petition on learned counsel for respondent number 4. 2 weeks are granted to respondent number 4 to file statement of objections. Objections ಹಾಕಿಲ್ಲ ಇನ್ನು ಅದೇನ್ರಿ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅಂತಾರೆ. Yes.
This case pertains to granting aid not the post of Group D laboratory attendant. But the government has filed its objections not last week. Copy is served on me. And I just my week's time to file my.
A week's time is granted at the request of learned counsel for petitioner to file a rejoinder.
Yes.
To the statement of objections filed by the respondent state.
I also seek for a date, 7th or any date.
Baaki sir, no. 2021 matter. Yes.
Challenge the suspension order, my lord. Suspension order.
29. 29.
Petitioner in this case. Challenge the suspension order as per the annexure F. The suspension order passed on 15/5/2021. My
lord, may make submission. I appeal for the respondent. I am going to file statement of objections. 2 weeks time may be granted.
Covered by decision as
covered.
Jay Kumar Chaudhary case alli. Within 3 months ಆದ್ಮೇಲೆ extend ಮಾಡಬಾರದು. Extension ಮಾಡಿಲ್ಲ ಸರ್. Until further orders ಅಂತ ಮಾತ್ರ ಮಾಡೋದು.
You are working as what?
Bill corrector ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ ಸ್ವಾಮಿ. ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಸರ್ವಿಸ್ ಇಂದ. ಅದಾದ್ಮೇಲೆ ನಾನು ಹೈಕೋರ್ಟ್ ಅಪೀಲ್ ಆಯಿತು. ರಿಟ್ ಪಿಟಿಷನ್ ಆಯಿತು. ಅದು ಅಲೋ ಮಾಡಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು. As per the order dated 30/11/2022. Annexure A1 A1.
Page number?
Page number 14. Page number 18 and last paragraph, 6th paragraph. Writ petition is allowed. The matter is remitted back to the hands of the respondent to hold a regular departmental inquiry and afford the petitioner reasonable opportunity to defend the defense and then take appropriate action in accordance with law within 6 months from the date of receipt of the copy of order. As a consequence of the court's prayer and petition shall reinstate to service the order. ಅದ್ರ ಮೇಲೆ ನಾನು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ತೀನಿ 24/12/2020. But the respondent number 3 passed an order 29/1/2021 ಮಾಡ್ತಾರೆ ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ. ಬಟ್ ಆರ್ಡರ್ ನಾನು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡೋದು 11/5 ನಾನು 13/5 ನನಗೆ ಸರ್ವ್ ಆಗ್ತದೆ ಥ್ರೂ RPI. ನಾನು 15/5 ಹೋಗ್ತೀನಿ. ಅಲ್ಲಿ ಹೋದಾಗ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಇಲ್ಲ ನಿಮ್ಗೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಪೆಂಡಿಂಗ್ ಇಟ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಸಸ್ಪೆಂಡ್ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ.
How can you do it, sir? Objections file ಮಾಡದಲ್ಲ. If there is a specific direction by a court that he shall be reinstated.
Opportunity was given.
An opportunity.
I will file an objection, maybe called.
There is a clear direction by the court
My lord,
that the
it
petitioner
was-
shall be reinstated into service.
My lord,
If you are not happy with that order, you should have challenged it. Without challenging it, you can't pass this kind of an order, sir. It would amount to contempt.
My lord, I will make one submission. Opportunity may be given. I will file objection.
ಏನ್ objection file ಮಾಡ್ತೀರಾ sir?
ಅಲ್ಲ, ನಾನು ಹೇಳಿದೆ, because I will submit the facts. my
Is
lord.
it not a
As it-
on the
he made
face of it?
submission.
Is it not contempt?
Please, my lord, he made the submission that it was served in the month of May. Immediately on the very next day, he
ಏನು?
was terminated from the service. I will bring the real facts before this song. I want a small opportunity maybe. Please, my lord. That is my humble request.
ಪೇಜ್ ನಂಬರ್ 36 ಅಲ್ಲಿ
ಅಂದ್ರೆ because
ಕವರ್
I-
ಕೂಡ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
My lord,
ನಾನು ಯಾವಾಗ ಶುರು ಆಗಿದೆ ನಾನು
Which is the impugned order?
ಇಂಪ್ಯೂಸ್ಡ್ ಆರ್ಡರ್ ಇಸ್ annexure F my lord.
Page number.
ಪೇಜ್ ನಂಬರ್ 27.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲೆ ಚಿಕ್ಕಘಟ್ಟ ತಾಲೂಕು ಸಾದಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಸಾದಲಿ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಎಸ್ ಟಿ ಸತೀಶ್ ಬಿನ್ ತ್ಯಾಗರಾಜು ಅವರ ನೀವು ಸಾದಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಕರ ವಸೂಲಿಗಾರನಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿಮ್ಮನ್ನು ವಜಾ ಮಾಡಿರುವುದು ಪುರಸ್ಕರಿಸಿದ್ದು ಈ ಬಗ್ಗೆ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಾವೆ ಹೂಡಿದ್ದು ಅದರ ಆದೇಶದಂತೆ ನಿಮ್ಮನ್ನು ಪುನರ್ ಆಯ್ಕೆ ಮಾಡಿ ಆದೇಶ ನೀಡಿರುವುದು ಸರಿಯಷ್ಟೇ. ಸದರಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ನಿಮ್ಮ ದೋಷಾರೋಪದ ಬಗ್ಗೆ ತನಿಖೆ ನಡೆಸಲು ಸೂಚಿಸಿದ್ದು ಆಡಳಿತಾಧಿಕಾರಿಗಳು ಆದೇಶದಂತೆ ನಿಮ್ಮ ವಿರುದ್ಧ ಕೆಳಕಂಡ ದೋಷಾರೋಪಗಳು ಇರುವುದರಿಂದ ನಿಷ್ಪಕ್ಷವಾದ ತನಿಖೆ ನಡೆಸಲು ನಿಮ್ಮನ್ನು ತನಿಖೆ ಮುಗಿಯುವವರೆಗೂ ಅಮಾನತಿನಲ್ಲಿ ಇರಿಸಲಾಗಿದೆ ಅಂತ ಕೊಡ್ತಾರೆ. ಇದಾದ್ಮೇಲೆ ನಾನು ಚಾರ್ಜ್ ಮೆಮೊ ಕೂಡ ಇಶ್ಯೂ ಮಾಡೋದಿಲ್ಲ ಸುಮ್ಮನೆ. ದಿಸ್ ಇಸ್ ಪಾಸ್ ಇನ್ 15/5/2021. ಅದೇನು ಇಲ್ಲ, ಏನು ಬರ್ತಾ ಇಲ್ಲ ಸರ್. ಅದರಿಂದ ನಾನು ಮೆಮೊ ಪೋಸ್ಟಿಂಗ್ ಹಾಕಿ
ಬರ್ಕೊಳ್ಳಿ. The petitioner was earlier before this court in WP number 47875 of 2018, challenging the resolution passed by the respondent Gram Panchayat, removing him from service, invoking section 113(3) of the Karnataka Gram Swaraj and Panchayat Raj Act, 1993. Full stop. This court, by order dated 30th of November 2020, allowed the repetition and remitted back the matter to the respondent Gram Panchayat to hold a regular departmental inquiry and afford the petitioner reasonable opportunity of defense and then take appropriate action in accordance with law within 6 months from the date of receipt of copy of the order as a consequence of the aforesaid prayer. And further, the respondent Gram Panchayat was directed to reinstate the petitioner into service. Full stop. Thereafter, the impugned order the page number
27.
dated 15/5/2021 is passed, stating that the petitioner will be kept under suspension till completion of the inquiry. Stop. Next para. On the face of it, it is clear that the impugned order borders on contempt of the orders passed by this court. Stop. Nevertheless, at the request of the learned counsel for the second respondent, second and third respondent, Gram Panchayat, a week's time is granted to file objections. Full stop. Next para. Please this matter on 7th of April 2020.
Pleasure.
by the petitioner. In this manner, the petitioner is the regular holder of the executive engineer in KPTCL manner. As per rules of the KADB manner, sir, executive engineers of the KPTCL are only entitled to be posted against the post malad in KADB manner. Whereas the respondent malad is in the cadre of assistant executive engineer.
Yeah, what are you doing, sir? You are arguing the matter, is it? Huh? ನೀವು ಹಿಂಗ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಈ ಹಳೆ ಮ್ಯಾಟರ್ಗಳು ಯಾವಾಗ ತಗೊಳ್ಳೋದು ಮತ್ತೆ ನಾವು?
It is regarding repatriation.
ಆಯ್ತು.
And the term is going to end by May of.
ಎಲ್ಲಾರ್ದು ಅರ್ಜೆಂಟ್ ತಾನೆ. ಇಂದು 2021 ಮ್ಯಾಟರ್ ಸರ್. ಪ್ಲೀಸ್ ಸಿ ದಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ಯಾವ ವರ್ಷದ್ದು ಅಂತ ನೋಡಿ ಸ್ವಲ್ಪ.
The term is going to end on 15/5/2022.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಸರ್? Yes.
Reputation. Now he's already repatriated, he's got a posting of his choice. So my lord, my submission to your lordship is that nothing may survive for consideration after May 15th.
May 15th?
Of 2022. It's a time-bound deputation, and that is coming to an end.
And what is the prayer in this petition?
Prayer D.
Prayer D. Modified repatriation minutes. The fifth respondent is not entitled to continue in the post minutes because he is in the cadre of assistant executive engineer minutes. He is under 132 only minutes.
Prayer D.
The fifth respondent was also repatriated to his parent without there being any posting orders minutes. He has been continued minutes. That is a modified. Therefore, we are reporting lordship's minutes. On request only minutes because there was no stay order minutes. On request minutes, I was posted to a different posting minutes in Bangalore city only minutes. Because it was a premature to Gulbarga minutes, therefore we challenged the term that was withdrawn minutes. We'll argue the case. So it's a bit minutes.
ಏನು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಾ? ಅವ್ರು ಹೇಳ್ತಾ ಅಲ್ವಾ ಈಗ ಮೇ ಅಲ್ಲಿ this will become infectious.
But the respondent is not entitled to.
Yeah, all these are all luxury litigation, sir. What is all this? There are better issues to be considered. People are dying without salary. So many other things are there. It's
a modified order minutes.
List this matter after summer vacation.
Minutes, they have no use minutes.
Yes.
Any short date minutes?
No, sir.
Yes.
Regard to cancellation of registration of the society. Last time, Lord, the Lord has heard and directed to produce the grant records. I filed it, my Lord. With the memo, page 6 is not the grant order dated 17 July 79.
Eight acres of land.
Okay. And my Lord, the next document is the mediation entries on the basis of the grant.
So you have done nothing. You have done nothing after taking the grant.
Page 33 is the report by the Tahsildar. That shows that Lord, nothing has been done by the.
ಅದೇನೆ. ಏನು ಮಾಡೋದು ಇವಾಗ?
Therefore, Lord, I am entitled for quashing the order because it was done without notice by publishing in the paper.
Please read this page number 33.
Please. Bangalore ಉತ್ತರ ತಾಲೂಕು ದಾಸನಪುರ
ಅದ್ಬಿಡಿ ಕೆಳಗಡೆ ಹೋಗಿ.
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಪ್ಯಾರಾಗ್ರಾಫ್ 2 ಅದರನ್ವಯ ಉಲ್ಲೇಖ 2ರಂತೆ ಸಂಬಂಧಪಟ್ಟ ರಾಜೇಶ್ವರ ನಿರೀಕ್ಷರಿಂದ ವರದಿ ಪಡೆಯಲಾಗಿ ದಾಸನಪುರ ಹೋಬಳಿ ಲಕ್ಷ್ಮೀಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 24 ಮೂಲತಃ ಸರ್ಕಾರಿ ಭೂಮಿಯಾಗಿದ್ದು ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 30 ಎಕರೆ ಪೈಕಿ 8 ಎಕರೆ ಖರಾಬು ಖಾತಾ ಉಳಿಕೆ ಈ ಪೈಕಿ 18 ಬಿಪಿಎಂ ನಿವೇಶನ ರಹಿತ ಬಡ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮತ್ತು ಪಂಗಡದವರಿಗೆ ನಿವೇಶನ ಮಂಜೂರಾಗಿದ್ದು 8 ಎಕರೆ ಜಮೀನಿಗೆ ದಲಿತ ವಿವಿಧ ಗ್ರಾಮೋದ್ಯೋಗ ಕೈಗಾರಿಕಾ ಸಹಕಾರ ನಿರ್ಧರಿಸಿದ ದರ ಒಟ್ಟು ಸರ್ಕಾರಕ್ಕೆ ಪಾಲಿಸಿದಂತೆ ಮಾನ್ಯ ಉಪಾಧಿಕಾರಿಗಳು ಆದೇಶ ಮಾನ್ಯ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮತ್ತೆ ಮಂಜೂರಿಯಾಗಿ MR ನಂಬರ್ 17/81 ಲಿಮಿಟೇಷನ್ ಅಂಗೀಕರಿಸುತ್ತದೆ. ಹಾಲಿ ಗಣೀಕೃತ ಪಾಣಿಯಲ್ಲಿ ದಲಿತ ವಿವಿಧ ಗ್ರಾಮೋದ್ಯೋಗ ಕೈಗಾರಿಕಾ ಸಂಘದ ಹೆಸರಿನಲ್ಲಿ ಪಾಣಿ ಇದ್ದು ಇಡೀ ರಾಮಸ್ವಾಮಿ ಆಯೋಗದ ನಕ್ಷೆಯಂತೆ ಸದರಿ ಸಂಘವು ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತಾರೆ ಎಂಬ ಅಂಶವನ್ನು ರಾಜ್ಯ ತಿಳಿಸಿದೆ.
Annexure J report may please be seen. Annexure J is a report called for by the Divisional Authority. 103 ನಲ್ಲಿ the Deputy Registrar, page number 103, Annexure J. This is a report called for by the Divisional Authority. Last para in page 103. ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಉತ್ತರ ವಲಯ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಜಂಟಿ ನಿಬಂಧಕರು ಸೊ ಇವರು ಸಲ್ಲಿಸಿರುವ ವರದಿಯಲ್ಲಿ ಸದರಿ ಸಂಘದ ಮೂಲ ಉದ್ದೇಶಗಳಾದ ಗ್ರಾಮೋದ್ಯೋಗ ಕೈಗಾರಿಕೆ ಅಭಿವೃದ್ಧಿ ಸದಸ್ಯರ ಏಳಿಗೆಯ ಕುರಿತು ಯಾವುದೇ ಕಾರ್ಯಚಟುವಟಿಕೆ ನಡೆಸದೆ ಸುಮಾರು 8 ವರ್ಷಗಳ ನಂತರ ಸಂಘದ ಹೆಸರಿನಲ್ಲಿರುವ ಜಮೀನನ್ನು ಹೊಂದುವ ಏಕೈಕ ದೃಷ್ಟಿಯಿಂದ ಸಂಘವನ್ನು ಪುನಶ್ಚೇತನಗೊಳಿಸಲು ಕೆಲವು ಜನರು ಕೋರುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಸಂಘವನ್ನು ಪುನಶ್ಚೇತನಗೊಳಿಸಿದಲ್ಲಿ ಸಂಘವು ಹೊಂದಿದ್ದ ಮೂಲ ಧ್ಯೇಯ ಹಾಗೂ ಉದ್ದೇಶಗಳನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸುವ ಸಾಧ್ಯತೆಗಳಿರುವುದಿಲ್ಲವೆಂದು ವರದಿಯಲ್ಲಿ ತಿಳಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸಹಕಾರ ಸಂಘದ ಪುನಶ್ಚೇತನಕ್ಕಾಗಿ ಮಾಡುವ ಕೋರಿಕೆಯ ಸಮರ್ಪಕ ಹಾಗೂ ನೈಜತೆಯಿಂದ ಕೂಡಿದ್ದಲ್ಲಿ ಸಂಘದ ಮೂಲ ಉದ್ದೇಶಗಳು ಮತ್ತು ಸದಸ್ಯರ ಕೈಗಾರಿಕಾ ಚಟುವಟಿಕೆಗಳನ್ನು ಮರುಸ್ಥಾಪಿಸುವ ಉದ್ದೇಶವನ್ನು ಹೊಂದಿರುವುದು ಮನವರಿಕೆ ಆದಲ್ಲಿ ಸಂಘವನ್ನು ಪುನಶ್ಚೇತನಗೊಳಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು. ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮಗಳ 33B ಅನ್ವಯ ನೋಂದಣಿಯನ್ನು ರದ್ದುಪಡಿಸಲಾದ ಸಹಕಾರ ಸಂಘದ ಸಮಾಪನಾ ವಿವರಣೆಗಳನ್ನು ಸಮಾಪನೆಯು ಪೂರ್ಣಗೊಂಡೆಂದಿನ 3 ವರ್ಷಗಳ ಮುಗಿದ ನಂತರ ರಿಜಿಸ್ಟರ್ ಅನ್ನು ನಾಶಪಡಿಸಬಹುದು. ಮೇಲೆ ತಿಳಿಸಿರುವ ಕಾರಣಗಳಿಂದ ಸದರಿ ಸಹಕಾರ ಸಂಘದ ನೋಂದಣಿ ರದ್ದತಿಯಾದ ಸುಮಾರು 8 ವರ್ಷಗಳಿಂದಲೂ ಹೆಚ್ಚಿನ ಅವಧಿ ಕಳೆದ ನಂತರ ಸಂಘದ ಆಸ್ತಿಗಳು ಒತ್ತುವರಿಯಾಗಿ ಅನಧಿಕೃತ ಕಟ್ಟಡಗಳು ನಿರ್ಮಾಣವಾಗುತ್ತಿರುವುದು ತಡೆಯುವ ಉದ್ದೇಶ ಇರುವುದರಿಂದ ಸಲ್ಲಿಸಿರುವ ಪಾಣಿ ಪತ್ರದಲ್ಲಿ ಸಂಘಕ್ಕೆ ಮಂಜೂರಾಗಿರುವ ಜಮೀನು ಗೋಮಾಳ ಜಮೀನು ನಮೂದಾಗಿರುವುದರಿಂದ ಈ ಸಂಘವನ್ನು ಪುನಶ್ಚೇತನಗೊಳಿಸುವುದು ಸಮಂಜಸವಾಗುವುದಿಲ್ಲವೆಂಬ ಅಭಿಪ್ರಾಯವನ್ನು ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸುತ್ತಾ ಸಂಘದ ಹೆಸರಿನಲ್ಲಿರುವ ಜಮೀನು ಹೆಚ್ಚು ಬೆಲೆ ಮತ್ತು ಮೌಲ್ಯಯುತ ಆಗಿರುವುದರಿಂದ ದುರ್ಬಳಕೆ ಆಗುವ ಸಂಭವವಿರುವುದರಿಂದ ನಿಯಮ 24A ಅನ್ವಯ ಸರ್ಕಾರದ ವಶಕ್ಕೆ ಪಡೆಯುವುದು ಸೂಕ್ತವೆಂದು ವರದಿಸುತ್ತಾ ಮೇಲಿನ ವಿವರಗಳನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. Pursuant to this report, Annexure K, Divisional Authority concurred with the findings of the original authority. Page 108. There, the Divisional Authority, it notes the report, the additional registrar, the second part. Examining the submissions made by the advocate for petitioner and the report submitted by the additional registrar of cooperative societies, and also the relevant provisions of Karnataka cooperative societies. I find that this petitioner society was liquidated on 29/9/1998, and subsequently the registration was cancelled widely. The impugned order dated 31/3/2005. That advocate for petitioner has not produced any record to show that either the petitioner or any member of the society have made any effort to revive the society at the time of liquidation. There is no provision for appeal against the impugned order made under Section 75. This revision petition has been filed under Section 108 after lapse of 7 years from the date of impugned order. As such, the submission made by advocate for petitioner to condone the delay is substantiated. Further observed that the impugned order was passed on the basis of the report submitted by the concerned liquidator. After the society has been liquidated, the committee of such society does not exist. Hence, the question of issuing notice to the petitioner who stated to be the ex-president of the society before passing impugned order does not arise.
and therefore these submissions made by the advocate for petitioner cannot be considered as tenable. Since there is no provision to revive the cooperative society after cancellation of registration of such society under section 75, as such, I find that the report submitted by the additional registrar of cooperative societies towards the revival of the petitioner society is not in accordance. However, as far as the transfer of valuable immovable property, which was still in the name of the society to the government is concerned, report submitted by the additional registrar of cooperative society is considered as tenable. Accordingly, it is appropriate to give direction to the respondent to take suitable steps.
The very same authority, in a similar
Sir, there are chances of misuse of all this. See, this society was cancelled by order dated 31/3/2005, and admittedly, you have not produced anything because it is not possible for conducting any transaction, and you have not conducted any transaction even since 1998. How can you come before the court now?
Your Lordship kindly see page 34 along with the memo page.
Allah sir, you can't even style yourself as the first respondent cooperative society because it is cancelled already.
It is not in dispute that Lord, we are the members of that erstwhile society. Lord, unless we challenge this, Lord, nobody could challenge.
You should have challenged it within reasonable time, sir.
You have no notice.
So many.
Your Lordship kindly see
Correct,
page.
sir. No notice, Andrea. What were you doing? That is what I'm asking you. Last time also I asked you the same thing.
Please.
If you were really transacting business in terms of your bylaws, you would have come to know on the very next year when you submit your statement of accounts.
Yes.
That is the requirement under law.
It is not been done.
You have not done for so many years together.
Your Lordship kindly see
At your instance, how can we revive this society? I
the
don't
order is passed, Lord, annexure C.
Yes.
Lord, including the other 6 Lord, the society, by publishing a notice, Lord, in the paper, even not personally notified. Lord, I have produced the document to show
Sir,
that.
accepting that submission,
Yes.
you would have come to know the very next year if there was some order passed like this. You did not come to know because there was no transaction, there was nothing in the society for decades together.
That is true. Lord.
Then
Lord, what I say is, Lord, to pass order under section 75. There should be an order.
ಅರ್ಥ ಆಯ್ತು ಆದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ there was no one who could receive notices from the state.
That is totally wrong. Lord, unless they make attempt to serve the notice, Lord, can't be done.
That is why
Page 34,
no,
along with the memo, a similar petition, they allow, the government is allowed on the ground that no opportunity is given before Lord, passing under section 75.
Sir, there are hundreds and thousands of such orders we have passed. There is no doubt about that. But the difficulty here is that there is nothing in this society, no transaction has taken place for more than 20 years.
That is why,
How
Lord,
can you seek revival of this society now at this stage?
that is, Lord, I agree. Lord, for such societies, Lord, there should be an inquiry under section 63 and 64. Thereafter, Lord, under section 72, order has to be passed. Then 73, Lord, he is appointing the liquidator. Then, Lord, section 75 arises. In this case, admittedly, no records are forthcoming, either inquiry under 63, 64, Lord, the winding up of society under 72, 73 liquidator appoint madilla.
Varala, sir.
Lordship kindly see.
They have very clearly stated that notices sent to you has not been served on you because there is no one in the office, there is nothing, no office at all.
Notice,
Then what should they do then?
notice of publishing, Lord, in the paper is a last resort. Kindly see, Lord, rule 32.
ಈಗ ನಿಮ್ಮ ಅಡ್ರೆಸ್ ನೋಡಿ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಈ ಪೆಟಿಷನರ್ ಅಡ್ರೆಸ್ ನೋಡಿ. On your own showing, you have no place of office. ಏನು ಅಂತ
ಸಂಜಯಪಾಳ್ಯ
ಅಷ್ಟೇನಾ? ಆಗೋಗುತ್ತಾ?
Place where my lord it is.
No, sir.
Society register ಮಾಡಿರೋದು ಅದೇ ಹೆಸರು. Kindly see my lord, I produced the registration certificate also. Annexure A. That when the order has been passed, Lord, in violation of the principles of natural justice, when they are not in a position to show, Lord, no order is passed, either 63, 64, 72 or 73. The question of 75.
Sir, that is why we have always held that any action to be taken should be taken within reasonable time. ನೀವು ಅವ್ರದ್ದು ಹೇಳ್ತಿರಲ್ಲ, ನಿಮ್ಮದು ಹೇಳಿ. For decades together, you have kept quiet because you were, there was nothing at all. There was no one to run the society.
That if really, Lord, the society was wound up, the liquidator is appointed. He should have taken, Lord, the proceedings under the act. Nothing has been done.
Sari, ಯಾರ ಹತ್ರ ಹೋಗ್ಬೇಕು ಸರ್ ಅವರು? They have to go before whom?
After filing the revision, to be able to find out the, Lord, the existence of the property.
If you really had an office and you are running, you are doing your business normally, they would have found you. And having taken possession of this land, 8 acres of land, you have done nothing.
That in view of all, Lordship kindly see, if the opportunity was given.
No, sir.
Otherwise, my Lord, very purpose of registering the society, my Lord, particularly, my Lord, interest of the.
You have lost it.
Kindly see, my Lord, your Lordship kindly. Otherwise, when they have not taken any action, the endorsement I have produced.
Sir, it is too late in the day to revive this.
Otherwise, my Lord, we will lose the, Lord, the.
ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಆಗ್ಲೇ. ಎಲ್ಲ ಮುಗಿದೋಗಿದೆ.
ಎಲ್ಲೂ ಹೋಗಿಲ್ಲ.
They have to formally cancel that grant and hand it over to someone else. That's all.
Kindly see, Lord, page 5 of that endorsement given. If they have passed the orders, Lord, I can understand, assuming that I have, along with the
starting alla first paragraph alli helpitidare avaru.
15/3/22
that notice sought to be served on you.
ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ ಅವರು, ಆರ್ಡರ್ ಆಗಿದೆ 72, 73 ಅಲ್ಲಿ ವೈಂಡ್ ಅಪ್ ಆಗಿದೆ, ಆಮೇಲೆ ಲಿಕ್ವಿಡೇಟರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Let them show it. On that basis, you Lordship can reject my petition. Kindly see, Lord, page 5 in the memo filed along with 15/3/2022. ಏನು ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Sir, they have destroyed all that in terms of the law. That is why they say you are, whatever you have to do within the time prescribed. There are laws which would require maintenance of the records for a particular period. If you go beyond that period, what will they do?
That when they can not the set aside the similar order, passed in similar circumstances after 10 years. So far as the petitioner is concerned, they said that you have brought the revisional authority late, therefore you are not entitled. Kindly see on 22/2/2022, the endorsement issue. I specifically sought. Your Lordship got it, endorsement. 2/2/22. Along with the memo. 15/3 memo. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖದ ಪತ್ರದಲ್ಲಿ ದಲಿತ ವಿವಿಧ ಗ್ರಾಮೋದ್ಯೋಗ ಕೈಗಾರಿಕಾ ಸಂಘ ನಿಯಮಿತ ಸಜ್ಜೆಪಾಳ್ಯ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ನೋಂದಣಿ ಸಂಖ್ಯೆ ಮೇಲೆ ತಿಳಿಸಿದ ಸಂಘವು ನೋಂದಣಿಯಾಗಿದ್ದು, ಸದರಿ ಸಂಘದ ನೋಂದಣಿ ರದ್ದತಿಯಾಗಿದ್ದು, ರದ್ದತಿ ಸಂಖ್ಯೆ ನಂಬರ್ ಈ ಮೇಲೆ ತಿಳಿಸಿದ ಸಂಘವನ್ನು ರದ್ದತಿ ಮಾಡುವ ಕಾರಣ ರದ್ದತಿ ಮಾಡಿರುವ ಲಿಕ್ಯುಲೇಟರ್ ಆಫೀಸರು ಯಾರು, ಸಂಘದ ರದ್ದತಿ ಮಾಡುತ್ತಿರುವ ನೋಟಿಸ್ ಪ್ರತಿ ರದ್ದು ಮಾಡುವಾಗ ಇಲಾಖೆಯಿಂದ ತೆಗೆದುಕೊಂಡ ಕ್ರಮಗಳು, ಕಡತದಲ್ಲಿನ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಕ್ರೋಢೀಕರಿಸಿ ಬರುತ್ತೀರಿ. ಈ ಕಚೇರಿಯ ಕಡತದಿಂದ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಾಗಿ ತಾವು ಕೋರಿರುವ ಸಂಘವನ್ನು ರದ್ದುಪಡಿಸುವ ಕಾರಣಗಳು, ರದ್ದುಪಡಿಸಲು ನೇಮಕಗೊಂಡ ಸಮಾವೇಶನಾಧಿಕಾರಿಗಳು ಸಂಘಕ್ಕೆ ನೀಡಿದಂತಹ ನೋಟಿಸಿನ ಪ್ರತಿಗಳು ಹಾಗೂ ರದ್ದುಪಡಿಸುವಾಗ ಅನುಸರಿಸುವ ಪ್ರತಿಕ್ರಿಯೆಗಳ ಕುರಿತು ದಾಖಲಾತಿಗಳು ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಸದರಿ ಕಡತದಲ್ಲಿ ಸಂಘವನ್ನು ರದ್ದುಪಡಿಸುವ ಕುರಿತು ಸರ್ಕಾರ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಸದರಿ ಪ್ರತಿ ಲಗತ್ತಿಸಿದೆ. Except notification, they don't say that we have destroyed it. Absolutely no order has passed. If no order is passed under 72 and 73, how can they they pass under 75 on the ground? The liquidator has appointed and he has said that no pointing in reviving the society, it's not functioning. Could pass an order. Therefore, on their own showing.
In a similar case.
Then, my lord, you lordship kindly see the annexure C.
In a similar case, annexure, concurrent bench of this honorable court. That opportunity needs to be granted because when the society is found to be inactive and there have been no activities in that. Considering the report of the officer, the revisional authority has concurred with the findings. There have been concurrent findings. Last paragraph. Page number 134.
Paragraph 7.
The relevant portion is at page number 134. Very last paragraph. Authorities may not put the authorities have, after taking into consideration the report submitted by the Cooperative Development Officer and after seeing the economic viability of the societies, the manner in which they are functioning, and due to change of circumstances, in view of the subsequent development in the area, the first respondent has rightly passed the order at Annexure A for winding up of the affairs of the eighth petitioner in first petition and seventh petitioner in second petition. Therefore, I do not find any substance in the submission of the learned counsel petitioners that the mandatory provision of section 72 of the Act has not at all been followed and no opportunity as such has been given to the petitioners, and hence there is violation of the principles of natural justice. The third respondent being the competent authority and the fact-finding authority, after issuing the statutory notice as referred to at serial number 1 of the order by the Annexure A, has initiated proceedings under section 72 after thorough evaluation of the oral and documentary evidence available on file and after taking into consideration the detailed report submitted by the Cooperative Development Officer and the different heads as stated supra. I am of the considered view that all the three authorities have recorded concurrent findings of fact against the eighth petitioner in the first petition and so, and every aspect of the matter has been taken into consideration and appreciated by the divisional authority. But in this matter also, similar orders have been passed by the divisional authority after taking into consideration the report.
The report is after the cancellation.
And my lord, in the order of cancellation of registration, my lord, we have stated in what circumstances the Samapani proceedings, my lord, came to be passed.
Let Annexure C, your lordship kindly. In respect of all 7 societies, the registration has been cancelled. Kindly see, Lord, where is the specific allegation against the petitioner society? It is like omnibus. Just Annexure C, page 72. that, Lord, I will, page 75 is the typed copy. From top. ಈ ಸಮಾಪನೆಗೊಂಡ ಸಹಕಾರ ಸಂಘಗಳ ಸಮಾಪನಾಧಿಕಾರಿಗಳು ಸಂಘದ
Page number 72.
75.
75.
Typed copy. ಸಮಾಪನೆಗೊಂಡ ಸಹಕಾರ ಸಂಘಗಳ ಸಮಾಪನಾಧಿಕಾರಿಗಳು ಈ ಸಂಘಗಳ ಪ್ರಭಾರವನ್ನು ವಹಿಸಿಕೊಳ್ಳಲು ಎಷ್ಟೇ ಪ್ರಯತ್ನ ಪಟ್ಟರು ಈ ಸಂಘಗಳ ಅಸ್ತಿತ್ವ ನೋಂದಾಯಿತ ವಿಳಾಸದಲ್ಲಾಗಲಿ ಇಲ್ಲದಿರುವುದನ್ನು ಮನಗಂಡು ಈ ಸಂಘಗಳ ಪ್ರಭಾರವನ್ನು ವಹಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಈ ಸಂಘದ ಅಸ್ತಿತ್ವವು ದೊರೆಯದೇ ಇದ್ದ ಕಾರಣ ಸಂಘಗಳ ನೋಂದಣಿ ರದ್ದುಪಡಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರು ಬೆಂಗಳೂರು ಪ್ರಾಂತ ಬೆಂಗಳೂರಿವರು ಸಂಜಯವಾಣಿ 2/3/2005 ತಮ್ಮ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಪ್ರಕಟಿಸಿ ಸಂಘಗಳ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಾಗಲಿ ಸಾರ್ವಜನಿಕರಾಗಲಿ ಹಣಕಾಸು ಸಂಸ್ಥೆಗಳಾಗಲಿ ಈ ಸಂಘಗಳ ನೋಂದಣಿ ರದ್ದುಪಡಿಸಲು ಆಕ್ಷೇಪಣೆ ಇದ್ದಲ್ಲಿ ಈ ಸಂಘಟನೆ ಹೊರಡಿಸಿದ್ದ ಲಿಖಿತವಾಗಿ ದಾಖಲೆಗಳೊಂದಿಗೆ ಸಲ್ಲಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿತ್ತು. ನಿಗದಿಪಡಿಸಿರುವ ಅವಧಿಯಲ್ಲಿ ಅನುಬಂಧದಲ್ಲಿರುವ ಸಂಘಗಳ ಬಗ್ಗೆ ಯಾರೂ ಸಹ ಯಾವುದೇ ಅಪ್ಡೇಟ್ ಮೇಲೆ ತಿಳಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅನುಬಂಧದಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸಹಕಾರ ಸಂಘ ಹಲವಾರು ವರ್ಷಗಳಿಂದ ಶ್ರೀಕಂತು ಸದರಿ ಸಂಘ ಅಸ್ತಿತ್ವದಲ್ಲಿ ಎಂಬ ಬಗ್ಗೆ ಮತ್ತು ಇದರ ಲೆಕ್ಕಪತ್ರಗಳು ಯಾವ ಬೆಳೆಯುವ ಎಂಬ ಬಗ್ಗೆ ಯಾವುದೇ ರೀತಿಯ ಮಾಹಿತಿ ಇಲ್ಲದಿರುತ್ತ ಈ ಸಂಘಗಳ ಸಮಾಪನಾಧಿಕಾರಿಗಳು ಸಹಕಾರ ಸಂಘ ಕಾಯ್ದೆಗಳ 59ರ ಕಲಂ 73, 74 ಸಹಕಾರ ಸಂಘ ನಿಯಮ 24-33ರಲ್ಲಿ ವಿಧಿಸುವಂತೆ ಸಮಾಪನಾ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪೂರ್ಣಗೊಳಿಸಲು ಸಾಧ್ಯತೆ ಇಲ್ಲದಿರುವುದರಿಂದ ಕಾಣಲಾಗಿದೆ. ಈ ಸಂಘ ಮುಂದುವರೆದರಿಂದ ಸದಸ್ಯರಿಗಾಗಲಿ ಅಥವಾ ಸಾರ್ವಜನಿಕ ಯಾವುದೇ ರೀತಿಯ ಉಪಯೋಗ ಇಲ್ಲದ ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರು 1ನೇ ವಲಯ ಬೆಂಗಳೂರು ಅನುಬಂಧ ನೋಂದಣಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಶಿಫಾರಸು ಮಾಡಿರುವುದರಿಂದ ಹಾಗೂ ಸಂಬಂಧ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಕಲಂ ನಂಬರ್ this is not in respect of all the 7 societies. There is no the specific allegation.
Ellardu ade same category.
The same category. Then what is stated in the annex C, there is an order passed in 72 and 73, and the liquidator could not do anything. Kindly see, I have read the endorsement issue. Absolutely no material.
Material ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಸರ್? ಇವಾಗ they have said please you have just read it out now.
ಅಲ್ಲ ಆರ್ಡರ್ ಆಗಬೇಕಲ್ಲ. Proceedings is one thing. There should be an order of winding up under section 72. There is no order.
Formally it is passed, that's all.
At least we should
there is no question of opportunity because you are never found.
Let the 75, this is
No,
the
sir.
order passed under section 75. But I can understand, after passing the order under 72 and 73, the opportunity whether to be given and while passing order under 75. The order passed is under section 75. On the ground, there is already an order passed under 72 and 73. That order is not forthcoming. There is no order. I specifically asked them, please furnish the order, the notices copy, and the proceedings taken by the liquidator. Nothing has been said. They said that no records are available. They have not said that it is destroyed. So far as the similar society which was the registration was cancelled in 2006. The revisional authority, the government allows on the grounds. No opportunity was given.
Yavagadu? When did that happen?
That's 2017. Kindly see, I have produced along with the present memo. That's what I am referring. They are treating me apart.
No, sir. Immediately thereafter, if the society has come before the authorities, all that would have been considered.
In similar society, has approached the
ಹೋಗಿರ್ಬೋದು.
Please.
Correct. It is possible that after 6 months or 1 year, definitely, if you are functioning regularly, you would have had an opportunity to come to know about the orders passed.
Kindly see page 34 of that.
If you leave it for decades together, what will happen, sir?
If they pass such an order, ಎಲ್ಲ 10 ಸೊಸೈಟಿ ಸೇರಿಸ್ಬಿಟ್ಟು ನೀವು ಯಾರು ಫಂಕ್ಷನ್ ಮಾಡ್ತಾ ಇಲ್ಲ
ಹೌದು ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ ಯು ಪ್ಲೀಸ್ ಪುಟ್ ಯುವರ್ ಸೆಲ್ಫ್ ಇನ್ ದೇರ್ ಪ್ಲೇಸ್ ಯು ಪ್ಲೀಸ್ ಟೆಲ್ what should happen if there is no one found in there is no office no transaction nothing how far should how long can they wait
law requires there should be a step by step order page 34
you will continue at 2:30
please
no adjournment now what
Court officer. 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 Court officer.
ಇಲ್ಲ ಇಲ್ಲ ಹಂಗೆ ಹಂಗಂಗ್ ಮಾತಾಡಂಗಿಲ್ಲ.
ರೀಚಾರ್ಜ್ ಸರ್ ವರ್ಷದ ಮಾಡಿಸಿದೀವಿ.
5 ದಿವಸ ಫುಲ್ ವರ್ಷಕ್ಕೆ.
ಒಂದು ವರ್ಷದ ಮೊನ್ನೆ ಫೆಬ್ರವರಿ 5ನೇ ತಾರೀಕು 7ನೇ ತಾರೀಕು ಒಂದು ವರ್ಷದ ಫುಲ್ ಮಾಡ್ತೀವಿ. ಮಾಡಿದಾರೇನ್ರಿ ಯಾವಾಗ ಟಿವಿ ಇದಿರ್ಲಿಲ್ಲ. ಯಾವ್ದು ಸರ್? 26/09.
26/09
ಜಿ ಕನ್ನಡ.
ಅದು 2609 ಹಾಕಿ ಇಲ್ಲ 2687 087. ಕರೆಕ್ಟ್ ಇದೆ ಸರ್.
स्मार्ट कार्ड की जांच की जा रही है. सेटअप ऑप्शन स्मार्ट कार्ड सर्च ಮಾಡ್ತಾ ಇದೆ. ಇದು ಪರ್ಚೇಸ್ ಬಿಲ್ ಕೊಡಿ ಸರ್. ಇಲ್ಲ ಅಂದ್ರೆ ಈ ನಂಬರಿಗೆ SMS ಮಾಡಬೇಕಂತ ಮೆಸೇಜ್ ಕಳಿಸಿ.
921
201 22
921 ಹೇಳಿ 921.
ಅರೆ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡ್ರಿ ಯಾರವರು.
Worship stream. Morning I could not move on matter. I filed application for stay, my lord. So election is scheduled to be held on 4/4, your lordship.
Number 31. Yes, continuation.
But I was reading the.
Now, after the orders were passed, when was the first time you sought to challenge it?
Annexure E brought the 26 representation.
Two 2013.
Thereafter, by annexure G, it is informed that you have to file a revision before the government. Then I filed the revision before the government.
Let us see section 108. In a period of 6 months from the date of an order, may call for and examine case of proceedings of any officer subordinate to it, except those subject to appeal or revision by the tribunal, or those in respect of which an appeal has been made. There's a definite meaning behind giving this kind of a period, sir.
But the authorities not exercise the power by condoning the delay. Page 34. Along with the documents filed.
Hello?
Page 34. Is the revision taken by the government note against the order dated 8/6/2005. Passed note under section 75 of the Act. Page 36, blood.
34.
34.
ಯಾವ್ದಿದು ಮೊಹಮ್ಮದ್ ಹನೀಫ್ ಅಂತ ಏನೋ ಇದೆ.
Similar person. The society has approached after cancellation of the registration.
But this pertains to some other.
Some other. Just to show that in case of others, entertain the revision and set aside. So far as my case is concerned, it is rejected. ಸಂಘ ನಿಬಂಧನೆಗಳ ಧಾರವಾಡ ಜಿಲ್ಲೆ ಹೊರಡಿಸಿರುವ ಆದೇಶ ಸಂಖ್ಯೆ ಸೊ 8/6/2005 ಅನ್ನು ಪ್ರಶ್ನಿಸುತ್ತಾರೆ. ಈ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ಸ್ವೀಕರಿಸಿ ಸೂಚನೆಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಪ್ರತಿವಾದಿ ಮೇಲ್ಕಂಡ ಸಂಘದ ಆಸ್ತಿ ಜವಾಬ್ದಾರಿಯನ್ನು ನಮೂದಿಸಿದ ಆಸ್ತಿ ಮತ್ತು ಜವಾಬ್ದಾರಿ ನಿಯಮಾನುಸಾರ ವಿಲೇವಾರಿ ಮಾಡದೆ ಸಂಘಗಳ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ಆಧಾರದ ಮೇಲೆ 24 ಸಹಕಾರ ಸಂಘ ನೋಂದಣಿ ರದ್ದುಪಡಿಸಿ ಆದೇಶ ಹೊರಡಿಸಿದ್ದು ವಾದಿಸುತ್ತಾರೆ. ಅರ್ಜಿದಾರರ ಪರ ವಕೀಲರು ಮೇಲ್ಕಂಡ ಸಂಘವು ನೋಂದಣಿ ಎರಡನೇ ಪ್ರತಿವಾದಿ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಂದಕರು objected on the ground that there is a delay. Page 36, paragraph 2. ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 59 ಕಲಂ 72ರಲ್ಲಿ ಸಹಕಾರ ಸಂಘವನ್ನು ಸಮಾಪನೆಗೊಳಿಸಿ ಕಲಂ 73ರಲ್ಲಿ ನೇಮಕ ಮಾಡುವ ಸಮಾಧಿಕಾರಿಯು ಸಮಾಪನೆಗೊಂಡ ಸಹಕಾರ ಸಂಘದ ಆಸ್ತಿ ಜವಾಬ್ದಾರಿಯನ್ನು ನಿಯಮಾನುಸಾರ ವಿಲೇವಾರಿ ಮಾಡಿದ ನಂತರ ಆಸ್ತಿ ಜವಾಬ್ದಾರಿ ಹುದ್ದೆಯನ್ನು ಶೂನ್ಯಗೊಳಿಸಿ ಸಂಘದ ನೋಂದಣಿ ರದ್ದತಿಗೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ ನಂತರ ಆ ಪ್ರಸ್ತಾವನೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ 75 ಸಂಘದ ನೋಂದಣಿ ಕ್ರಮವನ್ನು ರದ್ದುಪಡಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದರೆ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಸ್ತುತ ಆದೇಶ ಹೊರಡಿಸುವ ಮುನ್ನ ಮೇಲ್ಕಂಡ ಕ್ರಮಗಳನ್ನು ಪಾಲಿಸದೆ ಸಹಕಾರ ಸಂಘಗಳ ಹೊರಡಿಸಿರುವ ದಿನಾಂಕ 22/3 ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ಆಧಾರದ ಮೇಲೆ ಒಂದೇ ಆದೇಶದಲ್ಲಿ 54 ಸಹಕಾರ ಸಂಘಗಳ ಕ್ರಮವನ್ನು ರದ್ದುಪಡಿಸಿ ಎರಡನೇ ಪ್ರತಿವಾದಿ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಹೊರಡಿಸಿರುವ ಪ್ರಸ್ತುತ ಆದೇಶವು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 59, 60 ಮತ್ತು ಸ್ವಾಭಾವಿಕ ನ್ಯಾಯ ತತ್ವಗಳಿಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿರುವುದೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. ಎರಡನೇ ಪ್ರತಿವಾದಿ ಸಹಕಾರ ಸಂಘದ ಖಂಡಿತವಾದ ಪತ್ರದಲ್ಲಿ ಅವಕಾಶದ ಮೇಲ್ಮನೆ ದಾಖಲೆಗಳಿರುವುದರಿಂದ ಸಹಕಾರ ಪುನರ್ ಪರಿಶೀಲನಾ ಅರ್ಜಿಯನ್ನು ನಮೂದಿಸಿರುವುದರಿಂದ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದ ಉಚಿತವಲ್ಲವೆಂದು ಅವರು ವಾದಿಸುವ ವರದಿ ಮಾಡಿರುವ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಆದೇಶದಲ್ಲಿ 54 ಸಹಕಾರ ಸಂಘಗಳ ನೋಂದಣಿ ಕ್ರಮಗಳನ್ನು ಹೊರತುಪಡಿಸಿದ್ದು 50 ಪೈಕಿ ಅರ್ಜಿದಾರ ಸಂಘವು 40ನೇ ಸಂಖ್ಯೆಯ ಅರ್ಜಿದಾರ ಪರ ವಕೀಲರು ಪ್ರಕರಣವನ್ನು ದಾಖಲು ಉಂಟಾಗಿರುವ ವಿಳಂಬವನ್ನು ಮನ್ನಾ ಮಾಡಲು ಮಧ್ಯಂತರ ಅರ್ಜಿಯೊಂದಿಗೆ ಪ್ರಾಣವನ್ನು ಹೊರಡುತ್ತಾರೆ. ಅಲ್ಲದೆ ಸಹಕಾರ ಸಂಘದ ನೋಂದಣಿ ಕ್ರಮವನ್ನು ರದ್ದುಪಡಿಸಿ 75ರಲ್ಲಿ ಹೊರಡಿಸುವ ಆದೇಶವನ್ನು ಪ್ರಶ್ನಿಸಿ ಕಲಂ 105 ಮತ್ತು 106 ಮೇಲಿನಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲವಿರುವುದರಿಂದ ಸರ್ಕಾರ ಖಂಡಿತವಾದ ಸಮರ್ಥನೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. ಅರ್ಜಿದಾರರಿಗೆ ಈ ಪ್ರಕರಣವನ್ನು ದಾಖಲು 10 ವರ್ಷಗಳ ವಿಳಂಬವಾಗಿದ್ದರೂ ಸಹ ಪ್ರಕರಣದಲ್ಲಿಂದ ಪ್ರಸ್ತುತ ಆದೇಶವು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘ ಕಾಯ್ದೆ 29 ನಿಯಮ 1960 ಸ್ವಾಭಾವಿಕ ನ್ಯಾಯ ತತ್ವಗಳಿಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿರುವುದರಿಂದ ವಿಳಂಬ ಮನ್ನಾ ಮಾಡಲು ಪ್ರಾರ್ಥಿಸಿ ಮಧ್ಯಂತರ ಸೂಕ್ತವೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. ಮೇಲ್ಗಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಅರ್ಜಿದಾರ ಸಹಕಾರ ಅನ್ವಯಿಸುವಂತೆ ಪ್ರಸಿದ್ಧ ಆದೇಶವನ್ನು ಕರ್ನಾಟಕ ಆದೇಶವನ್ನು ವಜಾ ಮಾಡಿ ಆದೇಶಿಸುತ್ತದೆ.
This can be done in this case. Why not in this case? There is no reasons at all, assigned at all here.
Case may not be properly considered the
Correct, amma. Allunu 10 years. You see this second last paragraph in page number 37. Last page. Please go to the last page. Second paragraph. Odi.
ವಿಳಂಬವಾಗಿದ್ದರೂ ಸಹ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಶ್ನಿತಾದೇಶವು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮ ಸ್ವಾಭಾವಿಕ ನ್ಯಾಯ ತತ್ವಗಳಿಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿರುವುದರಿಂದ ವಿಳಂಬ ಮನ್ನಾ ಮಾಡಲು ಪ್ರಾರ್ಥಿಸಿ ಅರ್ಜಿದಾರ ಪರ ವಕೀಲರು ಮಧ್ಯಂತರ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸುವ ಸೂಕ್ತವೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. ಪುನರ್ ಪರಿಶೀಲನಾ ಸಹಕಾರ ಸಂಘಕ್ಕೆ ಅನ್ವಯಿಸುವಂತೆ ಪ್ರಶ್ನಿತಾದೇಶವು ತಳ್ಳಿಹಾಕುವುದು ನ್ಯಾಯಸಮ್ಮತವನ್ನು ಪರಿಗಣಿಸಿ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಅರ್ಜಿದಾರ ಸಹಕಾರ ಸಂಘಕ್ಕೆ ಅನ್ವಯಿಸುವಂತೆ ಎರಡನೇ ಪ್ರತಿವಾದಿ ಸಹಕಾರ ಸಂಘಗಳ ಧಾರವಾಡ ಇವರು ಹೊರಡಿಸುವ ಆದೇಶವನ್ನು ವಜಾ ಮಾಡಿ ಆದೇಶಿಸಿದರು.
ಏನ್ ರೀಸನ್ಸ್ ಇಲ್ಲ, ಏನು ಇಲ್ಲ. If that can be done in that case, why not in this case?
This particular case is considered on that. One more submission is
Same thing has happened in respect of 54 cooperative societies. Please see this. ಒಂದೇ ಆರ್ಡರ್ ಅಲ್ಲಿ 54 ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟೀಸ್ ಇದೇ ತರ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. And if on the same grounds it can be recalled and
the fact that not even order is passed in 2005, no steps have been taken regard to the properties of the society, as could be seen from the report of the Tashikar.
petition is filed by the society itself. It cannot maintain a writ petition because under section 9 will not now view the cancellation of the registration of the society. It is
correct. ಯಾರು ಮಾಡಬೇಕು ಮತ್ತೆ? This appeal also is filed by the society only.
We have dismissed it on the ground of delay.
ಹೌದಮ್ಮ, the one that they read, the senior counsel has read out now, just now. It's all the same thing only. It's filed by the society only.
ಸದಸ್ಯರು ಅಂತ ಇದೆ ಸರ್. ಸದಸ್ಯರು ಅಂತ ಹಾಕಿದ್ದಾರೆ, ರಿಜಿಸ್ಟರ್ಡ್ ಸಂಘ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಹಂಗಾರೆ you first respondent ಬಿಟ್ಬಿಡಿ ಹಂಗಾರೆ. ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಮಿಕ್ಕಿದವರು ಇದಾರಲ್ಲ
ಸದಸ್ಯರಿದ್ದಾರೆ.
ಬರ್ರಿ. The first petitioner is a cooperative society registered under the provisions of the Karnataka Cooperative Societies Act. So, the certificate of registration of the first petitioner society is dated 10/10/1974. The second petitioner is the president, and the other petitioners are members of the first petitioner cooperative society. So, petitioners are aggrieved by order dated 22/6/2018 passed by the first respondent. State government, through its principal secretary, Department of Cooperation. Stop. The petitioners had approached first respondent, invoking the provisions of Section 108 of the Act. To recall, the orders of cancellation of the registration of the society dated 12/5/2005 and subsequent order dated 14/3/2016 passed by the third respondent, additional registrar of cooperative societies. Stop. Next para. Learned senior counsel Shri A.G. Shivarna, appearing for the petitioners, submits that on a plain reading of Annexure C, which is a notification published in the Karnataka Gazette, namely order dated 31st of March 2005, the registrations of 7 cooperative societies have been cancelled. by order of the Deputy Registrar of Cooperative Societies, Bangalore.
ಅದೇ ನಡೀತಾ ಇದೆ ಅವಾಗಿತ್ತು ಮಧ್ಯಾಹ್ನ ಅದೇ
invoking
ಫೋನ್ ಮಾಡಬೇಕು ಅವನಿಗೆ
section 75 of the Act. Stop. Learned Senior Counsel submits. Data. The Assistant Registrar of Cooperative Societies submitted a report to the Deputy Registrar of Cooperative Societies recommending cancellation of the registration of the said cooperative societies on the ground that there has been no business transacted in the 7 cooperative societies named therein, including the first petitioner herein. Stop. Notices sent to the registered officers have returned unserved. After the appointment of the liquidator, the steps taken by the liquidator to serve notice the cooperative societies mentioned therein. Returned without service, since the registered officers do not exist, and there is no person on whom the notices could be served. Stop. Consequently, paper publications were taken out. Calling for explanation as to why the societies should not be cancelled. The registration of the societies should not be cancelled. So objections were also called for from the general public in that regard. So, nevertheless, no response was received from the societies, and consequently, the authorities have proceeded to pass the impugned order dated 31st of March 2005, cancelling the registration of all the 7 cooperative societies mentioned therein. etc. Learned Senior Counsel further submits that at the instance of the first petitioner, at the instance of the petitioner society, the state government granted 8 acres of land in survey number 24 of Lakshmipura village, Lamangala Taluk, to enable the petitioner society to establish small industries which would benefit the members of the society. Which was formed for which was formed by persons belonging to the deprived classes, and with a view to encourage establishment of small industries. The Learned Senior Counsel submits that even after the impugned orders are passed, cancelling the registration of the petitioner society, and winding up and dissolving the society, the landed property granted in favor of the petitioner society continues to remain with the petitioner society. Stop. This aspect of the matter is sought to be evidenced by production of the record of rights. Stop. The Learned Counsel, Senior Counsel, therefore submits that the winding up proceedings are only on paper, and the same has not been implemented in terms of the provisions contained in sections 72 and 74 of the Act. Stop. The Learned Senior Counsel would draw the attention of this court to an order dated 28/7/2017 passed by the first respondent state government, in respect of another similarly situated cooperative society, wherein Similar action was taken by the competent authority while cancelling the registration of 54 cooperative societies, by order dated 22/3/2003. Stop. A revision petition under section 108 was filed by 2 members of the cooperative society and a society, along with an application seeking condonation of delay of more than 10 years. Stop. The revision petition was objected to by the Deputy Registrar and Assistant Registrar of Cooperative Societies on the ground that there was no business transacted in the society for many years. Semicolon. Annual general body meetings were not held. Semicolon. No audited report, audited statement of accounts were submitted. And the notices sent to the societies returned unserved. Stop. It was also argued by the authorities that no useful purpose would be served if the registration of the societies are revived, since the original, the founding members of the society were not interested in reviving the society. And in fact, revival of such society would encourage unauthorized persons to take charge of the society and its assets. Stop. Nevertheless, rejecting the contentions of the authorities, 10 years delay were condoned, and the order of cancellation of registration was set aside by the state government, by order dated 28/7/2017. The senior counsel would therefore submit that such being the case, when benefit has been granted to other cooperative societies which were similarly situated, the state government would not have rejected the petition filed under section 108 of the Act, comma, in respect of the petitioner society. Stop. Next para. Learned AGA reiterates the very same contentions that were raised by the authorities as found in the order dated 28/7/2017 in the case of Gopi Nagar House Building Cooperative Society, which was referred to by the learned senior counsel. So, the learned AGA submits that all the procedures contemplated under section 72 and 74, comma, in the matter of liquidation of the cooperative society has been followed, and thereafter the impugned order of cancellation of registration has been passed by the Deputy Registrar of Cooperative Societies. So, the learned AGA would also seek to contend that this writ petition filed at the hands of the first petitioner, Cooperative Society, which admittedly stands cancelled, whose registration admittedly stands cancelled way back in the year 2005, cannot be entertained, cannot be maintained. Stop. Next para. Having heard the learned senior counsel for the petitioners, the learned AGA for the respondent authorities and the state, and on perusing the petition papers, this court finds that the benefit granted to a similarly placed cooperative society, namely Gopi Nagar House Building Cooperative Societies, as pointed out by the learned senior counsel, could not have been denied to the first petitioner, Cooperative Society. So, difference in the two cases. So, it is true that the society has not been conducting its business since long ago. Nevertheless, this court cannot ignore the fact that immovable property measuring about 8 acres have been granted to the first petitioner, Cooperative Society, at the hands of the respondent state government. Stop. This, in the considered opinion of this court, places the first petitioner society on a higher pedestal when compared to the case of Gopi Nagar House Building Cooperative Society. Stop. Although orders are passed under section 72 and 74, liquidating the assets of the first petitioner cooperative society, nevertheless, it is evident from the material available on record that the immovable property continues to be in the name of the petitioner cooperative society. In that view of the matter, it is also clear that the provisions contained in sections 72 and 74 of the Act in the matter of liquidation has not been followed. Stop. If the provisions were truly followed, then necessary action would have been taken to liquidate the assets of the society, more particularly the immovable property which is owned by the society. Stop. Therefore, the learned senior counsel is right in submission that having regard to Article 14 of the Constitution of India, the respondent state government have denied the benefit granted to another similarly situated cooperative society whose registration was cancelled and in a revision petition filed under section 108, delay of more than 10 years were condoned and the order of cancellation was quashed and set aside. Stop. On the grounds of principles, on the grounds of equality enshrined in Article 14 of the Constitution of India, this court is of the considered opinion that the benefit given to Gokinagar House Building Cooperative Society, as noticed herein above, is also required to be given to the petitioner cooperative society. Stop. The contention of the learned AGA that the first petitioner cooperative society would not have maintained this writ petition, even if accepted, the petition is still maintainable at the hands of the members of the cooperative society in the form of petitioners number 2 to 6. Stop. Next paragraph. For the reasons stated above, this court proceeds to pass the following order. 1. The repetition is allowed. 2. The impugned orders dated 12/5/2005 at Annexure C, 14/3/2016 at Annexure J, and 22/6/2018 at Annexure K are hereby quashed and set aside. Stop. Consequently, the order passed by the Honorable Minister for ಅಲ್ಲ ಇದು ರಿವ್ಯೂ ಒಂದಿದೆ ನೋಡಿ annexure L.
That's the review.
So this order is passed by the Honorable Minister. Of the Department of Cooperation at annexure L dated 9/12/2020 is also set aside, passed and set aside. Stop. Next. The third and fourth respondents, namely the the Deputy Registrar of Cooperative Societies, fourth respondent, and the concerned Assistant Registrar of Cooperative Societies are hereby directed to ensure that the first petitioner cooperative society is revived while appointing a returning officer to hold elections to the board of directors of the first respondent cooperative society as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a certified copy of this order. Stop. Ordered accordingly.
Can you look at application at 2:30 PM matter, number 49, Society?
Madam, with regard to the deliberations which took place before your lordships yesterday, this morning, Lord, the meeting has been held with the Chief Minister. I may only request lordships to have it on Monday, but we're contemplating some decision. Today, Lords, there was some difficulty. They had to leave from court. Kindly have it on Monday. Form lordships, what is the view the government wants to take?
Anyway, see, I can even express what is running in my mind.
Yes.
Ultimately, the democratic process that is contemplated under section 14, that has to be given effect. A decision can be taken only by the members of the society.
True.
So the state government, even in its advisory capacity, if it wants to advise them accordingly,
yes,
let it do it.
Yes.
and permit the members to take a decision in the manner contemplated under section 14. ಇಲ್ಲಾಂದ್ರೆ ಏನಾಗುತ್ತೆ, if you go on trying to prosecute these matters, ultimately no decision will be taken, and the urgency with which the state government wants to give effect to this, even that will not happen. This is what is going in the interest of the general public.
The observations of your lordships as a proposition. In this case, of course, the stand of the government is, of course, we have expressed. It is the 16-17 resolution, 17-18 resolution, which crosses the 40. Anyway, that is something which we have submitted before a lordship. But after having made that statement, the contention of the petitioner calling into question Annexure G, we have contemplated something, but I want to place before a lordship on Monday and see whether the petition will survive at all. But we want to see after that lordship might cancel.
The learned Advocate General submits that due to some unavoidable circumstances, he was not able to get instructions, and therefore,
Some discussion is on. Discussion is some discussion we have had. So therefore, Monday, lordship.
the learned Advocate General would submit that some discussions are taking place in this regard at the highest level, and would therefore request this court to take up this matter on 4th of April 2022.
Tuesday, lordship. So that's in case or not, if there is some, because there is some function which is taking place. But Tuesday, lordship. Only as an abundant precaution. Not
5th of April. Next para. Learned Senior Counsel Shri Jaykumar S. Patil, graciously accepts the submission made by the learned Advocate General. Stop. Next para. Consequently, release this matter on 5th of April at 2:30. Yes.
Because the petitioner is working as superintendent engineer, in which post he has been placed as in charge chief engineer in the BBM. Plus by page 295, picture yes. On NR Ramesh, he makes a complaint to the Anti-Corruption Bureau about the work order that was issued on 8/3/2019, which my lords will get the date at page 296. End of the first paragraph, he mentions MS Venkatesham Guttike Kararu Guttike Karar Patra Madakundu ದಿನಾಂಕ 8/3/19 ಆತನಿಗೆ ಕಾರ್ಯದರ್ಶಿ ಪತ್ರವನ್ನು ನೀಡಿತು. Then my lords, he points out whether real or imaginary, that is something that has to be done by the investigation. And at page 302, he accuses everybody, commencing from the commissioner and down. Now, my lords, on the basis of this complaint dated 14th December 2020, the ACB writes to the state government on 24/23/2021. My lord should get the date at page 17. Annexure A, page 7. Now, lords, without any scrutiny, because, my lords, on establishment of ACB, the state government issued a circular in August 2021. When any complaint is sought to be referred to ACB, the concerned department or the competent authority has to carry out internal scrutiny, arrive at a conclusion that there is a prima facie case to investigate, and thereafter only it can address the inquiry to ACB. Meanwhile, my lords, the Prevention of Corruption Act was amended by insertion of section 17 capital A with effect from, my lords, the 26th July 2018. There, my lords, before registering any even an FIR or commencing an investigation, it is now mandatory in cases where an element of exercise of discretion is involved, whether discretion is bona fide or malified, or whether it attracts the problems of Prevention of Corruption Act. Legislature has now incorporated a mandate with effect from July 2018. Authority competent to remove that public servant will have to apply its mind. Thereafter, give a sanction or prior approval to commence the investigation. Only thereafter, investigation or FIR and all that can start. It attracts application. Now, let's kindly see Annexure A. Annexure A, government what they say is, Superintendent of Police has scrutinized the complaint and sought our permission. Therefore, we are granting it. That is totally contrary to what the Supreme Court said in Yashwant Sinha's case, where kindly I will look at it. At page, there is paragraph 116. That is at page 391, last but one page. It is a concurring opinion of Lordship Justice K.M. Joseph. One of the reasons that was given by the Supreme Court for dismissing the writ petition filed by Yashwant Sinha and others was that you have approached this court seeking registration of an FIR and investigation. That cannot be done by this court. Prior sanction of the competent authority is required. Authority competent to remove that public servant from service. Therefore, it is for you to make a complaint. On that basis, if the Anti-Corruption Bureau, in that case it was CBI or whatever it is, if they are satisfied, they can write to the competent authority. Competent authority, if it is satisfied, it will give the sanction. And this judgment, a coordinate bench of this honorable court had an occasion to consider. And it said, application of mind by at the hands of the competent authority is of the same standard as is required under section 19 after investigation. Only thing is, after the investigation, when sanction is to be given for prosecution, witness statements, all those things will be done. But at the time when you are giving prior approval for commencement of investigation, at least you are required to verify the files and scrutinize. If that scrutiny is carried out, in this particular case, my client was not at all in that portfolio at that point of time. He occupied the post for 1 month during the leave period of the regular officer in that department. 20th, he was to be specifically 22nd October 2018 to 22nd November 2018. He was there.
Where have you stated so?
That they have stated is in the writ petition, it is said, I have produced the order sheet also, order sheet of the para 10. Para 7 at page 8, I have said, I was in the office from 22/10/2018 to 21/11/2018. Then at para 10, it is submitted the petitioner has given up the charge of the chief engineer in charge when the incumbent chief engineer returned to the office on 22/11/2018. During that 1 month period that I was there, all that I have done is executive engineer put up the bids before me, and I ordered Manoj, that is at page 110. I have ordered Manoj, this matter has to be placed before the notice commences to page 98, annexure H. All that I have done in the entire file is page 110, last paragraph. Previous page, chief executive engineer puts up the matter to me for acceptance of the tender. I said no. I said competent authority is, my lord's page 110, last paragraph I will read. ಸದರಿ ದರಗಳನ್ನು ಮತ್ತು HMP ಸ್ಥಾಪನೆ ಹಿತದೃಷ್ಟಿಯಿಂದ ಹಾಲಿ ನಗರೋದ್ಯಾನ ಯೋಜನೆಯ ಕಾಮಗಾರಿಯ ಟೆಂಡರ್ ಪರಿಶೀಲನಾ ಸಮಿತಿಯ ಮುಂದೆ ಮಂಡಿಸುವುದು ಸೂಕ್ತವೆಂದು ಅಭಿಪ್ರಾಯಿಸುತ್ತಾ ಸದರಿ ಟೆಂಡರ್ ಅನ್ನು ಮಾನ್ಯ ಆಯುಕ್ತರವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ರಚಿತವಾಗಿರುವ ಟೆಂಡರ್ ಪರಿಶೀಲನಾ ಸಮಿತಿ ಮುಂದೆ ಕಡತವನ್ನು ಮಂಡಿಸಲು ಕೋರಿ ಪ್ರಸ್ತಾವನೆ ಅಥವಾ ಸಾರ್ವಜನಿಕ ಕಾಮಗಾರಿ ಸಮಿತಿ ಪಾಲಿಕೆ ಸಭೆ ಮುಂದೆ ಪ್ರಸ್ತಾವನೆ ಮಂಡಿಸಲು ಅನುಮೋದಿಸಿದೆ. Thereafter, at para 40, commissioner orders to place it before the council. It goes, and meanwhile I would have also have gone out of that department. And ಏನಲ್ಲೇ ಅವರು ಏನು ಸ್ಕ್ರೂಟಿನೈಸ್ ಮಾಡೋದಿಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಫ್ ಪೊಲೀಸ್ ಹ್ಯಾಸ್ ಸ್ಕ್ರೂಟಿನೈಸ್ಡ್. To entrust to them, we have to scrutinize ಅಂತ ಲಾ ಹೇಳೋದು. Therefore, I will start stay of further proceedings pursuant to annexure.
Where this page paragraph 116 ಅಲ್ಲಿ you wanted to point out something.
There is one of all that I have said is there is 116
of the judgment.
Of the judgment. Yes. Of the judgment. 116 section 17 capital A is extracted.
Yes.
117 months. In terms of section 17 capital A, no police officer is permitted to conduct any inquiry or conduct investigation to any offence done by a public servant where the offence alleged is relatable to any recommendation made or decision taken by the public servant in discharge of its public functions without previous approval inter alia of the authority competent to remove the public servant from his office at the time when the offence was alleged to have been committed. In respect of the public servant who is involved in this case, it is clause C which is applicable. Unless therefore there is previous approval, there could be neither inquiry or investigation. It is in this context opposite to notice that complaint which has been filed by the petitioners in petition number so and so moved before the first respondent CBI is done after section 17A was inserted. The complaint is dated 4/10/2018. Para 5 sets out the relief which is sought in the complaint, which is to register an FIR under various provisions. Para 6 and 7 of the complaint are relevant in the context of section 17 capital A, which reads as follows. That part may be omitted. Para 118. Therefore, the petitioners have filed the complaint fully knowing that section 17A constituted a bar to any inquiry or investigation unless there was prior approval. In fact, a request is made to at least take the first step seeking permission under section 17A of the 2018 Act. Writ petition number 298 was filed on 24/10/2018 and the complaint is based on non-registration of FIR. There is no challenge to section 17 capital A. Under the law as it stood both on the date of filing of the petition and even as on today, section 17A continues to be on the statute book and it constitutes a bar to any inquiry or investigation. Petitioners themselves in the complaint request to seek approval in terms of section 17 capital A. But when it comes to the relief sought in the petition, there was no relief claimed in this behalf. Even proceeding on the basis
but ಇದರಲ್ಲಿ permission ತಗೊಂಡಿದಾರಲ್ಲ.
So permission is bad ಅಂತ ಹೇಳಿದ್ರೆ ಇವರು ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಬೇಕಾಗುತ್ತೆ.
ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
ಅದರ ಬಗ್ಗೆ ಇಲ್ಲ. ಅದರ ಬಗ್ಗೆ the coordinate bench has taken a view. That is one of in this on this appeal is also not filed. That judgment has become final. There is one of Praveen Kumar Megaikar case. Has followed the my lords would turn to page 18, my lords. Circular dated 24/8/2016 issued by the state government is extracted. ಅದರಲ್ಲಿ para 3 reads like this. ಆದುದರಿಂದ ಇನ್ನು ಮುಂದೆ ಸರ್ಕಾರದ ಇಲಾಖೆಗಳು ತಮ್ಮ ಇಲಾಖೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿ ಅಧಿಕಾರಿಗಳ ವಿರುದ್ಧದ ಪ್ರಕರಣವನ್ನು ಭ್ರಷ್ಟಾಚಾರ ನಿಗ್ರಹ ದಳಕ್ಕೆ ತನಿಖೆಗಾಗಿ ವಹಿಸುವ ಮುನ್ನ ತಮ್ಮ ಹಂತದಲ್ಲಿ ಆಂತರಿಕ ಪರಿಶೀಲನೆ ಇಂಟರ್ನಲ್ ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿ ಸಂಬಂಧಪಟ್ಟ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಗಳ ಅನುಮೋದನೆ ಪಡೆದು ನಂತರವೇ ಪ್ರಕರಣಗಳನ್ನು ಭ್ರಷ್ಟಾಚಾರಕ್ಕೆ ನಿರ್ವಹಿಸುವುದು. And it is held, my lords, that after analyzing that, it is held that the para 24, page 22, about 17A it is mentioned. Then what was the sanction order given? That is extracted at para 25. Then, my lords, para page 26 only, law is stated. In that particular case, facts they had been exonerated Department of Inquiry. Para 26 only, declaration, formation of opinion by the statutory authority while granting prior permission to section 17A should reflect application of mind with reference to the material available on the ground. Adinda fatal and there is no such application of mind and approval order is set aside. The starting point of this application of mind by the sanctioning authority came in Veeraswamy's case, Lordship Justice Veeraswamy's case. Whether the High Court judge is public servant for the purpose of prevention of corruption. That not grave apprehensions were expressed because if prayer sanction in the other, what will happen? And not Supreme Court said, Lordship Justice Jagannath Shetty speaking for the Constitutional Bench, he said, it is the duty of the authority competent to remove him from service to protect him if his actions are bona fide. Therefore, what he has to do, 1, 2, 3, 4, 5. Then what happened was in Subramania Swamy's case, an executive order had been made for joint secretary and above and central government. This procedure has to be followed. That was set aside by the Supreme Court, saying that why only joint secretaries and above. Either all public servants are equal, either all of them are entitled for reserve for that protection, or none of them is entitled for that protection. Thereafter, the 17 capital A was introduced with that. That is the history of this.
Learned AGA takes notice for response number 1 and 3. 1. ಇವ್ರಿಗೆ ಯಾರು ಪೇರ್ ಹಾಕ್ತಾರೆ? ACBಗೆ ಮನಮೋಹನ್. Learned counsel. Learned counsel.
May I submit, my lord? May I submit, my lord? I am representing Mr. Manmohan PN. With your lordship permission, my submission is that as per the petition, my lord, my learned friend submitted that the petitioner was in charge as chief engineer from 22/10/2018 to 21/11/2018.
Yes.
Now, your lordship may kindly see page 105, my lord. And this tender opening actually happened on 2/11/2018. That is when he was in charge as chief engineer. Page 105, my lord. There on top, the Muru Nalku, ಟೆಂಡರ್ನ ತಾಂತ್ರಿಕ ಬಿಡ್ ತೆರೆಯುವ ದಿನಾಂಕ 2/11/2018 ಸಂಜೆ 4:30 ನಂತರ. So that was done on that day. Then if you
One second. 2/11/2018.
Yes, my lord. Then the page 106, my lord, just after the ullekha, after that it says ಖಂಡಿಕ 17ರಿಂದ 21ರವರೆಗಿನ ವರದಿಯನ್ನು ಅವಗಾಹನೆಗೆ ತರುತ್ತಾ ಉಲ್ಲೇಖ 1ರ ಟೆಂಡರ್ ನೋಟಿಫಿಕೇಶನ್ ನಂತೆ ಸರಕು ಮತ್ತು ಸೇವೆಗಳು ಒದಗಿಸಲು ಟೆಂಡರ್ ಆಹ್ವಾನಿಸಲಾಗಿರುತ್ತದೆ. ಮಾನ್ಯ ಮುಖ್ಯ ಅಭಿಯಂತರು, ದಟ್ ಇಸ್ ದಿ ಪಿಟಿಷನರ್, 22ರ ಖಂಡಿಕ 22ರಲ್ಲಿ ಇಬ್ಬರು ಬಿಡ್ದಾರರಾದ ಶ್ರೀ MS ವೆಂಕಟೇಶ್ ಮತ್ತು ಶ್ರೀ M ವೆಂಕಟಚಲಪತಿರವರ ತಾಂತ್ರಿಕ ಬಿಡ್ ಅನ್ನು ಅನುಮೋದಿಸಿ. Because he recommends that technically these two bidders, their bids are valid from the technical point of view. Because if your lordship can go back to 105, in the first bidder, he is tantrikavagi anarharagirtare. So after two bidders who are technically approved, then he was that was the financial bid later, that thereafter the financial bid was opened on 16/11/18. That's what that paragraph in 105(6) says.
It's all right, but that is all.
Yes,
we'll have to go into all these aspects only at a later stage.
Exactly.
Now the basic contention of the learned senior counsel is that yes,
the application of mind, my lord. Now whether the impugned order, the annexure A, whether it has been passed with the application of mind.
Yes.
Now if your lordship can see page 17, annexure A, the first paragraph after the ullekha, then ಇದರಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ಗುತ್ತಿಗೆದಾರರಿಂದ ನಿಯಮಬಾಹಿರ ಕಾರ್ಯಗಳು ನಡೆದಿರುತ್ತದೆ. Before going to that, my lord, what is application of mind? I think my learned friend would refer to he was referring to the decision of the coordinate branch of this honorable court, my lord. But
yes,
what is application of mind is actually giving reasons for that. That's what it means. Now in page 17, they have page 17 and 18, the annexure A of annexure A, 4 reasons are given.
Yes.
Now 4 reasons are given. Why? So it says in the last, I'll not take your lordship's time reading the entire this thing. In the last 3 lines in page 17, ಈ ಮೂಲಕ ಕನಿಷ್ಠ 3 ಕಿಲೋಮೀಟರ್ ಉದ್ದದ ರಸ್ತೆಗಳ ನಿರ್ವಹಣೆ ಕಾರ್ಯವನ್ನು ಸಂಬಂಧವೇ ಇಲ್ಲದೆ ಶ್ರೀ MS ವೆಂಕಟೇಶ್ ಎಂಬ ಗುತ್ತಿಗೆದಾರನಿಗೆ ಲೂಟಿ ಮಾಡುವ ಸಲುವಾಗಿಯೇ ಸೇರಿಸಲಾಗಿದೆ ಎಂಬುದು ಅತ್ಯಂತ ಸುಸ್ಪಷ್ಟವಾಗಿದೆ. This statement by the authority which granted this approval cannot be without any inquiry, my lord. Then if your lordship can kindly go to page 18, ಇದೇ ಕರಾರು ಪತ್ರದಲ್ಲಿರುವ ರಸ್ತೆಗಳಲ್ಲಿನ ಗುಂಡಿಗಳನ್ನು ಮುಚ್ಚುವುದಕ್ಕೆ ಬಳಸಿಕೊಂಡಿರುವ ಪೈಥಾನ್ ಮೆಷಿನ್ ಕಾರ್ಯಗಳಿಗೂ ಸಹ 2020ರ ಆಗಸ್ಟ್ ತಿಂಗಳವರೆಗೆ ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿದೆ.
ಅದಲ್ಲ ಅವರು ಬರೋದಿಲ್ಲ ಅದು. This cannot be imputed to the petitioner.
No. What I'm saying is
only
that
now what you have pointed out is that
yes, my lord.
The petitioner,
yes, my lord,
was of the opinion that the financial bid of 2 persons,
yes, my lord,
2 persons,
yes, my lord,
can be approved.
Yes. No, technically
can be considered.
Yes.
That is the opinion.
Yes, my lord.
That is the opinion. Yes.
Yes, my lord.
Ad bitre bere enide.
No. My submission is this, my lord. My learned friend's argument is that this annexure A was passed without application of mind. What
Correct.
application of mind means is that giving reasons. Now,
Correct.
this annexure A, the 4 points which I read, my lord, on page 17 and 18, these are the reasons based on which the authority granted approval.
Sir, please understand that
yes,
this order is in respect of how many persons? 1, 2, 3. 3 persons. 3 persons plus other 27 bitpade. 3 persons.
Yes, ma'am.
So when the petitioner is contending,
yes, ma'am,
that I was holding that post as an in charge chief engineer only for a particular period,
yes, ma'am,
1 month. What is it that the authority has found about that one?
That's exactly what I'm.
Please point out, sir.
Now, my lord, the annexure A is in respect of not 3 persons. It is in respect of 1 person only.
No. Please read the order, sir.
My lord, if your lordship can.
No. In that case, it will be even more difficult.
My lord,
if you say if it is only in respect of this person,
yes,
then it will be even more difficult. Then.
My allegations are proved.
My lord, if your lordship can see. The ಇಬ್ಬರು ಗುತ್ತಿಗೆದಾರ ಭಾವಿಸಿ ಈ ಪೈಕಿ ನಿಗದಿತ ಮೊತ್ತಕ್ಕಿಂತ 48.39% ಅಷ್ಟು ಕಡಿಮೆ ಮೊತ್ತವನ್ನು ನಮೂದಿಸಿದ MS ವೆಂಕಟೇಶ್ ಎಂಬ ಗುತ್ತಿಗೆದಾರನಿಂದ ನಿಯಮ ಬಾಹಿರವಾಗಿ ರಸ್ತೆ ಗುಂಡಿಗಳನ್ನು ಮುಚ್ಚುವ ಗುತ್ತಿಗೆಯನ್ನು ನೀಡಲಾಗಿತ್ತು. ಸೊ ಇದರಲ್ಲಿ ಈ ಕೆಳಗೆ ಕಂಡಂತೆ ಅದಕ್ಕೆ not here the question is it's not just 3 persons, there are about 27 persons of various departments who have been proceeded with. I mean the ACP is seeking proceeding against them. Now, my lord, if your lordship can see, the estimated expense for cost of the project was 7.35 crores, whereas he gets it for, these are all matters for evidence at the trial, at the time of trial. Now, the question whether the annexure A has been passed by application of mind or not, this is the annexure A very clearly gives the 4 reasons. Very clearly gives 4 reasons. And if your lordship can kindly go to page 19, the 5th line from there, page 19, my lord. BBMP ರಸ್ತೆಗಳ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳ ಇಲಾಖೆ 29 ವಿಭಾಗಗಳ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಇವರುಗಳ ವಿರುದ್ಧ ವಿಚಾರಣೆ ತನಿಖೆ ಕೈಗೊಳ್ಳಲು ಕಲಂ 17A ಭ್ರಷ್ಟಾಚಾರ ಪ್ರತಿಬಂಧಕ ಕಾಯ್ದೆ ಸೊ ಅಂಡ್ ಸೊ ಹಾಗೂ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೊ ಅಂಡ್ ಸೊ ದಿನಾಂಕ 14/3/26 ಖಂಡಿಕೆ 5ರಂತೆ ಪೂರ್ವಾನುಮತಿ ನೀಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. Then these are the common, these are matters which have to be investigated, my lord.
All right. Yes,
yes,
sir. All right. Yes,
please, man.
Hello.
Sorry. It is not.
There is no application of mind.
And the circular there refers 24/3/2016.
Yes.
It has nothing to do with the prevention of corruption. That circular also, I did not want to humiliate them by quoting that. Just to reckless ag ಮಾಡ್ತಾರೆ ಅಂತ 24/3/2016 circular is the circular establishing ACP. It has nothing to do with the grant of prayer of they have to scrutinize the complaint and not engage in this letter.
All right. BBMP ಯಾರು ಬರ್ತಾರೆ?
DBMP.
Learned Council Miss DJ Rakshita is direct to take notice for respond number 2. Learned Council Shri P.N. Manmohan has entered appearance for respond number 3 by filing a caveat. Stop.
Memo of appearance, my lord.
There is no caveat. He has entered appearance for respond number 3. Sorry, has entered appearance for respond number 3.
Please.
I don't know how you could enter appearance without even the court issuing notice.
Section 17A was introduced to protect the civil servants from the wrath of the courts.
I was under the impression that you had filed a caveat. That is why I heard you.
No, man.
Learned Counsel for the petitioner is directed to serve 2 copies of the petition along with annexures on learned counsels for response number, on all the learned counsels for the respondents, comma, including the learned AGA. Next para. Learned senior counsel, Shri P.S. Rajgopal, comma, appearing for the petitioner, submits that the petitioner, who was the in-charge chief engineer of road infrastructure wing of the second respondent, BBMP, for a period of 1 month between 22/10/2018 to 21/11/2018, he sought to be proceeded against at the instance of the third respondent, Anti-Corruption Bureau, on the basis of a complaint said to have been made by one Shri N.R. Ramesh, comma, in his complaint dated
40/12/2020.
Stop.
Page 2795.
The complaint is in respect of irregularities in the matter of supply, installation, commission of asphalt hot batch mix plant, and supply of other equipments as listed in the REP document, and various bituminous mixes with operation and maintenance for 5 years. At survey number 50, Kannur village, stop. Allegations are made against many of the officers of the second respondent, BBMP, based on which the third respondent, ACP, wrote a letter dated 23/4/2021 to the state government requesting for permission to prosecute the petitioner and one Shri Srinivas, executive engineer, and 27 other unnamed persons. Stop. Learned senior counsel submits that in terms of section 17 capital A of the Prevention of Corruption Act, it is mandated that before sanction is granted, comma, the appropriate authority is required to bestow its attention and apply its mind to any complaint or a report submitted by the investigating by the police. Stop. In this regard, comma, the learned senior counsel has drawn the attention of this court to the impugned order dated 7/2/2022 issued by the first respondent state government granting sanction for prosecution in respect of the petitioner and the others, including 27 unnamed persons. Stop. The learned senior counsel submits that having regard to the fact that the petitioner was the in charge chief engineer only for a period of about 1 month between 22/10/2018 to 21/11/2018, comma, nothing is forthcoming to demonstrate application of mind, comma, at least in respect of the petitioner. Moreover, comma, the learned senior counsel seeks to place reliance on a decision of a coordinate bench of this court in the case of Praveen Kumar Megharik and another versus State of Karnataka and others in WP number 200356 of 2021, dated 26th of March 2021. Stop. The coordinate bench, having noticed the provisions contained in section 17 capital A of the Prevention of Corruption Act, comma, has held that formation of opinion by the statutory authority while granting prior permission under section 17 capital A should reflect application of mind with reference to the material available on record. Stop. The learned senior counsel has made out a prima facie case. Full stop. Consequently, there shall be an ad interim order of stay of the operation of the impugned order dated 7/2/2022 at annexure A, comma, insofar as the petitioner is concerned, comma, till the next date of hearing. Learned counsel for the petitioner has filed a memo dated 29/3/2022 seeking leave of this court to withdraw the petition with liberty to file a fresh petition. Stop. However, no reason is assigned as to why liberty should be granted to the petitioner to file a fresh petition. Full stop. Next, consequently, the petition stands dismissed as withdrawn. Full stop. Ordered accordingly.
Number 32.
Mandate number 3 filed for vacating the stay order. And is not only a formal party to the proceedings. In fact, I am not ready in this matter, so that it may be taken up for the disposal also.
Who is the contesting respondent?
Respondent number 4 is the contesting society.
Society.
Yes.
Or served unrepresented.
Yes.
Huh? Mate? Yen matira?
The respondent number 3 is formal party. Anyway, it may be taken up for final disposal.
Final disposal, avare ilvalri. Contesting respondent illa. The matter about. You were working there, is it?
Yes.
Huh?
I was working.
You were working.
I retired in the year 2012.
But you don't want the presence of the contesting respondent.
Yes.
Why don't you take out hand summons then?
Sir.
If you don't understand that much, I cannot help you, sir. Yes.
Even I can take the hand summons.
Without the presence of the contesting respondent, what order can be passed, sir?
Yes.
Although the contesting respondent number 3 is served and unrepresented, on the asking of this court, the learned counsel for petitioner submits that he would take out hand summons. Full stop. Consequently, the petitioner is permitted to take out hand summons to respondent number 3. Respondent number 4.
Society.
Respondent number 4. Respondent number 4. 3 and 4.
3 filed their
hand summons. Respondent number 4, within a period of 1 week from today. Yes.
Anyways.
Stay.
Yes.
Last time we extended Marskondilla. The interim order granted on 30/11/2021 stands extended until further orders.
Petitioner and respondent number 627. The petitioner was working as a secretary of the respondent 4 society.
It has come up for service of notice on some of the respondents.
Now, because of the input matter of the deputy stars,
69
proceedings are initiated with the assistant star only against me. Entire 32 lakhs he is claiming. The appeal is made by respondent to 627 without depositing 25% of the order amount. Section 1 order is passed contrary to section 106 bracket 6 of the Karnataka Cooperative. If an appeal is filed by the parties, they have to deposit 25% of the order amount before the deputy. The respondent number 627 admittedly did not deposit. Whereas I have filed an appeal questioning the very same order. Annexure of endorsement is issued. Annexure of endorsement, page number 46. Our appeal fail 25% ಕಟ್ಟಬೇಕಾಗಿಲ್ಲ. ನಾನು ಅದೇ ಆರ್ಡರ್ ಪ್ರಶ್ನೆ ಮಾಡಿ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. Page number 34 of the informing order and should be passed by the deputy commissioner.
One not six, six.
Six. Endorsement ಎಲ್ಲ ರೆಫರ್ ಮಾಡಿ.
But that is the provision.
Yes. The respondent number 6 to 27 who questioned the order passed on section 68 by filing an appeal on section 106 admittedly did not deposit. Let them not deposit. Whereas I have filed appeal questioning the very same order. The annexure fees issued by the deputy.
Correct, sir. That is the provision, sir.
ಹೌದು ಅವ್ರ ಅಪೀಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಅಲ್ಲ, ಅವ್ರ ಅಪೀಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
We are not concerned with that one. We are concerned with your appeal.
Please, madam.
If there is a mandatory requirement of pay.
No, I have not filed this percent questioning annexure. I have filed this percent questioning annexure D.
Annexure D.
Annexure D. According to the respondent authorities, 32 lakhs misappropriated by the petitioner and respondent 6 to 27 as per instruction as per section 68 order also. Now, because of the passing order particular annexure D, absolving respondent 6 to 27 from liability, entire amount the assistant star is claiming from me by initiating section 69. Whereas according to reports, they have also misappropriated.
Annexure D.
D is the order passed by the deputy star, absolving the liability of respondent 6 to 27. Absolving.
But you are also a party to that proceedings.
I was respondent.
Then
I opposed the appeal.
Correct.
Opposed the appeal. Now because of this order, now the attendant star initiated proceedings to recover entire amount from me only. From you only. Whereas the report says they have also misappropriated 32 lakhs. Not only the secretary, then directors, ex-directors.
Sir, what is it that you want now?
No, annexure D may be stayed for a limited period. Annexure D. Annexure D. Order passed by the deputy star. Annexure D.
Questioning this, this is an order passed under section 106.
106. It's 106H. Order of the registrar, section 68. I produced the order to page number 30.
Kenama, what is the reason that everything is now put on this person? Adalla. Annexure D. Annexure D was an appeal filed by the other persons against whom allegations were made. That appeal is allowed while this person was the fifth respondent therein, and all the monies is said to be required to be recovered from this person. What is the reason for that? So there is some reason for that. There's some reason for that.
The inspection report implicates petitioner and respondent 6 to 27. Inspection report.
Sir, but you will not be able to get any relief if you are questioning only Annexure D. Annexure D is an appeal filed by those other persons. Whereas you also filed an appeal under section 106, and you were asked to deposit the
25%
that is in terms of the mandate.
Mandate.
If you provide, they will consider your appeal.
No, that is not the subject matter of this requisition. One submission.
What is the use of challenge this Annexure D, sir?
Page number 38, my letter from Dread, para number 16 end.
Yes.
ಅನ್ವಯವಾಗುತ್ತೆ ಎಂಬುದನ್ನು ಒಂದನೇ ಸಾಬೀತುಪಡಿಸಲು ವಿಫಲರಾಗಿರ್ತಾರೆ. ಒಂದನೇ ಎದುರುದಾರ ನಾನಲ್ಲ, ಪರಿವೀಕ್ಷಣಾಧಿಕಾರಿ ಇನ್ಸ್ಪೆಕ್ಟರ್.
ಅದಲ್ಲ ಸರ್. Last paragraph in page number 38.
Page number 38. ಮುಂದುವರೆದು ಸದರಿ ಪರಿವೀಕ್ಷಣಾ ವರದಿಯು ವಿವರಗಳನ್ನು ಎರಡನೇ ಎದುರುದಾರರು ಪೂರ್ಣವಾಗಿ ಪರಿಶೀಲಿಸದೆ ಮೇಲ್ಮನುವಿದಾರರು ಲೆಕ್ಕಪತ್ರಗಳ ಅಭಿರಕ್ಷಕರಾಗಿಲ್ಲದಿದ್ದರೂ ಸಹ ನೇರವಾಗಿ ಅವರನ್ನೂ ಸಹ ಜವಾಬ್ದಾರನಾಗಿ ಮಾಡಿರುವ ಕ್ರಮ ನಿಯಮಬಾಹವಾಗಿರುತ್ತದೆ.
ನೆಕ್ಸ್ಟ್ ಓದಿ.
ಕೇಂದ್ರ ಸರ್ಕಾರ ಸಾಲ ಮನ್ನಾ ಯೋಜನೆಯಲ್ಲಿ ಕ್ಲೈಮು ಬಿಲ್ ಅನ್ನು ತಯಾರಿಸಿ ಯೋಜನೆಯ ಲಾಭ ಪಡೆದಿದ್ದವರು ಹಾಗೂ ಸಂಘದ ಅಂತಿಮ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳು ಜಂಟಿಯಾಗಿ ಹೊಣೆಗಾರರಾಗಿರುತ್ತಾರೆ. ಕಾರಣ ಕ್ಲೈಮು ಬಿಲ್ ಅನ್ನು ನಿಯಮಬದ್ಧವಾಗಿ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಗಳ ಇತಿಮಿತಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿ ಕ್ಲೈಮು ಪಡೆಯುವ ಜವಾಬ್ದಾರಿಯು 5ನೇ ಎದುರುದಾರರಿಗೆ ಸೇರಿರುತ್ತದೆ. ಕ್ಲೈಮ್ ಪಡೆಯೋದು ನಮ್ಮ ಜವಾಬ್ದಾರಿ.
ಇದನ್ನ ಸ್ಟೇ ಮಾಡಿದ್ರು ನಿಮ್ಗೇನು ಅನುಕೂಲ ಆಗಲ್ಲ.
ಆಗುತ್ತೆ ಸರ್, ಅಲ್ಲಿ
ಇಲ್ಲ
ಏನಾಗುತ್ತಂದ್ರೆ
ನೋ ಸರ್, ದಿ ಒರಿಜಿನಲ್ ಆರ್ಡರ್ will still be on you.
No.
This is an order in appeal.
Yes.
The original order is there.
No, original order is passed on 68.
Correct.
68.
That is there.
Basing on order passed on 68.
No, because challenge ಮಾಡಿ ಪ್ರಯೋಜನ ಇಲ್ಲ.
No, because of this order, the deputy has set aside the order passed on section 68.
No, sir.
Yes.
Sir, that has to be considered in your appeal.
No. ಆದೇಶ ಓದ್ಬಿಡ್ತೀನಿ. ಆದೇಶ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಇರಲ್ಲ. ಆದೇಶ ಏನ್ ಮಾಡ್ತಾರೆ, ಮೇಲ್ಮನವಿದಾರರು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ 106 ಮೇನವನ್ನು ಪುರಸ್ಕರಿಸದೆ ಪ್ರಕರಣದಲ್ಲಿ ಎರಡನೇ ದೂರುದಾರರು ಹೊರಡಿಸಿರುವ ಪ್ರಕರಣ 68 ಆದೇಶ ಸಂಖ್ಯೆ ಸ್ವಾಂಡ್ಸು ದಿನಾಂಕ 3/6/2001 ಕೇವಲ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಸಂಬಂಧಿಸಿದ ಮಾತ್ರ ರದ್ದುಗೊಳಿಸಿ ಆದೇಶ.
Correct. ಅವ್ರದ್ದು to the extent of those appellants, it is quashed.
Now
the entire allegation is only against you.
That is true, not. But
so ನೀವು ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಏನ್ ಬರುತ್ತೆ?
ಅಲ್ಲ 60
ಆರ್ಡರ್ ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ನಿಮ್ಗೇನ್ ಲಾಭ?
ಅಲ್ಲ ಇನ್ಸ್ಪೆಕ್ಷನ್ ರಿಪೋರ್ಟ್.
You want the others also to be with you and share the difficulty.
My contention before the deputy star and assistant star, as per the directions of the managing committee, I have acted.
Sir, do you want to deposit 25% and go on with the matter or not? ಆಗಲ್ಲ ಅಂತಂದ್ರೆ ಬಿಟ್ಬಿಡಿ. I will issue notice and keep quiet. Learned AGA takes notice for response number.
Already ಆಗಿರುತ್ತೆ.
ಆಗಿದೆಯಾ?
ಸರಿ.
Why it's
I have more because of the assistant star is proceeding early. My 69% against me.
ಹೌದು. ನೀವು appeal file ಮಾಡಿದ್ರು, if you don't want to deposit the mandatory deposit, what can they do then?
No.
You have to deposit and take the order. Or if there is any provision for condonation of judgment.
Submission. Deputy star discriminated between respondent 6 to 27 and me. They filed an appeal questioning the order passed on section 68.
Therefore,
they do not want to.
If there is any provision by which we can direct the authority to waive off that mandatory requirement of deposit, you please point out.
There is no that provision, but the same provision not applied by the deputy star to.
ಆಗೋಯ್ತು ಸರ್ ಅವ್ರದ್ದು ಕೆಲಸ. ನೀವು ಅದನ್ನ ಹಿಡ್ಕೊಂಡು ಏನು what is it that you are going to get?
No, because of the assistant star has initiated proceedings 16 and only against me.
A week's time is granted to take steps in respect of response number 4, 5, 8 and 11. Yes.
Next date of hearings.
ಬರಲ್ಲ.
34 Vishnu Agada.
This 1 week time, my lordship, and I want to place affidavit Union of India as filed in Bombay High Court. Kindly have it on next week, my lordship. Place it on record.
Air India's matter, my lords, regarding posting the maintainability of this.
Oh, Air India.
Air India matter.
Oh, the affidavit file ಮಾಡಿದ Union of India detail affidavit 23 pages regarding maintenance and staffs, payment to salaries and take caring of the everything. Okay, I would furnish. That is the help me for the maintainability.
That is only for the period of 1 year. What is the arrangement? Air India has Union of
Sir,
India.
there is already a decision on this matter. The decision of the Delhi High Court.
Delhi High Court. Balco judgment.
Furnish that help us. Maintainability ಮೇಲೆ I'll go with the argument.
Because that is also a case related to privatization.
Wednesday, only Wednesday. Wednesday.
Huh?
Wednesday, next Wednesday. Based on that.
Although the matter was adjourned on the last occasion at the request of the learned senior counsel appeared for the petitioners to answer the question of maintainability of the writ petition. Learned counsel for the petitioner seeks for a short accommodation. We'll stop. Release this matter on 6th of April 2022. We'll stop. No further adjournments will be granted. We'll stop. The question of maintenance will be decided on the next date appeal.
Great. Much of it.
Respondent number 3, please. Respondent number 3, my lord, filed the application for a direction. My lord, December court, my lord, on 3rd December 2021, please, my lord, passed the interim order. The elections may be go on as scheduled, however, results thereof shall not be announced without the leave of this in this court. Accordingly, my lord, on 5th December 2021, my lord, the election was held to the respondent number 3 association. However, my lord, in order to order passed by December court, my lord, till now, my lord,
The results are not declared.
result not declared, my lord, in view of the interim order passed by the December court, my lord.
Yes.
Almost 4 months, my lord, has been elapsed. My lord, we have filed our detailed objections to the petition, please, my lord, on 4th January 2022, please, my lord. Respondent number 3 filed its detailed objections. My lord, the grounds of petitions, my lord, conducted the annual general body meeting and the elections on the same day. It is not conducted, my lord, as contended by the petitioner's hearing, my lord. Only elections was scheduled on 5th December 2021, and the general body meeting was postponed. And further, my lord, another ground, my lord, without the appointing the officials from the side of cooperation department, my lord, the election was said, my lord. It is also not correct.
Sir, it is as good as hearing the matter and disposing it finally.
Please, my lord, Monday or Tuesday, my lord, because of 4 months, my lord.
That is called out. There is no representation for the petitioner.
On the last occasion also, my lord, he did not turn up. Moreover,
release this matter on 7th of April.
Public.
This case, petitioner is a retired first division assistant. Lord, she has put in 40 years of service. Lord, on 31/5/2020, she retired. Even after 2 years, Lord, pensionary benefits are not settled. Presumably, Lord, on the reason that that order passed by the Honorable Court quashing Art 2014 Act is pending before the division bench. Lord, that is the reason, presumable reason, because I have not been informed as to the reason with which this benefit is withheld. So therefore, my lord, I have filed repeated representations to the respondents. Now, my lord, although my employer has forwarded the pension proposal to the respondent number 2 and 3, settlement pension is not being granted.
Yesterday, I have given the statement of objection. I could remember that.
Objection,
Lord, in this case, I have got the instruction that the treasury, the amount has already been released. Not it has gone to the treasury. That is only the.
Learned AGA submits on instructions that the pensionary benefits of the petitioner have been determined and directions are issued from the office of the accountant general. Stop. AGA therefore seeks for a short accommodation to secure further instructions. Full stop. Release this matter on 7th of April.
For the petitioner in this case, my lordship.
I'm appealing for the respondent number 2 and 3. We need to file for objection, seeking for a time 2 weeks.
In the death benefits, my lordship has not granted to the petitioner. The husband of
weeks are granted at the request of response number 2 and 3 to file statement of objections.
I may be permitted to serve the copy to government advocate, my lordship, in respect of respondent number 1.
Yes. In the meanwhile, learned counsel for the petitioner may serve a copy of the writ petition on the learned AGA.
Yes, my lord, I have received copy of a statement of objection filed by respondent, my lord. I want to file my rejoinder. Therefore, kindly post this matter on 21st April. In the meantime, I will file rejoinder and also serve copy to the respondent, my lord.
The petitioner
21st April,
seeks for a short accommodation to file rejoinder to the statement of objections filed at the hands of the respondent. Stop. A week's time is granted to do the.
No, my lord. 21st, ದಯವಿಟ್ಟು 21st ಏಪ್ರಿಲ್ ಕೊಡಿ my lord.
ಅಲ್ಲಲ್ಲ, ಒಂದು ವಾರದಲ್ಲಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ.
Yes, my lord. ಅಲ್ಲ
2 weeks ಬೇಕಾ?
15 days time ಕೊಡಿ my lord, ಸರ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವ್ರಿಗೆ, ಯಾಕೆಂದ್ರೆ ಪ್ರಿಪೇರ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ, 2 weeks are granted.
Yes, my lord.
Release this matter on 21st of April.
21st, my lord.
21st of April.
Yes, my lord.
Much obliged. Much obliged.
Okay. Much obliged.
Much obliged.
Yes.
ಯಾವ್ದು ಎಸ್ PTCL ಮ್ಯಾಟರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ನನಗೆಲ್ಲ ಮರ್ತೋಗಿದೆ.
ಅದೇ ಹೇಳ್ಬೇಕಂತೆ ಒಂದು
ಹಾ
ಸೇರಿ ಒಂದು ರಿಕಲೆಕ್ಟ್ ಮಾಡಕ್ ಒಂದು 15 minutes ನಮ್ ಕಡೆಯಿಂದ ಬೇಕು. ಇವ್ರ ಕಡೆಯಿಂದ ಸ್ವಾಮಿ ಸ್ವಾಮಿ if your lordship pleases, could it be taken on 5th, my lord?
Seventh,
7th to 8th to 11th, 12th, I'm not there. Otherwise, after 12th, my lord, it is not on 5th and 6th. 11th, 12th to ಇರೋದಿಲ್ಲ. 7th to 8th to 11th, 12th ಇರೋದಿಲ್ಲ. It could be on.
Sorry, I release this matter on 5th of April.
5th, great.
5th of April. Yes.
I have moved this matter last week, my lord. By inadvertently, cause list respondent advocate's name not shown in the cause list, my lord. My lord, I request my lord to take it on Monday. All our respondent advocate cause list ಅಲ್ಲಿ ಬಂದಿಲ್ಲ, ಹಂಗಾಗಿ ಅವರು ಗೌಳೆ ಅವರಿಗೆ ನೋಡಿ cause list ಅಲ್ಲಿ ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
ಫಾಂಟ್ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಂತ
cause list ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಮೈಸೂರು ಮೆಡಿಕಲ್ ಕಾಲೇಜ್.
ಮೈಸೂರು ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ತಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರಿ, DPC ಮೀಟಿಂಗ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಯಾರು? ಚಂದ್ರಕಾಂತ್
ಆರ್ ಗೌಳೆ. ಅವ್ರ ಗೌಳೆ ಮತ್ತೆ ನಾರಾಯಣ್ ಭಟ್ is appearing for impleading applicant. ಗೌರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ, DPC ಮೀಟಿಂಗ್ ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ. ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಓನ್ಲಿ AGA R1 to R3 ಅಂತ
directed to show the name of council.
Respondent number 2.
Respond number 2 and 3.
2 only. Mysore Medical.
My lord, I appear for respond number 3.
Name of learned counsel Sri Chandrakant Dode for respond number 2.
ಬಂದಿದೆ. DPC meeting proceeding page number 101, my kindly visit. Page number 101. ದಿನಾಂಕ 3/11/2015 ನಡೆದ DPC ಸಭೆಯಲ್ಲಿ ಪದೋನ್ನತಿ ನೀಡಲು ನಿರ್ಣಯಿಸಲಾಗಿದೆ. ಉಪಾಧ್ಯಕ್ಷರವರ ಸಮಕ್ಷಮದಲ್ಲಿ ನಡೆದ ಕಡತ ವಿಲೇವಾರಿ ಸಪ್ತಾಹದಲ್ಲಿ ನಿರ್ದೇಶಕರು CA ಅವರು ಈ ಕಡತವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸುವುದನ್ನು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಈ ಕಡತವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ ಅಂತ. DPC ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ನಂದು ಪ್ರಮೋಷನ್ ಆಗಿದೆ, ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕು ಅಂತ. ಇದು ಫೈಲು ಕಾಲ್ಫಾರ್ ಮಾಡಿದ್ರು ಕೋರ್ಟ್ ಇಂದ, ಅವರು ಇದುವರೆ ತನಕ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಇದು ಗೌರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಇದು DPC ಮೀಟಿಂಗ್ ಇರೋದು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಾಲೇಜ್.
What Mr. Gole?
My lord, he is not right there. Anyway, my lord, as directed by your lordships in the earlier order, my lord, we have already filed a number of documents, my lord, which were with us. Recently, my lord, after your lordships adjourned the matter last time, I have filed one more memo, my lord, along with the copy of the DPC meeting. And thereafter also, And thereafter, one nimsha.
Previously, Lordship.
And thereafter also, my lord, this case
Please,
has
Lord.
been rejected.
That
reject
even several dates, the last on 23/11/2021, this Honorable Court directed to secure the records of DPC meeting. I have filed an application for direction also. But so far as they have not produced that DPC meeting held by the second respondent medical.
This is the one you are talking about.
Please, my lord. Please, my lord. Please, my lord. Wherein I have been decided, my lord, that meeting. It has been decision has taken to consider my request of promotion.
Yes. What is
Lord,
what
that
is it
decision
that
by
you said
itself,
about this Annexure K?
Annexure K, my lord, is
Annexure K. Annexure K.
Annexure K, my lord. Annexure K, my lord.
Page number 100.
Actually, last time, my lord, all our names were shown. This time, my lord, our names were not shown at all. And it's only when Mr. Bhatt called me, my lord, I was able to. One second, my lord. Lordship, kindly permission.
Even record produce material.
Government records, Lord, wherein the.
ಅಲ್ಲ ಇದು ಈ ನೋಟ್ ಶೀಟ್ ಯಾರ್ದು ಇದು ಗವರ್ನಮೆಂಟ್ ಅವ್ರದಾ
ಅವ್ರದ್ದು
Mysore Medical.
ಹಂಗಾದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ
We don't have, Lord. That is my submission also. Last occasion I made the same submission. Records very
ಸುಮಾರು ಸಲ ಬಂದಾಗ ಕೂಡ ಎಷ್ಟು ಸಲ ಡೈರೆಕ್ಷನ್ ಇದೆ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಇದು Annexure K. Annexure K, my lord.
ಸೂಚಿಸಿರುತ್ತದೆ. ಸದರಿ ಸೂಚನೆಯಂತೆ ಈ ವಿಷಯವನ್ನು ಮೈಸೂರು ವೈದ್ಯಕೀಯ ಕಾಲೇಜು ಸಂಶೋಧನಾ ಸಂಸ್ಥೆ ಪದೋನ್ನತಿ ಸಮಿತಿ ಡಿಪಿಸಿ ಮಂಡಿಸುವಂತೆ ಹಾಗೂ ಸಂಬಂಧಿಸಿದ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯವನ್ನು ಜರೂರಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಕಳಿಸುವಂತೆ ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಾಲೇಜು ಮತ್ತು ಸಂಶೋಧನಾ ಸಂಸ್ಥೆಗೆ ನಿರ್ದೇಶನ ಕೋರಿದೆ. That is only the records we have.
Allah, Annexure K, my lord, is not the proceedings, my lord, of the MMC. No, you lost subject to correction. ಅದು ಇದು ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಇಲಾಖೆ ಹೆಲ್ತ್ ಅಂಡ್ ಫ್ಯಾಮಿಲಿ ವೆಲ್ಫೇರ್ ಸರ್ವಿಸಸ್ page 103 may kindly be seen. And I don't know, my lord, why Narapand is making a hue and cry of all this, because he is challenging the conditions in the order of appointment, my lord, which we have already given effect to. And subsequently, the DPC meetings, my lord, his request has been rejected. That's what I have produced along with my memo. And he wants to challenge, my lord, the conditions of order of his transfer from the Department of General Medicine to that of nephrology. He has already been given effect to. She has been working, my lord, since 2015 onwards till date. And she has been promoted, my lord, in 2019 as professor and made head of the Department of Nephrology. She wants promotion, my lord, in the department which she is no more working. That is the Department of General Medicine. That too with effect from 2012. It's impossible to even think of, my lord, seeking such a relief. The department in which, my lord, she has already given up. We have transferred those conditions, my lord, after 2 years of its implementation and acceptance. Cannot now at this point of time, my lord, reversed or quashed. She has accepted the conditions therein that she would not claim any seniority in the Department of General Medicine, and she would continue to work in Department of Nephrology. And she would be placed last in the seniority list in the Department of Nephrology. Her first prayer in the writ petition is to seeking quashing of the conditions in the order of her appointment in the Department of Nephrology. That she files, my lord, after 2 years of acceptance of that order. That order has already been given effect to. The person and this Annexure K page, last page 103, my lord, is of that of Arogya and
Annexure J, page number.
Annexure K, my lord, as a copy which has been given.
Prayer number 1 is in respect of Annexure J.
Annexure J. J is the order, my lord, which we have passed. Transferring her to the Department of Nephrology at her request. Other decision ತಗೊಂಡಿದ್ದೀವಿ ನಾವು. Condition number 2 and 3, page 99, Annexure J.
My representation on 27/4/2013, my lord, much prior to the official memorandum that has been pending consideration before the second respondent, my lord. DPC meeting has held.
What is this condition number 2 and 3?
That's what, my lord, in the condition official memorandum, the conditions imposed in the official memorandum date 2/1/2015 are illegal because as on the date when the official memorandum date 2/1/2015 was issued, the petitioner's representation dated 27/4/2013 to grant a promotion to the post of professor of medicine with effect from 24/11/2012 was already pending consideration before the authorities concerned. However, without considering the said representation, the authorities have slept over the matter. Even after the official memorandum dated 2/1/2015, the petitioner has been making representations after representations not to deny her the right of promotion to the post of professor of medicine. DPC has been held, my lord. They are avoiding to produce that record before my lord, my lord. It speaks about my promotion with effect from retrospective effect to my lord, to 27/4/2012, my lord. That is why my lords, after consideration earlier, my lord, this honorable court direct them to produce that record. They are avoiding to produce that record. It considered my request, my lord, by the second respondent. Therefore, my lord, kindly direct them to produce that record, my lord.
Every time they remain.
If that is the case, I would have directed.
My lord, this honorable court, my lord, on 22/3/2021 to secure the records, my lord, in respect of DPC. By that time, my lord, it is under the impression of government has that record, but the second respondent college is the custody of that record.
My lord, I have already produced along with the memo, my lord. The question, my lord, is not of the representation if any made by her. The question is one of implementing that order, my lord, if it warrants.
18/2/2020 said point number 2 and the state government is hereby directed to furnish the original records at the time of hearing of this petition.
Please,
even number 1 of 2019 is according disposed of. Since the learned counsel for the respondent number 2 submits that the original records are now with the respondent number 1 state government, the learned AGA is also directed to furnish the original records at the time of hearing.
The second respondent. Now the government.
ಆಗ್ಲೇ ಹೇಳ್ಬಿಟ್ಟಿದಾರ ನೋಡಿ the original records are
ಇಲ್ಲ ಅವರ ಹತ್ರ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರ ಇವರೇ ಹೇಳ್ತಾರೆ ಅವ್ರ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. DPC ಮೀಟಿಂಗ್ ಆಗಿರೋದು ಅವರ ಹತ್ರನೇ ಇದೆ ಅಂತ. Now it is burden shifting from their money. Kindly direct them to.
ಈಗ annexure K ಅಲ್ಲಿ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ ಕಾಪಿ ನೋಟ್ ಶೀಟ್ it pertains to the government.
Yes, sir.
Where is that? Annexure K ನೋಡಿ page number 100. ಅದಿದೆಯಾ? ಮತ್ತೆ ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಎಸ್ ಪಾಯಿಂಟೆಡ್ ಔಟ್
ಪುಟ 86 ಮನವಿ ಮೇಲೆ ಸರ್ಕಾರದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳು ಪುಟ ಫಾರ್ ಡಿಪಿಸಿ ಅಂಡ್ ರಿಪೋರ್ಟ್ ಎಂದು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಸೂಚನೆಯಂತೆ ಈ ವಿಷಯವನ್ನು ಮೈಸೂರು ವೈದ್ಯಕೀಯ ಕಾಲೇಜುಗಳು ಮತ್ತು ಸಂಶೋಧನಾ ಸಂಸ್ಥೆಯ ಪದೋನ್ನತಿ ಸಮಿತಿಯ ಸಭೆಯಲ್ಲಿ
ಅಲ್ಲ, ನೋಟ್ ನಂಬರ್ 8 ಇನ್ ಪೇಜ್ ನಂಬರ್ 101
ನಂಬರ್ 9 ನೋಟ್ ನಂಬರ್ 9 3/11/2015 ನಂದು ನಡೆದ ಡಿಪಿಸಿ ಸಭೆಯಲ್ಲಿ ಪದೋನ್ನತಿ ನೀಡಲು ನಿರ್ಣಯಿಸಲಾಗಿದೆ. ಡಿಸಿಷನ್ ಟೇಕನ್
ಇದೆಯೇನಮ್ಮ ಕೊಡಿ.
ಡಿಪಿಸಿ ಮೀಟಿಂಗ್ ಇಲ್ಲ, ಇದು ಸೇಮ್ ಶೀಟ್, ಈ ನೋಟಿಂಗ್ ಶೀಟ್ ಇದೆ.
ನೋಟಿಂಗ್ ಶೀಟ್ ಇದೆ.
Where is this proceedings of 3/11/2015?
That's not ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ಮೆಡಿಕಲ್ ಅವರೇ ಮಾಡಿರೋದು, ಡಿಪಿಸಿ ಮೀಟಿಂಗ್ ಮಾಡಿರೋದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಅದಕ್ಕೆ ಹಿಂದಿನ ಪುಟ ನೋಡಿ. You can kindly see here. ಫಸ್ಟ್ ಪೇಜ್ ಡಿಪಿಸಿ ಮಂಡಿಸುವಂತೆ ಹಾಗೂ ಸಂಬಂಧಿಸಿದ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ವರದಿಯನ್ನು ಜರೂರಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವಂತೆ ಮೈಸೂರು ವೈದ್ಯಕೀಯ ಮತ್ತು ಕಾಲೇಜು ಸಂಶೋಧನಾ ಸಂಸ್ಥೆಗೆ ನಿರ್ದೇಶನ ಕೋರಬಹುದಾಗಿರುತ್ತದೆ. Therefore, my lord, this files are all with Mysore Medical College.
Mr. Gowda, it's with you only. You will not have to produce it. DBC has been held there in your office.
That
Proceedings are drawn there only.
My lord, there are two aspects. Yeah, I will have already communicated to them that the original, if any, with you, in respect of PDPC record should be made available to me. That's one thing. Second thing, my lord, assuming for a moment that 3/11/2015, my lord, is there, a decision is there. The question is one of implementation, direction implement. The question of direction, directing the implementation of that decision would not arise because you will also have rejected my reputation, my lord, of a similar nature. The recently, my lord, in WP, that's what I made a submission last occasion. You will also have not accepted my prayer with regard to such a DPC decision already taken. They already taken, in that case, the already decision was taken. You will also refuse to issue direction. Assuming for a moment that going a step ahead, my lord, that 3/11/2015 decision has been taken, but subsequently she has accepted the order of her transfer to nephrology department. If she wants to retain in in the general medicine department, that would have been one thing. It is her request that we have appointed her as associate professor, my lord. Thereafter, she has been promoted as professor in the department of nephrology. I don't know why she can.
When did that happen?
That happened, my lord, in Annex J itself, my lord, on 2/1/2015. The conditions of which she wants to challenge now at this stage. She has been promoted in 2019. Annexure J, my lord, is the document by which, my lord, she has been sent to nephrology department long before on 2/1/2015, page 99.
No. Annexure J is dated 2/1/2015.
Yes, my lord.
The DPC that we are talking of is 3/11/2015.
Maybe, my lord, maybe. But the question is one of giving effect to the order at Annexure J. With now she wants to challenge the conditions therein. Annexure, that is condition number 2 and 3.
Sir, you please place this DPC proceedings, sir.
DPC ಅದನ್ನ ಪ್ಲೇಸ್ ಮಾಡಕ್ಕೆ ಅಂತ ತೊಂದರೆ, ಅದು ಪ್ಲೇಸ್ ಮಾಡಬಹುದು. But that by itself would not give any right to the petitioner to seek a direction, my lord, for promotion, retrospective promotion 2012.
Can you have it on Monday?
ಇದೆಯಾ? 3/11 ಇದೆಯಾ?
ಇಲ್ಲ,
ಹಂಗಾರೆ ನಿಮ್ಮ ಹತ್ರ ಇರುತ್ತೆ ನೋಡಿ. ಇವ್ರ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇದೆ. They have taken it on Right to Information Act.
ಅಲ್ಲ, ಅದನ್ನ ನಾನು ತಗೊಂಡು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರೆ absolutely no difficulty on that. Point is, question, my lord, is one of.
Let us go through that one and then see what.
Yes, my lord. Yes.
In terms of the directions issued to the learned AGA to produce the original record, the learned AGA has in fact produced the original record. But the proceedings of the DPC meeting held on 3/11/2015 is in the office of the second respondent, Mysore Medical College. So therefore, the second respondent is hereby directed to produce the original records pertaining to the DPC meeting held on 3/11/2015. Stop. The next para. Learned counsel for the petitioner submits that the petitioner has secured the minutes of the DPC meeting dated 3/11/2015 under Right to Information Act. Full stop. The petitioner is also permitted to place the same on record along with a memo. Date. Release this matter on 7th of April. Please. Yes. All other matters next week.
Lordship, serial number 43, Your Lordship.
Instead
It
of
was
7, may I
pointed out by
request
Your
for
Lordship.
11
From
minutes.
last 4 occasions, senior counsel is appearing, Your Lordship. Just because of other state counsel is not present, Your Lordship, it is not urgent, Your Lordship. Kindly attend tomorrow, Your Lordship. Serial number 43, Your Lordship.
May I request for 11th, my lord? May I request for 11th,
Lords,
my lord?
one submission, my lords.
May I request for 11th instead of 7th, my lord?
45 and 11th mounting.
My lord, serial number.
46 and connected doesn't matter. Have it on 5th.
Serial number, Lordship, kind of serial number 42, my lord.
Dates, I'll only say next week. I can't give dates for all these things. Final hearing matters again.
Final hearing, but the statement of objection. Very short, but 45 and 46.
B group.
B group will ಬಂದಿದೆ ಅದು ಅದೇನಾಗಿದೆ ಅಂತಂದ್ರೆ
Sir, all other matters will come up next week. Let us see. Yes.
That date was
Next week, sir.
other connected.
I can't give date for any of these.
My lord, serial number 44. Today the date was given, my lords.
ಹೌದು ಬಂದಿದೆ.
ಬಂದಿದೆ ಅದು ರೀಚ್ ಆಗಿಲ್ಲ, my lords. Kindly the matter may be taken up.
ನಾನು ಏನು ಹೇಳಿ ನಾನು please understand.
My lords, the third respondent is